Good afternoon. Welcome to the House Judiciary Committee. It's March the 7th, 2023, and we have a large number of bills that we're going to be hearing this afternoon, starting with the Attorney General on House Bill 857. We'll hear from the Attorney General. You're going to hear from Dana Mulhauser as well. Anybody else you'd like up there with you, Mr. Attorney General, or no? Just
not on this panel, Mr. Chairman.
All right, that's fine. Thank you very much, and we will hear from you now. Oops.
Oh, you started the clock before I got started. I'll reset. Flag on the field.
We're tough. We're tough but fair. We try to be fair. Thank you. Go ahead.
Thank you, Mr. Chairman and members of the committee. It's great to be back. I am Attorney General Anthony Brown, and it's an honor to testify before you today in support of HB 857. This bill grants exclusive authority to the Office of the Attorney General to prosecute criminal misconduct in officer-involved deaths or incidents where death is likely, and only through, or I should say after, a thorough independent investigation is completed. When the Independent Investigation Division was formed 2 years ago by this body, the Office of the Attorney General assembled the very best attorneys to do this specialized work. You'll hear from Dana Mulhauser. She's here to my right, my division chief, who has 12 years of experience at the Department of Justice in this specialized work. Ms. Mulhauser will also walk you through some proposed amendments. My number two at Independent Investigation Division is Renee Joy. And before joining the unit, she led one of only 2 units in state's attorneys' offices around the state of Maryland that do this specialized work. I have an experienced team. That's the point I wanted to make. The Independent Investigation Division has conducted and is currently investigating a total of 30 cases since inception, with the expertise, ethics, and fairness that you intended and that the public deserves. The hearing today and the bill in front of you is not about our investigations. It's about the authority to prosecute. Yet today you will hear complaints from several witnesses about our investigations. But for every complaint you hear today, I have letters from counties around the state that are lauding the investigative work of the Independent Investigation Division. This bill is about ensuring public confidence in the prosecution decisions, just like with investigations, by professionals who do not work together or rely on each other professionally or personally, to the extent to which our local prosecutors do with their local law enforcement agencies and officers daily. I urge you to read the written testimony of Gerard Hogan, a former Howard County and federal prosecutor, who describes the impact of these personal relationships. We're not talking about inappropriate relationships. We're talking about the public's lack of confidence in the process, where these close relationships suggest a lack of impartiality. 2 years ago, this committee took on the issues around independent investigations of officer-involved deaths. And after robust debate, you settled the question of what constitutes a best practice when it comes to investigations. You recognized 2 years ago that local prosecutors should no longer be responsible for these investigations. Attorneys general in 13 states, including Maryland, have independent investigation authority. Only 3 of those states, including Maryland, do not have independent prosecutorial authority. You'll hear that the Office of the Attorney General is unable to prosecute these cases because we don't understand local communities. Every day, state's attorneys around the state ask us to try cases in their counties across the state. So I urge a favorable report on this bill, Mr. Chairman.
Ms. Mulhauser, go ahead.
Good afternoon, Chair Clippinger, members of the committee. I'm Dana Mulhauser. I'm Chief of the Independent Investigations Division at the Maryland Office of the Attorney General. I've spent the last dozen years of my career as a prosecutor specializing in this area of criminal law. And I point that out because I believe there was some confusion in the Senate. We have an Office of Criminal Lawyers and Prosecutors who specialize in criminal police cases. We're now in our second full year of operation. We've conducted 30 investigations, and we have done so with care, with neutrality, and with the attention to details that the Marylanders deserve. I'd like to give you some facts from our first year and a half, and I believe you have our first annual report in front of you. Our average time of arrival on scene is 1 hour and 14 minutes. Our partners in the State Police Crime Lab have done 5,800 microscopic comparisons, and more than 80% of our cases involve camera footage, all of which we have made available to the public. I tell you this so you will know what these fatalities look like, what we do to investigate them, and why we are here supporting this bill. I want to talk briefly about a few other aspects of this bill and a couple of things that came up in the Senate. So the bill contains two smaller changes. It allows the state's attorney's office to voluntarily refer a non-fatal case to the Attorney General if it is deemed that that case would benefit from this process. It's an entirely voluntary process, and it also clarifies what would happen in the event of a friendly fire fatality. So the Senate made two small changes to this bill, both of which we support adding here. One is to narrow that voluntary referral language to cover only serious bodily injury as opposed to all injury. That's fine. That was the intent of it anyway. We support that. The other actually has to do with the report that you have in front of us. I think they were fond enough of this report that they wanted to put that in the bill and make it mandatory, and we are certainly fine with that. So we would ask you to pass the version of the bill that is in the Senate. Thank you.
Thank you very much. We'll take questions now. We'll start with Delegate Kaufman, then Delegate Erican, and then the person whose birthday it is today. Delegate Kaufman.
Yes, thank you, and I will make this quick so we can get to the birthday girl. But my question, Mr. Attorney General, is the state's attorneys are worried that as a result of this legislation, there'll be a brain drain, that you're going to pillage their best attorneys from the office. And so I'm just wondering, have you prepared a fiscal note? I mean, DLS does, but do you have your own fiscal analysis? And if so, how many attorneys have you asked for? And lastly, my second question, very briefly, is Mr. Gibson, a fellow Democrat from Howard County, is asserting in his testimony that 23 out of the 24 state's attorneys are opposed to this legislation. So I was just wondering if you had any comment on that or wanted to highlight some people who are, in fact, supporting your legislation.
Delegate, thank you for the question. As you'll see on the list of witnesses, there are a lot of people in support of this legislation. Regarding the fiscal note, I'm going to let Ms. Mulhauser speak to that, but we do not anticipate the influx or the requirement for a number of attorneys or investigators or support staff that would really create a drain on state's attorneys. I mean, look, it's common knowledge that, prosecutors, they move from office to office. They move from one state's attorney to another state's attorney. They move from the Attorney General to the U.S. Department of Justice, just like you see in other professions. But if you look at the numbers, and Ms. Mulhauser knows them better than I, it's a small number of professionals that we'll need to staff up to do this prosecutorial function.
The number is 2. We've requested 2 attorney positions.
Yes, thank you. And in terms of what you were saying about people losing jobs, to me, am I right that a good way to retain staff is to just create a good place to work? So maybe, so by creating good places to work, they could combat some of their concerns?
Oh, I would certainly not disagree with that.
Okay,
Yeah.
Thank you.
Thank you, Mr. Chair. Thank you both for being here again. So this is Judiciary. We like to throw out hypotheticals. So it's our favorite thing to do. So I'm thinking in terms of, like, if you can think back to the Gun Trace Task Force, if they had someone had died in the commission of those felonies that they committed, would your office be looking to put them down for federal felony murder charges?
Well, let me just start by saying that, I don't want to comment on the Gun Trace Task Force only to the extent that, this will be authority going forward.
Right, of course.
And as defined in the law, a police-involved incident that results in the death or likely death, or if you accept the amendment, if upon referral from a state's attorney when it involves significant bodily harm, we'll take those cases.
So, but you would or would not be looking at pressing felony murder charges
Against
anyone who an officer who committed a felony and also someone died.
what we would do, which is you'll see in every investigation of conduct that results in the death or the likely death or significant bodily injuries, we'll do a thorough factual investigation. Right? We'll look at the applicable laws, whether it's statutes, whether it's training manuals, and things like that, and then make determinations based on the facts and the law,
Okay.
what charges, if any, would be brought.
Understood.
There are investigations that would lead to, the decision not to bring any charges.
Okay, yeah, that makes sense, I guess. How many, between the two of you, how many cases have you prosecuted in the state of Maryland?
So most of my experience is as a federal prosecutor. So I was prosecuting cases around the country. So some years or some months I would be prosecuting cases in Mississippi, and some years and some months I would be prosecuting cases in North Dakota. So what we did when we composed this unit is we put together some prosecutors who were from the state of Maryland and specialized in areas of law here, and some people who had separate expertise in this area of law from around the country. So I'm in that latter category.
Okay, so between the two of you, you have not prosecuted cases in Maryland, but you've hired people who have?
Correct.
Okay, understood. Those are all my questions for now. Thank you so much.
Very happy birthday to Delegate Taylor, who has the next question.
Oh, yes.
Then we'll go to Delegate Phillips, whose birthday it is not, and Delegate Williams. Delegate Taylor, please.
Thank you, Mr. Chair, and thank you for the birthday shout-out. Mr. Attorney General, you mentioned that you believe that local prosecutors are not independent enough to prosecute cases of police-involved deaths. So can you elaborate on that just a little bit more?
Sure. And let me just say that, that view and opinion is based on a lot of research and survey and analysis going back several years. And for example, and I think it may be in my written testimony, the President's Task Force on 21st Century Policing, 2015, reached the same conclusions. The 2018 report from the U.S. Commission on Civil Rights, looking at police use of force, reached the same conclusion. But even closer to home, and I drew your attention to the written testimony from Gerard Hogan. He was a Howard County Assistant State's Attorney. He was a federal prosecutor. And you'll see when you read his testimony, he says, "It is no exaggeration to say that we assistant state's attorneys and the police were a team, often together in our office or at the police station, at crime scenes, or just as often as Shannon's Bar or Route 40 after work. Many of us became friends, and in a county the size of Howard, I knew most of our officers by name and knew many of their families, etc." And then he goes on to say how that makes it very difficult for him and his colleagues to make these very difficult decisions about investigating and potentially charging and prosecuting a police officer with whom they're working day in and day out. But a more recent example, and Mr. Chairman, if you'll just indulge me, is this opinion. And I'm reading, local prosecutors, this is all quoted, local prosecutors lack the specialized expertise and independence to effectively prosecute and win cases against offending officers. This person writes. They say, historically, local prosecutors do not have a great track record when it comes to securing convictions in police misconduct cases. This person also opined, further, local prosecutors seem unwilling to acknowledge the blatant conflict of interest their offices face in pursuing police misconduct cases. After all, prosecutors work with police officers every day. Now, this person also believed that the Attorney General's office may not be the best place to do it, but acknowledge that it has to be independent. And these are the words, not of me, not of Ms. Mulhauser, these are the words of State's Attorney Ivan Bates.
Thank you.
Delegate Phillips, then Williams.
Mr. Attorney General, you mentioned feedback by the local state's attorneys about the work of the Independent Investigation Division. Can you be more specific about the feedback that you've received specifically from them? Also, I guess it's the State Law Enforcement Officers Labor Alliance talks about having unchecked power, if you will, in this particular, with what you proposed.
Sure. And I know that Ms. Mulhauser can give you more detail on the day-to-day interactions, because when we conduct these investigations, we're in constant communication with local state's attorneys. In fact, our protocols invite every state's attorney to designate someone from their office to work alongside of us. we do a conflict check to make sure that, you know, they don't have a close relationship with the law enforcement that's being investigated. So we invite them to participate. We notify them along the way of every critical decision that we make. Things like when and whether we're going to release video footage. Obviously, we have to send them an interim report so they can make their final decision on whether to prosecute. And then before we release the final report, we work with them on things like, hey, is there anything in there that you think needs to be redacted for whatever reason? So we work closely with them. And I'll tell you, out of the 30 cases that we've either concluded or worked on, these are some of the comments that we get. I want to thank Attorney General Frost and his team for the thoroughness of the report issued as a result of the police-involved shooting from October, Baltimore County. Thank you for your office's thorough investigation, Somerset County. Our conclusion was based on the results of a thorough investigation conducted by the Maryland State Police and Independent Investigation Division of the Office of the Attorney General, Howard County. The investigation was thorough and objective throughout, Queen Anne's County. And finally, the state's attorney for Wycomico County agrees with the IID's factual findings. Wycomico County. We've had a good working relationship. Our investigations and the results have informed their decisions. It doesn't come without some tension and you know, there's occasional disagreement, but it's a truly independent investigation. We keep the state's attorney's officers involved, and I'd say for the most part, notwithstanding any complaints you may hear today in this hearing, the investigations have been thorough and beneficial to our state's attorneys.
And good. And then the concern raised about checks and balances with the IID and how you might operate.
Sure. I mean, and let me have Ms. Mulhauser speak to the kind of the operations of that.
What I will say is that it is not uncommon, and in fact, it is often beneficial for law enforcement and for prosecutors to work closely together, and that is particularly true in various complex cases like white-collar cases, like RICO cases, like civil rights cases, where they involve a lot of complex affirmative defenses, they involve a lot of things that need to be proven, and what those cases are often referred to as either attorney-involved or attorney-led cases. And so I think we've heard a little bit of a red herring of, oh, there should be a wall between investigators and prosecutors, and that's not how it works in any of these offices. And so we wouldn't want to hamper the work that we do by putting restrictions on this office that aren't put within the Justice Department and aren't put within state prosecutors' offices or other offices.
Delegate Williams.
Yes. Thank you, Mr. Chair. Thank you, Mr. Attorney General, for being here. Earlier, you were talking about kind of the independence or possible conflict with the state's attorneys, having to prosecute, say, excessive use of force cases. And I know that's something that, over the years we have been diligently trying to deal with on how do we deal with, police interactions, excessive use of force interactions, those types of things. And so my question I have for you is, with your office prosecuting excessive force cases, how is that just different than saying just a regular kind of murder case that were to happen with someone who's not? And either one of you guys can answer that.
Sure. Sure. One of the things that makes excessive force cases particularly complicated is that police officers have available to them a specific defense that no one else in the state has available to them, which is a law enforcement justification defense. And let me be really clear, they deserve to have that defense because the job that they do is difficult and it's complicated, but that defense exists and it has to be addressed. And that's why, by and large, offices that are large enough and states that are large enough have separate specialized units that do this. And that was the specialized unit that I worked in when I was in the criminal section of the Civil Rights Division. There are a couple of offices within the state of Maryland that have that specialized office. And the 9 other states that have given their attorney general's offices this authority have been able to set up that specialized office so that you do things like talk to trainers, talk to supervisors, work through that question of reasonableness or, under this new standard, necessary and proportionality that really requires a different kind of defense than a standard order homicide case does. Now, we have people in our office who have certainly done homicide cases and been homicide prosecutors, and that's important as well. But these cases are really a combination of a violent crime case and a white-collar case.
Got it. Okay, thank you.
Seeing no further questions for this panel, we thank you all very much. I'm going to try and move along here relatively quickly and take one more panel of supporters of the bill. In person, I have Heather Warnken, Dwight Droughton, Willie Flowers, Jason Billingsley, Natasha Dartigue. We'll also add the people who are on virtually, including Mr. McKesson, who's on the screen, and Mr. Karoom, if he's available. You can, no? Okay. We have Mr. McKesson, that's fine. So I've called all the people who I have as the next people to testify. Here comes another person, I think, though. So that's fine. All right. And we'll begin with Ms. Dartigue, please, and move over.
Thank you. Good afternoon, Mr. Chair, Vice Chairs, members of the committee. I am Natasha Dartigue, Maryland Public Defender, and I am here in strong support of House Bill 385. This is a bill that enhances police accountability through independent investigation and, where necessary, prosecution of police-related deaths and serious bodily injury. There are fewer acts committed by local government that draw more controversy than a police department's use of lethal force. Broad cross-sections of the public, and I highlight the Black and brown communities throughout Maryland, have lost trust in local law enforcement agencies due in part to the perception of biased investigations of such deadly force incidents. Civilian distrust can be traced to the perception of a cycle of impunity by which the reluctance of local government to prosecute bad cops empowers future misconduct and drives communities to regard the police as adversaries instead of protectors. I would make note that in 2020, current State's Attorney Ivan Bates, in an op-ed, indicated, and he was referencing the Office of the Public Defender's Special Interrogation Department, where we essentially investigate officers. And I quote, Debbie Levy of the Baltimore Office of the Public Defender hits the nail on the head when she says that a specialized statewide agency could recruit the talent necessary to secure convictions against offending officers. Under the auspices of such an office, investigators and prosecutors would receive specialized training and work with experts in their field to ensure effective investigations and prosecutions. The Office of the Public Defender is here today supporting the fulfillment of this very idea. We ask that you enter a favorable report on House Bill 385. Thank you.
Hello, everyone. My name is Dwight Droughton. I'm a partner at Steptoe & Johnson. But prior to that role, I was an assistant United States attorney in Greenbelt, Maryland, where I had the opportunity to work with various counties in the state of Maryland. I have a great respect for the state attorneys and the ASAs that I had the opportunity to work with. Part of my role was a civil rights coordinator, in which I investigated and prosecuted offenses that involve police officers using excessive force or sexual assault and various other matters. There are three reasons why I'm in support of the bill that I want to focus on in the 2 minutes that I have. First is that this creates a centralized effort that will make information gathering more efficient. It would allow Maryland to have a group of attorneys that would develop expertise over time and make prosecutions that are equitable. You don't want a disparity where you have one county being particularly harsh towards officers and another county being particularly lax. Having one group that looks over all of it will make sure officers are treated fairly. The other thing to consider is that it develops, you have this awareness of officer-involved shootings in like counties that are not as central. So when thinking about the Department of Justice, for example, I was responsible for maybe 5 counties, but I was seated in Prince George's County and adjacent to Montgomery County. When watching the local news, those sort of things would come to my attention first. It's a little bit harder for me to learn about something in St. Mary's County when I was in that prior role. So having a body that will be aware of everything makes sure that everyone's treated equally. Another thing is witness and community trust. True or not, community members do view state attorneys' offices and police departments as being closely related. You remove the appearance of bias when you have a situation in which someone were to decline a case. You don't want anybody thinking that it's because of some sort of friendship. And finally, it's ideal to handle your own prosecutions from beginning to end. So if we have the Attorney General's office investigating the crimes, developing case theories, we should want them to implement it. I'm at time. Thank you.
Good afternoon, members of the committee. My name is Heather Warnken, and I am the Executive Director of the University of Baltimore School of Law Center for Criminal Justice Reform. We are grateful for this opportunity to testify in strong support of this bill. Impartial, independent investigations are the bedrock of the American legal system. Few incidents challenge the integrity and legitimacy of this system more than the decision to prosecute or decline to charge a death involving a police officer based on those investigations. As will be discussed today, an inherent conflict of interest exists when the state's attorneys investigate and prosecute officers from the same police departments that they work with and rely upon every day. This conflict of interest casts doubt not only on the capacity and effectiveness of local prosecutions of officers when needed and warranted, but it also undermines their credibility when those offices legitimately determine that a prosecution is unwarranted. This bill represents an important step toward the legitimacy and viability of a legal system that is already notoriously rife with systemic racism and continually damaged by the litany of police violence and misconduct cases that have given rise to some of the strongest social movements in recent memory. By taking this important step, aligned with best practices as discussed in our written testimony, vesting the prosecution authority in the Attorney General, this bill will help to ensure that cases warranting a criminal charge are pursued and that decisions not to prosecute are accepted by the public as the product of a legitimate and unbiased evaluation of both the facts and the law. We urge a favorable report. Thank you.
Good afternoon, Mr. Chairman, members of the committee. I'm Willie Flowers, and I'm with the NAACP. We stand in strong support of House Bill 857. I want to applaud the members of the committee who did the reform package in 2021. It was a valuable thing after the death of the murder of George Floyd, and everybody was excited that the reform package happened. So I was very surprised when, I guess in 2022, we received a call from the news media talking about this report. The Independent Investigation Division did a superb support, and you can see how beautiful it is. It has been passed around everywhere in the world, and it details substantial stuff about every murder that happened on the hands of police between 2021 and I guess 2022. It was fabulous to document it. It gave the background on officers. Every detail of it was perfect. The surprising thing was that there was nobody charged. Of the 23 murders at the hand of law enforcement, not a single person was charged. And it was devastating to understand later that the Attorney General's office, while they were empowered to do the investigation with such detail, they were not given the authority to charge anyone. And I'm sure I was not the only one surprised by this. Not only was I surprised, I was very disappointed because the Attorney General's office should be the third-party entity to do it. If it's not the Attorney General's office, it should be the U.S. Attorney's office, the FBI, someone to do it. The point is this. Our community has had the expectation of this body to put forth legislation that's going to resolve these issues of police murders, and you have the opportunity to do it. We stand in favor of this report. Thank you.
Mr. McKesson, please.
Hello, I'm Jerry McKesson. I lead Campaign Zero, an organization focused on ending police violence and mass incarceration. We track the data around police killings across the country in our database of mapping police violence. Since 2013, 178 people in the state of Maryland have been killed by a police officer. The local state's attorneys have only successfully prosecuted one of those officers in that time. When we look at another database that tracks this, for a longer period of time, from the 2000s, there are more cases and there are only 7 successful convictions of a police officer who's engaged in killing somebody by the local state's attorneys. They will repeatedly say that they have specialized knowledge, that they do these cases really well. The numbers actually don't show that. The numbers show that they cannot successfully get a case and work it all the way through to a conviction. And we're not saying that giving the AG the power will necessarily lead to a conviction. We do say that when we look at the data itself, that the local state's attorneys and the police are so closely working together that these investigations are shoddy sometimes, that there's just an inherent conflict of interest. And again, they will say that the AG's office doesn't have the skill, that they can do it better, that the data shows that they have done it better, and that actually just is not true. Again, from 2013 to today, they've successfully prosecuted one of these cases only. In the state of Maryland, an officer who kills is almost guaranteed to face no criminal conviction. An officer who harms somebody and does not kill them might actually face some sort of criminal consequence, and the local state's attorneys have done that relatively well, given the charges when we look at the data. But an officer who kills someone in the state of Maryland is almost guaranteed to face no consequence in the criminal process with the local state's attorneys holding the power. And again, we would say that is because of the conflict of interest. We believe that independent investigation is the only way to have true accountability and for the community to really understand and believe in the process. Thank you.
Questions to this panel. Delegate Tolles, followed by Pasteur and Bartlett.
Thank you, Mr. Chair. I'm going to ask this question to my good friend, Willie Flowers. Good to see you as always. And I'm not sure if you can answer this. Mr. Attorney General stepped away, so I'm going to put it in your hands.
The pressure.
You speak of a case being charged in your comments, and I'm also looking at your testimony. You indicated that if a case was charged, that it could, this bill could be beneficial in assisting with those situations. But what if you had prosecutors that were possibly, no fault of their own? Our prosecutors are very smart with cases, but were unprepared, and there were several postponements, as in the case that happened in Prince George's County with the police officer involved shooting, and where the court, where the county has already paid out to the victim's family, and, the court got involved where it was a lot of issues with that case. If this law, HB 857, was the law, would this have been helpful with that independent prosecution, the ability to have independent prosecution done by the Office of Attorney General? Would that have been helpful in this case?
I think that the civil case, to me, and I'm not an attorney, has nothing to do with the criminal case. If an investigation proceeds, and we're talking about the Attorney General being able to charge, and the investigation reveals that they should be charged, they should be charged. So I don't think one has anything to do with the other. The family should be compensated for a civil case. And there's politics connected to how quickly that happens. But regardless of anything, if there's a criminal case to be prosecuted, that officer, anybody involved with the killing of a citizen, in most cases this stuff is unarmed, they should be prosecuted.
Mr. Chair, it's okay if I can ask Madam Public Defender to kind of clarify that there's already been charged, money been paid out, case got messed up. In your opinion, would Attorney General be able to come in and try to independently handle this if they were given the opportunity?
So I would say first and foremost, my role is as a defense counsel, so I would not speak to in terms of specific prosecution for cases, but as
just a process.
But as was stated, a civil case and a criminal case are independent.
Oh, I am aware. So
I guess
I'm
I'm not
aware
clear
of
on
the
your question.
independence. So let me clarify. Case got messed up in Prince George's County. Is it possible, based off what Willie Flowers indicated about it being charged, they're already charged, already going through the court system, it's an issue. Would the Attorney General be able to, and I'm sorry I'm speaking around the Attorney General, but our rules, he's already stepped away from the table, so I apologize for that. But in you being an attorney who obviously goes, and Ms. Workin, if you want to answer that as well, my point is they're already charged, going through the court system. would they be able to intervene in that situation?
So I would say that if jeopardy has attached, they cannot come back and recharge. So when you say gone through the court system, I'm not clear as to what that means.
So they've already gone through the process. The Office of Attorney General is saying, something got messed up, let me take over this case, because it has not completed trial yet. Trial has not been completed.
So again, it depends if jeopardy has attached. Jeopardy.
Okay. I can speak to them offline, because the
Yeah,
trial,
yes,
I speak to you offline.
Yes.
The trial has not gone through. We had a situation in Prince George's County.
Sure.
Things got messed up. Trial has not been completed yet. But
I can
don't
tell
wanna
you,
get specific.
jeopardy, it does not, jeopardy to attach does not require the completion of the trial. So, but I will further speak to you online
Okay,
about
yeah,
that.
I can speak to, because I have some specifics I want to speak, I'll speak to Attorney General about.
Yes.
Okay, thank you. Thank you.
Delegate Pasteur, then Bartlett.
Thank you, Mr. Chair. Mr. Flowers, I'm going to come to you as well. And it's also good to see
Beat up on
you,
Willie Flowers Day.
always. Yeah, it's your day. Because I'm coming to you because you're not an attorney.
Right, thank you.
And I want to go back to something that Ms. Mulhauser said, of answering the question about her experience and the Attorney General's experience with trying cases in Maryland. And the answer was where she had been and that others have come from other places around the country, and that there was a mixture, if you will, from those in-state and out. And I'm asking this question because I have heard, of course, those who have the pushback who say, you know, you need to know the state, and this is what we've tried in the state, et cetera. But I'm asking you, forget the but, I'm asking you, as one who's not an attorney, what pluses, since you heartily support this, what pluses do you see in having that mixture? Not just having people who know Maryland, but people who have tried cases, similar cases around the country. So what's your answer in terms of the pluses to that?
With specifically speaking to Dana Mulhauser's background, the Attorney General's office in the state of Maryland has probably the best person to be involved in this process at all, considering her background. And I researched that background when I got the call from her. And we're in a healthy space, particularly for justice people who have been watching this horror of assassinations of mostly black men. So I think that it does require a diversity of experience and exposure. And at this time in history, I think the Attorney General's office in Maryland is at another level of expertise.
And if I may, I'd like to throw that out to the rest of the panel. What do you see as the plus to being able to bring in people with different experiences in the same kinds of situations, but beyond Maryland? Any one of you?
So I would say the great benefit is in terms of the level of experience, the fact that they are seasoned attorneys in terms of their skill. The biggest nuance would be in learning the Maryland law, if you are someone who does not practice Maryland, but as a seasoned attorney, I would say, I can speak for myself, practicing 26 years as a trial attorney, I can confidently go into any jurisdiction, and once I learn what the elements of the offense are, I can effectively defend a case. So it's really about having that level of knowledge, expertise, and experience. And for this particular team, they have gathered those individuals who are at the highest levels to be able to prosecute these cases. And it also speaks to the level in which has been intentional, that we want to do it, but we want to do it right in fairness not only to the citizens, but also in fairness to the individuals that are charged.
I think in addition to that, having a diverse team allows you to avoid blind spots and also add creativity. So if you have people that are accustomed to sort of doing things the same way consistently, they may not think about all of the issues that might come up, especially when you think about a jury is a team of laypersons. So it's not always a good thing to have people who are like in the weeds of being experts. And you also get rid of the stereotypes of thinking, I know how the jury panel will be, because everyone's different. But also, when you have people that have done fraud cases, sexual assault cases, murder cases, and they're working together, they can think about different approaches to getting in evidence and persuading the jury that someone who's only been in one lane might not be able to do. So just having those lawyers come together and think about it creatively helps a lot.
And I think my fellow panelists have covered this very well and very thoroughly. The only thing that I would add is, given the complexity of these cases and for all the reasons that they just spoke to, the ability to bring together all of those different types of expertise in the Attorney General's office to pursue the cases, combined with the great benefit of overcoming the perceived conflict of interest, just makes them incredibly well situated for this task.
Thank you. Thank all of you. Thank you.
Thank you. Thank you, Mr. Chair. My question is for Mr. Flowers, too. So one thing I was concerned about during the work on the Police Accountability Act was the public trust with respect to, the use of force and police officers and that sort. And I'm sure as president of the NAACP Maryland State Conference, that was a concern of yours. So my question is, you mentioned the booklet and how there had not been prosecution while it's in the hands of the state's attorney. My question is, have you been to the IID website? Have you seen the website?
Yes.
And were you able to view the body cam footage and the full report from the Attorney General's office and, follow the case all along the way?
Not all of them, but yes. I know it's there. I didn't watch every single.
Well, no, I didn't mean every single one. I'm just saying, were you able to view body cam footage?
Right.
Yeah. What was your thought process in being able to do that so easily and so quickly versus prior to the Police Accountability Act?
I doubled down on the fact that the ability to investigate was superb. What y'all did with empowering the Attorney General's office to investigate was amazing. I don't know if it happens anywhere else in the country, but because of that, I do think that the reason we're here is to talk about empowering the prosecutor's office to prosecute when state's attorneys don't. And so I think that the information is thorough. It's more than I've ever seen, and it's painful to know that research and investigation was done, and in 23 cases, not a single person was charged.
Right. And so, do you feel like the next step then?
The next step is to empower the Attorney General's office to be a substantial part of this process.
Okay. Thank you.
Seeing no further questions for the panel, we thank you all very much. Now I'm going to hear from those people who are opposed to the legislation. We're going to hear from Haven Shoemaker, Scott Schellenberger, Jamie Dykes, and Rich Gibson. Panel after this will include Mr. Davey, Mr. Shire, Ms. Smith from the Troopers Association, and Mr. Bollinger. And then the third panel will be Ms. Healy, Mr. Kroll, Mr. Harvey, Mr. Delmeyer. Start with State's Attorney Gibson, please. Go ahead.
Thank you very much. Good afternoon, everyone. My name is Rich Gibson, State's Attorney for Howard County, currently the President of the Maryland State's Attorney Association. It's an organization comprised of 24 elected state's attorneys. We are politically, racially, gender-wise a very diverse group. And our body voted on this issue. 23 out of the 24 members, elected state's attorneys, opposed legislation. 1 abstained. We opposed it for the following reasons. One, prosecutors already have the ability to enact policies and procedures to address real bias and have outside agencies handle those cases when actual bias exists. Two, if the bill passes, it will dilute and disenfranchise the local affected populations. The AG's office, Attorney General's office, is voted in by 6 million people. We are direct elects from our local communities and respond directly to them. By way of comparison, in Howard County, I am responsive to the 300,000 plus people that voted me in office in Howard County. The ability for the affected community to register a complaint, discuss personal issues, vote out the AG if they disagree with the way in which they're handling it is practically non-existent as compared with the local state's attorney who they have direct access to and greater control over. And finally, these cases are incredibly complex. The Attorney General's office does not have the requisite talent in-house to handle these matters. Not just any prosecutor can do this work. I know it because I've done it myself, right? It is the most skilled and experienced prosecutors that are handling these kind of cases. And the Attorney General will have no choice but to hire from local offices where the supposed bias already exists. And if they are biased working in our offices, that bias is not going to magically evaporate working in their office. Moreover, the local communities will lose the best and brightest prosecutors in those spaces, making those spaces less safe. For these reasons, we oppose House Bill 857, and I welcome any questions after the panel has provided their testimony. Thank you.
Good afternoon, Scott Schellenberger, State's Attorney for Baltimore County. So I'm just going to clear up a couple things that happened earlier today. Number one, today over in the Senate, when they were having a discussion about this bill, people kept asking what Ivan Bates' position was, and I know we just heard what his position was in the op-ed from 2020, but I texted him this morning during that conversation, and I said, they want to know your view. Are you against AG bill? Answer, Ivan, yes, against. So that clears that up. That was his position now, and that's his position with regard to this. Regarding the 23-4, 23 elected state's attorneys say this is why we get elected. This is one of the reasons why we are in office. We are elected by the people in our jurisdiction to make all these decisions. And the other thing I have to correct is the term murder. These are justifiable homicides. That's what's been ruled on in these cases. And so that's how we have to take a look and know them. 2 years ago, I sat in this very room and we had this conversation. We had the same conversation across the street in the Senate. And we all decided then that this was the best way to do it. The independent investigation, and yes, I did write a letter saying you did a great investigation because that's their job. But then my job is to make the decisions. And that's where the decision-making should stay with those who get elected to do this. I urge a unfavorable report because 23 state's attorneys are opposed to this, including me. Thank you.
Good afternoon. Jamie Dykes, State's Attorney for Wycomico County. If elected state's attorneys can't be trusted to prosecute law enforcement officers for crimes that they commit involving death, then we can't be trusted to prosecute law enforcement officers for other crimes. We can't be trusted to prosecute cases in which law enforcement officers are victims. And we can't be trusted to prosecute cases in which law enforcement officers are witnesses. It's absurd. This bill germinates from fallacies. That is, that because these are controversial cases, that a conflict exists. Every decision that each of us makes is controversial. And we're happy to do that because we are charged constitutionally with doing so. That these cases are complex, yes, they're complex. They are no more complex than the murders, the multi-co-defendant murders, the multi-victim rapes, child abuse cases that we handle. No more. It's offensive that legislative and state officials have indicated that there is a clear conflict for local state's attorneys handling these cases. Nothing could be further from the truth. Every decision that we make is based on the facts and the law and the circumstances of each and every individual case. I have personally prosecuted 2 law enforcement officers for abuses of power and sent them to prison. and I will prosecute another 1,000 if that's what the evidence and law requires. That is not my experience. I've prosecuted one CO for an abuse of power that happened on duty. My office is in the process of prosecuting a law enforcement officer for repeated abuses of power that occurred on duty, multiple victims. The defendant faces several life sentences. Am I unfit to prosecute him?
Mr.
Chairman, Mr. Vice Chair, members of my old committee, it's great to be back. So up until 9 weeks ago or so, I served 2 terms in the House of Delegates, and I have a little different perspective than my colleagues because I did serve 2 terms down here, and I got to tell you, whenever I saw a bill that had like uniform opposition from the elected officials that bill would impact across party lines, it served as a red flag for me. And that's what we have here in connection with HB 857. Each of the 24 state's attorneys in Maryland has a constituency. In Carroll County, I'm responsible to the 173,000 folks that I serve for the way in which I exercise my prosecutorial discretion. And each of us is accountable for the way in which we use that authority. Anecdotally, I can tell you that 2 previous state's attorneys in my county have been voted out of office over the last 20 years for the way in which they did or didn't do their jobs. And that's the way it should be. So, a one-size-fits-all approach in making prosecutorial decisions is not a good idea and seems to fly in the face, if you will, of Maryland's, traditional delineation of powers between the statewide elected Attorney General and the locally elected state's attorneys. Furthermore, I would note that the specter of the slippery slope presented by this bill is cause for concern as well. So I would respectfully urge an unfavorable report on HB 857. Thank you, Mr. Chair.
Thank you. Are there questions for this panel? Delegate Grammer, then the Vice Chair.
Mr. Chair, for the gentle lady, the proponents of the bill mentioned that, prosecutors are friends with law enforcement and you can't objectively prosecute those people because you're working with those people, you're friends with those people, you know their families. What you're saying is, prosecutors do work with cops. And because of that, what you're saying is you can't actually be objective in prosecuting any crime because that would imply bias as well. Look, I work with these cops. I'm biased to trust them. Is that kind of what you're arguing here?
Yes.
Okay.
Yes. Rich hit on it, but if there's a conflict that exists, because I've lived in my community my entire life, I've known some law enforcement officers for 20 years, I would consider those cases that those law enforcement officers I have a conflict with, and I would panel it to another prosecutor's office. There are already procedures and practices in place to protect against conflicts.
Can you, there's several cases where I know of with counties throughout the state where you do have to panel it, you do have to send it to another jurisdiction. Can you speak briefly on those, how that works? Is there discretion there? Can you talk about that a little bit, please?
So there is some discretion in that. It's if I'm handling the case, it's going to depend on severity and if that law enforcement officer has operated in a jurisdiction. So many cases will go to neighboring jurisdictions if it's a simple DUI, simple assault second, as long as that law enforcement officer hasn't operated in that adjacent county. The more complex the case, the more we're going to look to experience. Charlie Smith handled a homicide for my office when I took over and had represented a defendant in one of those cases. So I've called on Mr. Schellenberger for similar things in the past. He's assisted us, not in that way, but similar ways.
Okay. Thank you so much.
Yes.
The Vice Chair.
Thank you, Mr. Chair. And thank you, everybody, for coming in today. I know that everyone here is a upstanding public servant, so don't take this question the wrong way. But given the context of, I guess, the subject matter in question, this particular assembly of counties in front of me is interesting. So I just want to know if you're aware of a case in Carroll County from last year where the state's attorneys, some of the high-ranking state's attorneys in this office, are unable to bring cases in that jurisdiction because of there were at least 4 people in jail who were sitting there with a case involving a sheriff deputy who they knew had credibility issues, but nevertheless brought those cases anyway. And likewise, we had a similar scenario in Harford County. I believe that state's attorney was just disbarred in retirement last year under very similar circumstances. Would that not be what the subject matter of this bill is getting at? Close to some of the same types of linkages between some of the law enforcement officers and the offices that are supposed to be investigating them?
Well, with regard to the Carroll County case that you referenced, that was not a police-involved shooting type case or police-involved, use of force type case. That was a totally different set of circumstances.
But doesn't it implicate the relationships that this bill is getting at?
No.
It's not imagined. We actually have 2 cases from this very year where state's attorneys are either disbarred or not able to bring cases because of the improper relationships with the law enforcement, the FBI in one instance, and then the sheriff's deputies in another instance, that were impacting their judgment and ethics on cases before them.
Yeah, well, I'm not going to comment on the Harford County case, but I can tell you, and the Harford County State's Attorney is here, so you may hear from her, and maybe she'll elaborate. But I can also tell you that with regard to the Carroll County case, that has been farmed out to the Maryland State Prosecutor, who's still conducting an investigation. We're anxiously awaiting the report.
And if I could add, Delegate Moon, I could show you a list of 19 police officers who in the last 12, 13 years I've prosecuted. In fact, I believe I've shown it to some of you previously. We all take that responsibility very seriously. We also have a do not call list, and that is officers who we would not call to the witness stand because we are concerned about their credibility issues. There's a flag in the computer system that we have so that if anybody enters that officer as a witness in a case, they will get an immediate flag and they have to go talk to my deputy, who is the most experienced prosecutor in the office, who will tell them what kind of disclosures have to be made. So we deal with these type of issues every day and take them head on. And what I'm saying is, 2 years ago we had this conversation. I'm not saying we can't have it again. I'm happy to keep talking about it. One thing that we need to think about is there was another idea 2 years ago, and that was the possibility that you would give the local prosecutor the right of first refusal. So the AG's office would do the investigation. They would give it to Schellenberger and the state's attorney's office. He could decide to prosecute, and then you wouldn't have to use the AG's office. If the prosecutor decided not to prosecute, it would allow the AG's office to then pick it up if they chose to. And that was another discussion we had 2 years ago, and that might be something that we could certainly consider here as an option, because we believe that we're the right people to make these decisions.
Delegate Moon, if I may as well, just want to make sure that the record is clear related to prosecuting police officers. In Howard County during my first term, an officer brandished a weapon at a bunch of kids that were making too much noise in a local pool. We prosecuted that officer. That officer went to jail and is, presumably serving their sentence. We didn't quake about it. There was no equivocation. If someone is doing something wrong, whether they're a citizen, a member of the community, or an officer, we will hold them accountable. And as was stated earlier, if there is actual bias, if there's actual conflict, we do have mechanisms and techniques that we can use to ensure that the process is fair and that the defendant, in that case the officer, is treated fairly and that the community is treated fairly in the evaluation of the case.
And just one more correction. Let's all be clear, the Harford County prosecutor who had got disbarred is not the person who's here today.
No,
Yeah, and to that point,
she's not.
that person was voted out by the community they serve. So again, there's a check on our authority in the direct electoral process. If they don't like what we're doing, they can say you're out.
Thank you, Mr. Chair. My question is for my former colleague and Judiciary Committee member. So I'm looking at your testimony, State's Attorney Shoemaker. I think that's the first time I've ever said that in public. And I'm looking at the constitutionality, the Maryland constitutionality question that you raised in your first paragraph. And so in researching that, I can't help but notice in the Maryland Constitution, Article 5, Section 3B, that we, the General Assembly, have the power from time to time, as prescribed, as we see it, as prescribed law, to give the Attorney General other duties and other powers. Do you agree with that?
I believe you do. Now, whether you should do that is an entirely different matter.
No, I'm not asking that question. I'm asking whether or not you agree that that is part, and when I read, literally read the Constitution, that's what I see, and I just wanted to make sure you do agree that that power does reside in the General Assembly.
You can do that. I don't think you should.
Okay, thank you.
Thank you, Chair. State's Attorney Shoemaker, you mentioned about slippery slope, and I guess 2 years ago, the former Attorney General, he was in here and was granted some authority, and in all fairness, it's a new Attorney General that's here, but back again, requesting more authority. Can you kind of expand on what you were saying about slippery slope?
Well, one of the things I think I said on the floor one day is that Annapolis has more slippery slopes than Wisp. And the fact of the matter is, I mean, even though the Attorney General did testify over in JPR that he would not keep coming back to the well seeking additional authority, there's nothing to preclude it. And I'm concerned about the precedent that's being set by this particular piece of legislation.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Mr. Schellenberger, is there any particular reason why you pointed out what Ivan Bates' opinion on this bill would be? I just want to be clear.
Because an op-ed that he wrote before he was in office was read during the supporting testimony. And I wanted to make sure that it was clear that his position today is against. But that prior op-ed he did right, and he did at one point support this.
Okay, so I just got off the telephone with him while we were sitting here in committee, and I would like to be clear. Is that all that he told you that he felt about the bill? Yes.
Again.
Okay, well, he told me that he would be in favor of an amendment to have first refusal. Does that sound familiar to you?
We didn't discuss that.
Oh, you didn't discuss that today? I just discussed it while I was sitting here listening to what you said. You said exactly what he said after he said it to me, but you failed to give him any credit, so therefore I asked him about it.
No, I asked, they want to know your view. Are you against the AG bill? Yes, against.
Well, you can look at the footage, and you saw me with my phone up to my ear. I was snitching on you.
We're actually on the same side, delegate. So that other option was always discussed. No, that option was always discussed, and it was here 2 years ago. So we're actually agreeing.
Members are asked not to engage in three-way calling during the committee hearings.
Chair Clippinger, I just want to make sure that we're clear. The MSAA as a body voted and we voted to oppose. We did not vote for the amendment, so we really can't speak on any potential friendly amendments. I'm sure that's clear.
And we thank you for that. All right. Seeing no further questions for this panel, thank you all very much. We're going to the second panel, Michael Davey, Michael Shire, Rebecca Smith, Wanda Hurd, John Bollinger. We'll add a chair, please.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we are also requesting an unfavorable report on House Bill 857. As you well know, in 2021, the Maryland General Assembly granted the authority to investigate cases involving the death of a civilian involving police to the Office of Attorney General's office. In 2022, they came back. The General Assembly gave them more authority now to investigate additionally incidents where it's likely to result in deaths of citizens. And now we're back again where they're requesting additional responsibility or authority to investigate referral from a state's attorney's office, the authority to investigate other crimes related to police misconduct that are discovered, and they are requesting exclusive authority to prosecute these cases. The FOP believes that this additional authority to prosecute these cases is a conflict of interest by having one division of the Office of Attorney General having the authority to both investigate and prosecute these high-profile cases. We would argue that there are simply no checks and balances. This is not like a regular criminal case where the police officers do their investigation and they bring charges, and then a separate entity, the state's attorney's office, then has the opportunity to either dismiss those charges, reduce the charges, or increase the charges. That's the checks and balances that should apply across the board for every case. It also robs the local state's attorneys their ability to fully perform their duties of the elected office. Obviously, it creates another large conflict of interest. Using a state trooper as an example, if he's involved in a police-involved shooting, which is likely to cause death, or it's investigated by the Office of Attorney General, if they decide to prosecute it, they'll prosecute it. When the family then sues that trooper and the state, the Office of Attorney General now has to switch hats and now defend what the officer did. It just doesn't make any sense. There's been 30 investigations so far. There have only been, I think, 18 or 19 completed. We believe that this process should be allowed to work before any decision is made to transfer the ability to prosecute from the state's attorney's office to the Attorney General's office. Thank you.
Sir?
Good afternoon. For the record, Michael Shire, here for the Maryland Fraternal Order of Police. Been a police officer in Maryland for 19 years. I'm an attorney in the state. Thank you to committee chair and the committee members for allowing me to speak today. We are in opposition of House Bill 857. I'm not going to belabor and repeat what's already been said, but I want to add that it's interesting how this bill actually goes against one of the core values of the Maryland Police Accountability Act. The MPAA specifically put power out in our local communities. It said we're going to have local police accountability boards, local administrative charging committees, and civilians for trial boards drawn from local jurisdictions. That was what this body wanted from the MPAA, that local control, that local advice. Now we're saying, no, we're going to take the prosecutorial authority away from the local, and we're going to bring it back up to the state level. The MPAA didn't create a single statewide administrative accountability complex, but we want to create a single statewide prosecutorial complex. Those are in opposition to each other. They're from the investigations that have already been completed and submitted to local state's attorneys. There's been no cohesive argument that the state's attorneys are not doing their job. And we would agree with the state's attorneys. If I was in their place, like I said, I'm an attorney too. If I was sitting in their place, I would definitely take offense to legislation like this that would be removing my authority to do my own job. And for those reasons, the FOP asked an unfavorable report on this legislation. Thank you.
Good afternoon, delegates and ladies and gentlemen. My name is Wanda Hurd. I'm a retired Chief Judge of the 8th Judicial Circuit, that's Baltimore City. And I practiced law for 40 years. For those of you that don't know me, I was an associate judge at the circuit court for 21 years. I was a prior Assistant United States Attorney and Division Chief in the U.S. Attorney's Office. I was an Assistant Attorney General, and I was a Division Chief and a prosecutor in the State's Attorney's Office for Baltimore City. And to add to that, I was only 5. I was a federal public defender in Maryland. I think that I'm uniquely qualified and have the diverse experience to speak to this bill, because if passed, it will place decisions about charging and prosecuting in very crucial criminal cases in untrained hands. We all know what this bill is supposed to do. You've read it, and I've got several pages of testimony from the Senate side that you can read at your leisure. But our Maryland Attorney General's office has a tremendous national reputation as civil litigators. They represent the state, they represent state agencies, they do a wonderful investigation, which you've heard from the state's attorneys. They do assessment of civil rights cases. They do assessment of abuse of force cases for civil rights litigation, which sometimes are referred to the U.S. Attorney to prosecute. They do appellate work, but they are not day in, day out trial prosecutors. That's not their training. That's not what they do. And it is disingenuous to say that they won't steal the best and the brightest from the state's attorneys around this country to try, around the state, to try these cases. That's exactly what they're going to do. You're misinformed if you believe that state's attorneys do not weigh the credibility of police officers every day. In fact, that's what they do. Lastly, I've tried cases for 21 years where defendants were police. They spat on people, they went to jail. They shot people, they went to jail. They beat citizens, they went to jail. And COs were prosecuted in my courtroom. They are misleading you when they tell you that prosecutors of this state do not prosecute law enforcement officers.
Thank you very much. Please.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Rebecca Smith, and I'm General Counsel for the Maryland Troopers Association. I won't repeat what's already been stated today, but we are requesting an unfavorable report based on our concerns about the checks and balances of giving this power to both investigate and prosecute these matters with the Attorney General's office. I just wanted to point out 2 quick things. We heard the Attorney General speak about how the Assistant Attorney Generals are not independent enough. Well, who's going to keep the IID accountable and make sure that they remain independent enough? And when you have an agency, a unit that's picking and choosing what to investigate and what to include in reports and what to put on the website, that causes some concern. We have the Attorney General quoting the state's attorney saying that they agree with these investigative findings. That should also be telling to this committee. There haven't been any prosecutions because none have been recommended by the IID. Therefore, the state's attorney hasn't had a case to prosecute yet. And if and when that happens, I have no doubt that the state's attorneys in this state will take up that call and they will prosecute when necessary. Thank you.
Delegate Cardin for a question, please.
Thank you very much, Mr. Chair. Just real quick, Judge Hurd, it's good to see you. And when I'm in front of you, when I'm the other way and I'm in front of you, I always try and be as prepared as possible, and I can tell that you are very prepared here. So it's great to hear your testimony. Just if, in fact, a prosecutor chooses not to prosecute, but the Attorney General, after the review, thought that it would be appropriate to prosecute, do you think that it would be wrong to then let them get, as Scott Schellenberg was talking about previously, to get a second bite at the apple to be able to prosecute?
I don't think it would be wrong, but I also need to remind you, when you say prosecute, are you talking about referring that for abuse of force and use of force, civil rights violations, which the Attorney General can do, or refer it to the U.S. Attorney's Office, or as you're suggesting, an amendment to this bill which would allow the local state's attorney a right of first refusal, as you would. And I would have no issue with that. I think that they are doing a phenomenal job collecting data. They can go cross-jurisdictionally to get the information, the reports, the ballistic reports, the testimony, the body cam. They do that, and they're doing a great job of it. The next step is the decision of whether or not to prosecute that collection of information, whether it's legally viable. And that's a decision I believe that needs to be left with the state's attorney of the jurisdiction where the incident occurred.
Thank you. Thank you, Mr.
I've got mad respect for Judge Hurd. She knows that. Last night on the floor, you witnessed Blue and White Night, so this is my sister. Yeah, here. Couple of questions, though. As this is presented, one of the challenges that I really have is when it comes to police-involved homicides, statistics aren't good in terms of police officers being charged with a crime. And I understand, one might say that's because they're all doing their job and it's all justified. I have a challenge with that. And so I'm looking for your advice on how we might address that if it's not coming from the state's attorneys in the local jurisdictions. And then the second piece is there are other states that have already kind of gone down this path, New York, Illinois, and I think a few others. And my sense is the sky has not fallen. But, you know, I got mad respect, so I want to hear from you as to those two things.
Well, first, I applaud what we have done in the state, addressing the ability to gather information, to collect the data, and to put together a team at the AG's office, the IID team that collects that information. I think that is crucial. I also applaud the fact that this state has taken affirmative step to try to deal with equal justice issues and use of force issues across the board. That is phenomenal. But there is more that the citizens of your jurisdictions are concerned about than just the incidents when someone dies. That is crucial. That is important. But they are worried about the day-to-day interaction with law enforcement. The case I tried, where a man was spat upon by a police officer, that is serious. And the state's attorney handled it, they prosecuted, and I sent him to jail. There were incidents where an officer shot a man after he was already down, and there was no reason for it, and he was prosecuted. According to what you're talking about, those cases would never see the light of day in the IID unit in the AG's office. They would be left with the state's attorney's office. But guess what? I watched Pat Jessamy, Stu Sims, Chuck Bernstein, and Marilyn Mosby charge those cases, and I was the judge who sent these people to jail for what they did. Why are those cases and those interactions with our youth, with our community, not important enough for us to use those as well as a way to ensure trustworthiness? Why aren't we holding our law enforcement officers, that being the state's attorneys, to their oath, to be fair, just like we hold you to your oath? Would you want someone to come in and tell you what the citizens of your jurisdiction should do or should tell you to do today? No, we leave it to you to represent them. You've elected state's attorneys. Leave it to them to do their job. I'm not saying that the investigations should not be done by the Attorney General. They have uniquely the ability to reach in and it happens cross-jurisdictionally. There's state agencies that are involved. There are federal agencies that are involved with ballistic reports and drug reports and labs, and they have the ability to get the body cameras downloaded quickly. Well, let them do that. You've already given them that authority. But then let the state's attorneys do the job on all the cases. Not just the ones where someone died, not just the ones where someone was harmed. Have you ever been spat upon? I think that's serious, and I think that affects trustworthy credibility with the state's attorneys. Make them do their job across every element of the interactions with our citizens. And if you do that, we will build trust where it doesn't exist. We will build accountability. And when they don't do their job, well, they'll get voted out, won't they?
I would expect so. Isn't that so?
No, you get to ask the question, she doesn't. Anyway,
Okay.
go ahead.
So,
And I'm retired, so I'm not worried about that.
I know your philosophy about that. But what about, so the second part of that question was really not that we need to be mimicking everybody else, but I mentioned New York and Illinois, I know as a fact have done this and have empowered the attorney generals to kind of do this work. I don't know that they've done it exclusively, and it's exclusively a responsibility of the AG, but they have given them this power.
But this bill said exclusive. That's what I read. It said exclusive. And that's different than right of first refusal. And that's what I'm talking about. I am concerned. And I think that you steal away the best local prosecutors because we need them for other stuff. We need them for other homicides. We need them for other matters to advise the state's attorney on all those other cases. And the quality of lawyering that I see in my courtroom, that I'm concerned about. But I do believe that what Mr. Bates is saying, and I'm going to speak for him. You can tell him I spoke for him. He's talking about a time when he observed police misconduct, and he was a defense attorney. And he came down here and testified about GTTF. And he was concerned that they weren't being held accountable as officers, and ultimately assisted the U.S. attorney in providing information, and his client testified and provided information so they could be prosecuted by the U.S. attorney's office. That I like to think that was because back in the day, he was a prosecutor. He started out, and he still had that, sense of justice with him. And I think that everyone's talked about how the oath of office is important to lawyers and to prosecutors. We are charged. Most of my career, I was a prosecutor until I became a judge. And then I had that oath too. And when we had conflicts of interest, when there were problems, we referred those cases to other jurisdictions or other lawyers. I was a victim myself in Baltimore City. And Marilyn Mosby referred that case to the state prosecutor. And well, she should, because she didn't feel comfortable, because I was a judge on that bench, to handle the case. So, it happens all the time. We make these credibility findings and weigh that. You want us to do a better job. Give us the ability and the trust from the legislature that we can. Let the AG collect the data and hand it to us tied up with a big bow, and then let us do our job. And that's what I believe that the State's Attorneys Association is saying.
Thank you.
Thank you.
Thank you so much, Mr. Chair. Good to see everyone. Judge, isn't it so that the Office of Attorney General don't prosecute or don't have the ability to prosecute civil rights enforcements, which is why they have HB 772 before us to give them the authority to do that? So I just want to clarify something that was in your testimony.
The head of the IID unit has her expertise in civil rights. I don't know any other subsection that would fit the criteria of what you're talking about. However, there are standards for misconduct of any state official, and I don't know. We're in the process of moving the state's attorney, the police under one criteria to another criteria. So I'd have to look that up to determine whether or not there may be other areas where state officials violate certain ethics or rights. And I'm putting them in quotation marks because I'm not sure if it's civil rights. So I do not know that. But I can answer your other question that you asked a little earlier, which is about the civil rights, and the civil cases that are settled. You asked a question
No,
about.
that was not my question. I'm
Okay.
sorry. I was saying it doesn't matter because I don't want to take up time. I want to respect, what the chair want us to do. But I can speak with you offline. It was saying if the trial didn't go forward.
Yes.
But it's nothing to do with civil. I just brought that up as part of my argument. But we can talk about that offline. So I just wanted, to state for the record that what you said could have been a little misleading. In the sense that last week they came before this body to give them the authority to be able to have, civil rights investigations and enforcement authority. That bill was heard last week. So I just wanted to make that clarification. I'm sure they have all the authority that you are saying. And then, also, I wanted to clarify from Ms. Smith.
Yes.
That, the IID doesn't make recommendations in investigative reports to the state's attorney's office. Isn't that so?
Well, they claim that they don't, but if you read the reports, it talks about how the evidence would not support charges being brought forward. So it's just a terminology thing, but if you actually read all of the reports, they have not recommended any wrongdoing on an officer's part thus far.
Okay, I would disagree. Okay, thank you so much, Mr. Chair.
All right. Seeing no further questions for this panel, we thank you very much.
Thank you.
We have a third panel on this bill. Many members of the committee know that it's 2:30, and we have quite a few other bills, including a lot of people sitting there staring at us. And I don't know if anybody else notices them, but they're there. Robert Harvey, James Delmeyer, Stephen Kroll, Allison Healy. Don't know if John Bollinger came up last time. I don't remember if he did or didn't. Okay. We'll start right there. Go right ahead.
Good afternoon. I'm Bob Harvey. I'm the state's attorney in Calvert County. Mr. Chairman, I'll heed your advice and be brief. What this bill tells me is that the Attorney General doesn't trust us to do our job. We all at this table have taken an oath. Every state's attorney in Maryland has taken an oath, myself included, to enforce the law without partiality or prejudice. This oath extends to cases involving police officers, cases involving police-involved fatalities. As I often say, the police don't work for me, and I don't work for them. That allows me to prosecute police officers in appropriate cases where it's justified, and I have done so in 3 cases in the 3 years that I have served as state's attorney in Calvert County. And in the appropriate case where the facts and the evidence support it, I will prosecute a police officer in a fatal case. I will do it because that's what my oath requires. And if there is a conflict of interest, as has been pointed out many times, we farm it out to another jurisdiction. I get on the phone, I call my friend Tony Covington in Charles County. I say, Tony, can you take this case? They say yes. That's how it works, day in, day out. So I urge this committee to give an unfavorable report on this bill. Thank you.
Good afternoon, Mr. Chair, members of the committee. I'm James Delmeyer. I'm the state's attorney in Cecil County. We are asking for an unfavorable report on this bill on the grounds that it would usurp the authority of elected local prosecutors. Our system is designed that we are independent, and it should stay that way. I also support the current structure, which is an independent investigation. That's how we did it in Cecil County throughout my entire term. We just used a different agency. So my local sheriff's office would not investigate their own. We would bring in the Maryland State Police as a courtesy, and they would investigate. In fact, many of the same state police investigators working with the IID are the same exact homicide detectives I worked with when they were investigating my local law enforcement in those police-involved fatalities. So that is a good system. And this body 2 years ago agreed that was the solution. I pose to you what has changed. The Attorney General and Ms. Mulhauser with the IID have not given you any data that indicates we are not doing that job. They haven't said one case that any of us have looked at of those 23 which should have been prosecuted under their perspective. So if there's no problem, what are we fixing? Thank you, Mr. Chair. I yield my time.
Mr. Chair, members of the committee, thank you. My name is Allison Healy, and I'm the Hartford County State's Attorney. I also will try to be brief because I think a lot of our positions are the same. I echo what Mr. Delmeyer just said, which is that we are usurping our authority as state's attorneys. Our citizens have voted us in to prosecute these cases. And our county itself, I've been in office just since January, but we, even in this short time, prosecuted a law enforcement officer for a crime he committed off duty. So there is no inherent bias. We are here to prosecute the crimes that occur in our county, and we will do that. As Mr. Delmeyer said, there has not been one case that IID has pointed to that should have been prosecuted, not one. There is no factual basis that we are somehow inherently against prosecuting these cases. We, like Mr. Gibson said, we have the ability to be voted out by our citizens. We are diluting the voice of our voters. If I don't do a good job, if they disagree with the decisions I make, and let's be honest, these police-involved shootings affect our communities the most. If they don't approve of what I've done, they will vote me out. The AG's office will have zero consequences if my community doesn't agree with what they do in our police-involved shootings. The purpose of the IID legislation was to separate the investigation from the prosecution, to keep it independent. And by passing this legislation, we are flying in the face of that intention. And I will yield my time. I ask for an unfavorable report.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator and the Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases since 1984. My focus is going to be on the removal of injuries likely to result in death or serious bodily injury. No one knows or understands what that means. Keep the Attorney General doing it, but make them do death cases only to avoid that confusion. So I'd ask for that amendment or alteration. Keep them doing the cases, but solely death cases only. And for that reason, I'd ask for unfavorable report as to House Bill 857. Thank you.
Questions for this panel? Delegate Arakan, please.
Thank you, Mr. Chair. Thank you all for being here. I just wanted to give an opportunity for the State's Attorney from Hartford County to set the record straight on, we were mentioned previously, and I know you probably weren't even alive yet when this case actually occurred. I think it was in the 70s.
I was not.
Yeah, so isn't it true that in the case that was referenced, the State's Attorney was not charging a police officer with any crime at the time?
That is correct.
Okay.
And I did want to set the record straight on that if given the opportunity. First and foremost, that case had absolutely nothing to do with the police officer being charged with anything, and there was no conflict. But I'd also like to set the record straight that that very same prosecutor actually charged and prosecuted a police officer for firing at a fleeing car during his term. So that case had nothing to do with a police-involved death or anything of the sort, and has nothing to do with the issues that are before this committee under House Bill 857.
Yeah, and in fact, the disbarring occurred after he was our state's attorney.
It was after he was the state's attorney, and actually was, yes, that's correct.
And then my final, isn't that so, is in our county, we are blessed to have a great sheriff, and we don't keep a do not call list in our county, to my knowledge, because he terminates anyone that he finds won't stand up to judicial scrutiny on the stand.
So, I guess the answer to that question is we would speak to Sheriff Gaylor about that. That's the sheriff. Obviously, we have several municipalities as well. If we obviously are obligated under Brady and Giglio to provide to the defense any information which would affect the credibility of an officer. If we have that situation, we would then go have a conversation with the chief, and usually an IA complaint comes out of that and it's dealt with, but we certainly would not call a witness, obviously, that has a credibility issue.
Right.
But that's something that we would communicate to our sheriff directly and say this is a problem, and then we go from there.
Great. Thank you very much. Thank you all.
Further questions for this panel? Seeing none, we thank you all very much, and that concludes the testimony for House Bill 857. Committee, we're waiting for Delegate Smith, who apparently is in the Ways and Means Committee, and so we're going to try and do what we can there. We are going to need to go, we've got a couple things. First of all, House Bill 975 has been withdrawn, so we will not be hearing House Bill 975 today. We will hear House Bill 1044, because I believe Commissioner Harrison, who's right outside the door, is here. he's on the other door, Delegate Young, but okay. Well, we'll see how this works out, and that's fine. Well, but wait, now we have Delegate Smith. So now we're going to do Delegate Smith, and I lied. Okay, let's start all over again. We're going to go now to House Bill 859 because we have Delegate Smith who got here, and it's going to be Delegate Smith. The mayor was here but had to leave. Joshua Greenberg and Councilman Conway, come on up. And then we have the police commissioner who's testifying favorable with amendments, so we'll hear you next after this panel. Or do you expect him on this panel?
Are we doing 859?
859.
Yes, I just want to make sure that I was on the right.
You're on the right one. All right, we'll take the commissioner next. Go ahead, Delegate Smith.
Thank you, Mr. Chair, Mr. Vice Chair, distinguished members of the House Judiciary Committee. For the record, I'm Delegate Stephanie Smith, here to present for your consideration House Bill 859. Now, this is a very simple bill, but I do welcome any healing from the chair should he find the necessity. As many of you may know, over the past few sessions, we've been tackling the issue of private home detention agencies and ensuring that pretrial defendants had access to those tools if they were deemed eligible, and for those that were indigent, that they would have those fees absorbed. This bill is a little different because this is about ensuring that the private home detention monitoring companies are actually communicating with the courts and with the the Division of Parole and Probation in a very timely manner when those pretrial defendants and their charge are disconnected from that system. Under current law, if a pretrial defendant has been found to be disconnected from their private home detention monitoring system in excess of 24 hours, they have the company has up to, beginning in the next business day to notify the courts and the Division of Probation and Parole. And we all know that when someone is, violating that monitoring device, time is of the essence, and quite frankly, something terrible could happen because of the lack of proper oversight. So what this bill seeks to remedy is, instead of that reporting happening beginning in the next business day, it needs to happen immediately. And so, for example, if the court is not available at the time that the violation is identified, what this bill would outlay is an opportunity for just the duty judge in that jurisdiction to be notified, and then also a requirement at the same time to notify the Division of Probation and Parole. So the immediacy, we think, is not only just practically a good business threshold, but also a matter of public safety. If we are requiring monitoring, private home detention monitoring, that is an expectation that this person is being monitored the entire time. And anytime they are no longer being monitored in excess of 24 hours, there needs to be immediate notification. So that's what this bill seeks to do. And I do welcome your feedback and hopefully your favorable report for House Bill 859. Thank you.
Mr. Chair, just want to clarify, I'm here for House Bill 853.
I was like, I didn't know you cared about this.
Thank you.
Just welcome the support.
I was so confused then.
I thought it was a surprise. Surprise support.
Would anyone else like to pretend to be Councilman Conway? It's fine. I mean,
I am not, nor will I pretend to be Councilman Conway.
All right, it's fine. Commissioner.
Good afternoon, Ms. Chairman Clippinger, Vice Chair Moon, members of the Judicial Proceedings Committee. I am Michael Harrison, the Police Commissioner of the Baltimore City Police Department, here to testify in support of House Bill 859. And I would like to thank Senator McCray and the Mayor for the opportunity to speak about the issue on his behalf and on my own behalf for home detention monitoring. And as you've heard, I have seen firsthand the violence that can occur when an individual absconds from the pretrial or post-trial supervision. It is especially dangerous in instances of domestic violence when a defendant absconds to seek out a vulnerable victim, or when a gang member absconds to seek out retaliatory violence. BPD supports this bill as it is one step closer to identifying issues with the current home monitoring notification system and pre- and post-trial supervision as a whole. We recognize that the judiciary has concerns with the lack of uniformity between courts regarding the notification process and supports a working group to address this. BPD would welcome the opportunity to have those conversations about much-needed reform. Once again, I've had the personal and professional experience to see how this works and how it works well with both private monitoring and public monitoring. When I was the chief of police in New Orleans, Louisiana, one monitored adults, public and private sector monitored juveniles. And I've seen it where when a person stepped outside the geofencing area, the police were actually notified instantly, and it constituted a contempt of court. And so we were able to get dispatched immediately to where the geo-tracking tracked the defendant, and we were able to pick that person up and bring that person in. And then it became an issue of whether or not they were going to be remanded pre-trial until trial or remanded post-trial and revoked from probation. And so we look forward to working with the legislators, the mayor, the judiciary to implement a uniform, effective process to monitor defendants. And for these reasons, I respectfully request a favorable report of House Bill 859.
Good afternoon, Chair and members of the committee. I'm Director Walt Festerfield of Baltimore County Department of Corrections. I'm here to testify in support of House Bill 859. This legislation would require a private home detention monitor agency to immediately notify the court if a defendant on home monitoring leaves the premises. Currently, statute requires that when a defendant is subject to home monitoring has left the premises, the court must be notified the following business day. Unfortunately, this means that there are cases in which defendants have been missing for days due to extended weekends or holidays. The court is not notified until it's too late for prompt action. House Bill 859 would remedy this issue by requiring that on days or hours in which the court is not open for business, a private home detention monitoring agency immediately notifies the local duty judge, the court that issued the order, and the Division of Parole and Probation. Private home detention monitoring is intended to allow the defendant to await trial in their home while keeping the setting as controlled and secure as possible. This legislation would ensure that the spirit of the program is upheld by ensuring that any deviation from the court order is recognized and addressed right away. I will give you Baltimore County's procedure in our local jurisdiction. If an offender receives an alert, if an officer receives an alert that a GPS device has been removed, we immediately reach out to the offender and family to determine if the device was actually removed. If it is determined that it was removed, we call the victim in the domestic violence cases to notify them. The officer then notifies the necessary staff at Baltimore County Detention Facility and calls the non-emergency number to report the incident and get a criminal complaint number. The officer then completes a statement of charges and takes it to the commissioner to have an arrest warrant issued the same day. That same day, or sometimes that following business day, depending on the time of the escape letter, is e-filed to notify the judge of the escape, and a warrant has already been issued. Thank you.
All right. Thank you very much. There are questions very quickly to Delegate Smith. Isn't it true that in the legislation that you passed over the last couple of years that there was a work group that was supposed to be looking at electronic home monitoring generally?
Yes.
Isn't it true that there were House members appointed to both work groups over the last couple of years?
Yes.
Isn't it true that there were Senate members appointed over the last 2 years?
Yes again.
Isn't it true that someone else didn't make the appointments necessary to actually start the work group?
Sadly, that is too true.
And was that person the former governor of the state of Maryland?
Yes.
And would we perhaps find it easier to deal with some of the problems that we're seeing in electronic home monitoring if we had been working on comprehensive solutions for the last 2 years?
Yes.
Thank you for those insightful answers to my questions. Delegate Erican and then Bartlett.
Thank you, Mr. Chair. I know we all love a good work group. So, anywho, I wanted to give the sponsor an opportunity. First of all, thanks all of you for coming in. There's a letter in here from the judiciary. Have you seen it yet? I don't know if you have.
I'm aware.
Yeah, they just cite some concerns about the fact that they don't have, I guess, regulatory authority over DPSCS. So I'm not sure if you have an amendment in mind or if you have some avenue you're imagining where this could be done in a way that's functional for them. They didn't specifically offer a fix or an amendment, but yeah.
I think your chair was foreshadowing where some of those solutions could
potentially come from.
Yeah.
Could be born out
Could
of,
be born
perhaps.
out. Yes.
Got it. Well, maybe there'll be a seat for me on that work group. Who knows?
I don't do the appointing.
But we know who does.
Yes. Delegate Bartlett.
Thank you, Mr. Chair, and for the record, I do not want to be on any more work groups. Thank you very much. Smart lady. I've got enough. Okay, so first of all, I have to contain my excitement because now we're talking about a bill I can get behind that actually saves lives when it comes to crime. I like it. So this question is for Commissioner Harrison, or Commissioner Harrison. In your testimony, you were talking about, gang retaliation and that part. So I'm going there. So given the urgency of the parameters that are set in this bill, could it have helped prevent the incident where a fatal shooting occurred here in Annapolis after an individual was required to wear an in-home monitoring device, did whatever with it, and somehow got out, fired a firearm that resulted in a midshipman mother's death?
First of all, thank you for that. That is a great question. I don't know that there's anything that can prevent a specific thing at any time. What I can say is that when executed properly, a well-executed, well-run monitoring system would notify the courts and law enforcement the moment someone steps out of the prescribed monitoring area. When law enforcement appropriately and timely responds to it, the goal is then to keep that person from reoffending and or becoming a victim. And so those are the goals of why we need immediate response, not just to courts, but immediate response to law enforcement to go and, number one, ascertain if the device, as you've already heard testimony, has been removed, or if the person has stepped out of the geofenced area. The goal is to keep the person from reoffending, and the goal is to prevent the person from being a victim by not being where he or she is not supposed to be.
Thank you.
Thank you.
Seeing no other questions for the panel, we thank you all very, very much for being here today. And I believe that concludes the testimony for House Bill 859. We thank you all very much. Now we're going to go to House Bill 853. Now, Councilman Conway can come back. We'll hear from Delegate Smith. I know that the commissioner is here favorable with amendments here, so we're just going to take this panel. We can take this panel, or you can, that's fine. All right, so is there anybody else, so confusing. Is there anybody else that you would like, Delegate Smith?
Yes.
We'll take your panel, and then we'll run through the favorables, and then we'll have the commissioner come back. All right, Delegate Smith, there's an empty seat. We need to fill it with someone. Great. Mr. Roca.
Okay.
Mr. Roca signed up? Yes, he is. Great. Delegate Smith.
Thank you, Mr. Chair, Mr. Vice Chair, and again to my distinguished colleagues on the House Judiciary Committee. For the record, I'm Delegate Stephanie Smith, here to present for your consideration House Bill 853, and this is a bill concerning the ability for the City of Baltimore to actually have the same local control capabilities as every other jurisdiction in this state. I want to back up by kind of explaining how we got here today. I know many people are familiar with the fact that since about 1860 or so, the City of Baltimore has been under has been a state entity under BPD. It has not been locally controlled in the ways that other jurisdictions are accustomed to. And In 2019, a prior Baltimore City delegate, Talmadge Branch, who at that time was the majority whip, he issued a bill with the support of then Chair of Appropriations Becky McIntosh, as well as former Chair of the delegation Kurt Anderson and others, just basically saying, let's give Baltimore City local control. It passed out of the House delegation. It then subsequently passed out of the House 137-0, and unfortunately, there was not action taken in the Senate regarding that effort. In 2020, there was a pandemic. In 2021, there were a suite of police accountability bills that I don't have to tell you all about because most of you were there. Some of you weren't, and God bless you. You look a fresh face for the world because of that. And so for those that were there, you know there were many things that you were taking up, but one of them was concerning extending local control to the city of Baltimore. At that time, there was an administration bill that was passed out of both chambers, and what it was designed to do was to create a local control advisory board, as well as make the extension of local control to the mayor and city council of Baltimore contingent upon the passage of a city charter amendment vote showing an expression of a desire by the citizenry to have local control. Now, I want to make it clear that that bill that we all passed in 2021, the charter vote contingency was not legally necessary. It was just tied to that bill. And so question H was passed this fall while we were on the general election ballot. So was this question that was posed to the citizens of Baltimore. And over 82% of them said, yes, give us that same local control that every other jurisdiction in this state enjoys. And so why are we here today? You're probably like, Stephanie, why are you here? We're here because that bill got us active. It got us to have a charter vote. It also, laid forth a local control advisory board, of which I'm a member, but I am not bringing this bill in that capacity. And it unfortunately did not give the council the legislative abilities to actually regulate and interfere with, I thought I was the sponsor. I could talk a little longer. I wasn't aware of that.
Not here.
Okay, can I just summarize it in 30 seconds? No, can I summarize it in 30 seconds?
You got your 3 minutes. You can have a couple more seconds.
Yeah, just a couple more
You need to
seconds.
wrap up.
And so we're here today because under Article 2, Section 27 of the city charter, without it being repealed, the council cannot, in fact, adopt ordinances that interfere with the police commissioner's duties, which is the whole point of local control. The charter question was not, do you want a modified diet version or some other version of local control? It said, do you, the residents of Baltimore City, want to have control of your police department? So the bill that I'm presenting today was adopted and passed out of the Baltimore City delegation yesterday with only one dissenting vote and has the support of the delegation. And so I'm asking for your I'm humbly asking for your support and favorable report of House Bill 853. Thank you, Mr. Chair, for your flexibility.
Thank you very much. You'd like, Councilman, go ahead.
Thank you, Mr. Chair, and I'm finally here for the right bill. Once again, my name is Mark Conway. I'm a councilman representing the 4th District on the Baltimore City Council in North Baltimore. I also chair the Public Safety and Government Operations Committee on the City Council. I'm here to urge your support for this bill. And going back to Delegate Smith's history, it's really important to understand why we're here. We're here from a decision before the Civil War. We have not had control of our police department since before the Civil War. Now, going to a couple of things, we held a hearing as a city council on this issue, particularly where we were with local control, and we found out a very important piece. At this very moment, neither the city council nor the state has legislative authority to write laws for the Baltimore City Council. We just got the legal advice back now, confirming that that is in fact the case. So this bill very simply strikes Article 27, that line in Article 27 that limits our ability to write that law. We encourage you to support it. There's been discussions about limiting that, but I would posit that there's not a single city agency, not one, in Baltimore City, where there are limitations on the duly elected officials' right to write laws for those agencies. This would not be a good precedent to set going forward. There's not another council across the state that has that limitation, and so I would urge you not to consider any amendments that would consider that consideration. We as a council can be very responsible. We have first reader, second reader, third reader, 8 votes in order to pass a bill, and also the mayor's veto should there be a disagreement on those matters. We have the very same legislative process that we have here when considering those bills. So any misguided effort to introduce an amendment is just an attempt to limit the legislative authority of the elected officials of the city. So once again, I urge you to support this bill, and that's all I can ask. Thank you, Mr. Chair.
Good afternoon, Chair Clippinger and members of the committee. My name is Christina Roth, and I'm Senior Policy Associate of the NAACP Legal Defense and Educational Fund, or LDF. HB 853 would give the Baltimore City Council the authority to pass ordinances regulating the operation and conduct of the city's police department while increasing accountability and civilian participation with and oversight of a city-operated agent police department. LDF urges the passage of identical cross-filed bills, HB 853, sponsored by Delegate Smith, and SB 758, sponsored by Senator Carter, the Baltimore City Control over Powers of Police Commissioner Act, to effectuate this transfer as quickly as possible without limitations raised by city employees. As for those before me have mentioned, since 1860, when state officials overtook the city's police force to root out corruption, Baltimore City has had limited power over its police department. Unlike all other jurisdictions in Maryland, the City Council has been unable to adopt laws and policies to hold officers accountable for misconduct, yet Baltimore City taxpayers pay civil settlements for these acts. In Baltimore between 2015 and 2019, 63% of residents were Black, whereas 90% of all police use of force incidents were against Black people, compared with just 7.3% of incidents that were against white people. The killing of Freddie Gray in 2015 and the police response to the uprising that followed spurred national attention, and these events served as the tipping point for the ongoing 6-year consent decree between BPD, the Department of Justice, and a federal judge, demonstrating the continued need for police accountability. As has been raised in 2021, this General Assembly, and very much involved this committee, enacted legislation to transfer the control of BPD to Baltimore City if Baltimore residents voted in favor of a ballot initiative prompted by the measure. And that ballot initiative was supported by 82% of Baltimore residents. However, a provision in the Baltimore City Charter continues to prohibit the Baltimore City Council from fully exercising legislative authority over BPD. HB 853 addresses this by striking a portion of Article 2, Section 27 of the Baltimore City Charter, identified by the Baltimore Legal Department as a prerequisite for the City Council to assume control of BPD. We urge a favorable report of HB 853, the proposal that treats BPD like other city agencies, other police departments in the state, and fulfills the will of Baltimoreans. Thank you.
Thank you. Mr. Roca needs to move the microphone so it's facing him.
Do you want to switch it there? Or? Okay.
Okay.
Mr. Chair, members of the committee, my name is David Roca. I'm a staff attorney with the ACLU of Maryland, here to urge your support for HB 853 without amendments. I'm not going to focus, given the limited time, on the need for the bill as a whole. As you've heard, it's a long overdue measure that is removing the last vestiges of state control over the city's police department. I want to focus my time on amendments that the city administration has proposed to the bill, which would reinstate restrictions on the City Council's control, saying that they would be hindered from, they would not be able to pass legislation that would hinder the powers of the Commissioner over any deployment, investigative strategies, as well as any personnel, staffing, or daily management decisions. And I want to address why that would be improper. First, it's improper as a matter of principle. We don't have similar restrictions for any other city agency in Baltimore imposed by the state, nor does any other city in the state of Maryland. Indeed, as far as I know, in the entire United States, have similar restrictions of legislative authority over their police department. And substantively, the City Council should be able to pass legislation about police, quote, investigative strategies. For example, if the City Council wants to ban the Baltimore Police Department from using facial recognition technology, which is an investigative strategy, it should be free to do so, just like City Councils have done across the United States. And if the City Council wants to ban the BPD from doing consent searches, also an investigative strategy due to the huge racial disparities in their use and effects, just like a bill that is currently before the Montgomery County Council with respect to their police department, it should be free to do so. And when Mayor Scott was on the City Council and was a leading champion of the effort to restore the Council's authority over the BPD, he wanted the City Council to be able to revise the BPD's out-of-district
out-of-date district boundaries, which would affect deployment decisions. The city council should be able to do those things just like every other city council in Maryland, just like every other city council in the country. Thank you, Mr. Chair.
Thank you very much. Are there questions for this panel? Delegate Eric Hand.
Thanks. To the gentleman who just spoke, you did mention two things, because I was just thinking in my head, like, what are the things that they're wanting to do now? So you said facial rec, and you said there was the consent searches. That's already being debated in another jurisdiction. Is that right? Is there other things that you guys are trying to work on that you've been unable to? I'll let the sponsor decide who can answer.
So as I chair the committee on public safety, so I can try and answer it as best as possible. There are a couple of things that we have in mind, and I've sort of looked backwards at things that we would have wanted to do. For instance, body cams. It's a standard now across many of our departments across the state. It's something that we would questionably be able to do that with these limitations. District mapping. So we just redistricted the entire city. That was something that had been attempted for over 50 years, and we finally had the opportunity to do that. That would fall under one of those sort of management decisions by the police commissioner, for which we would not be able to do that as a city council again, and we would theoretically have to come back to the state in order to do our district maps, which I think is pretty silly. Another one is trauma-informed care. It's a standard that we have across all of our city agencies, realizing that a lot of folks in Baltimore City are experiencing trauma. And thinking about that when we walk into these very tense situations is going to be really important with de-escalating sometimes very tense situations. So these are some of the things that, looking backward, would already be things that we have done or tried to do but had to come to the state, or have not come to the state yet, just because it's hard to bring these things that are sometimes not relevant at the state level quite yet. There is a question right now about facial recognition. It's something that the council is deliberating on, but it's not something that we're trying to rush into, realizing that I think in some ways the state should really make that decision. But I think that is a decision that the city council should have the ability to use.
Until Eric, and I just want to mention for your consideration that the bill he mentioned, I brought that bill that enabled the council to actually change the boundaries of the police district. So I had to come here and do that, right?
Yeah.
And one of the things that is also problematic about that is that every other resident of the state knows that the people they elected locally to represent them can handle that without having to have input from people that live in other jurisdictions. And I think that most people could understand that that's a wrinkle to always have to talk to a body that is composed majority of people that are not in your jurisdiction to get their blessing for things that only impact people in Baltimore.
Yeah, I mean, I hear you. We have a lot of bills right now that are essentially usurping local control that are flying through, so hopefully all of those bills will also get some scrutiny. Who was the one opposing vote on the council?
Your colleague.
Oh, well, I look forward to hearing from him in that case, and to Commissioner Harrison. I know it says he's favorable with amendments, so I look forward to that. Thank you.
Delegate Young and then Conaway.
Thank you, Mr. Chair. Delegate Young was the one dissenting vote, not dissenting because I oppose local control. In fact, I've been working on local control since my first day at the ACLU of Maryland back in 2018. Mr. David Roker will remember. We had a good time working together. I still got a lot of respect for you, Mr. Roker. Mr. Councilman Conway, you mentioned that there was an opinion confirming that no one had legislative authority. That's an opinion that at least when I heard it, I didn't think it made sense. Could you, have you sent that written opinion? Where is it from? Is my question.
Hot off the presses, we got it about 20 minutes ago.
From
the law department in Baltimore City.
All right, if you could share that, because the draft I saw didn't quite say that. I believe the draft I saw said that the city council has authority, but it is very narrow authority. It is very limited by the language that is in the drafts that need to be, that are in the bills that need to be repealed. So I would just want to see that, or rather, I know that the administration is going to be speaking shortly, so I would just ask this administration in advance if you all could just be prepared to provide clarity. My second question, last question, is what are the powers of the police commissioner?
I don't have that in front of me at the moment. Unfortunately, I didn't come with my big binder. But I want to, because this question ties to the former one, there are a list of 15 powers of the police commissioner outlined for basic management of the police department. runs the gamut. What the decision from the law department effectively says is that covers almost everything, and there's nothing left to legislate. And so I think that's where the nuance is. Technically, sure, we could write laws that are outside of those 15 listed things, but the reality is there's not that much outside of those 15 things.
Yeah, so just to clarify, folks, Delegate Young is in support of local control. That is not a question. Delegate Young is in support of local control on June 1st, to be clear. I do, however, think that when we look at that list, I challenge where you said some of those things aren't available. I do recall that there are some circumstances where we do need to adjust that list to assure that everything that we've been talking about for years as it pertains to local control is available. A full repeal could do that. There will be, I don't want to speak for the folks who's going to speak to the other pieces on why there's an amendment, but I want to also be clear, and this is the last thing I'll say, the amendment that was referenced by Mr. Roca today, I shared with you all, Mr. Roca, CJSJ, and specifically as a draft in a back channel to ask for feedback. And I want to be clear and on the record that what happened instead of good faith negotiations was that you all returned with opposition, and it went public when I gave it to you all as a back channel to get feedback on what could work. So level setting and making sure that what's on the record is what's true. That language is draft language. It was never official language. And I did not appreciate and do not appreciate the fact that it went public and that it's been referenced in this hearing. Thank you, Mr. Chair.
Mr. Chair, can I add some clarification about what this bill does, just in light of that conversation? It would just be 3 seconds. Just a moment, sir, please. This is my bill. So I just want to emphasize that this bill is about ensuring that the locally elected Council of Baltimore has the identical rights to regulate the actions of the police force in Baltimore City that exists in every other county and jurisdiction. Anything that is dissimilar or not the same is not what the intent of this bill is about. And as such, the delegation did not support this bill with amendment. It is supported as presented to you today to be equal to all other jurisdictions, not a modified diet version of local control, identical.
Thank you, Mr. Chairman, can I also address?
Very, very briefly.
So, to my good friend, who I love and admire, but who I strongly disagree with on this issue, as you well know, but I also want to correct for the record, the language that I quoted is the language that Ms. Dana Moore proposed in the Senate hearing on this bill last Wednesday. That's the source of the language, okay? I want to be crystal clear about that. And I want to be crystal clear about something else that has come up, which is that this idea that the Baltimore City Council needs special restrictions on its ability to legislate in this area when no other city council in Maryland or the country has similar restrictions is simply wrong. And the reason it's wrong is because the same principles that apply to every other city council in Maryland apply to Baltimore as well. Baltimore City Charter has a separation of executive and administrative power. The powers that you referenced, Delegate Young, in the City Charter 16-7 are the kinds of administrative powers that any head of any agency has and has to have. But that doesn't mean for any agency that the City Council doesn't get to set policy. And the language that you're talking about, the language that Ms. Moore was talking about, the language that the Commissioner is talking about, all of that is aimed at restricting the City Council's ability to set policy. That's what they should be able to do. And if there is a concern that they have overreached, then those concerns can be argued in terms of separation of powers principles, which are inherent, not inherent, explicit in the Baltimore City Charter. And that's how these issues should be resolved, not by imposing separate additional substantive restrictions on the council's ability to act in this area. Thank you.
All right. Delegate Conaway, Tomlinson, and then Tolles.
Thank you, Mr. Chairman. Thank you, Delegate/Chair Lady, for bringing this bill. Thank you, councilmen and witnesses, for coming in. To the councilmen, while this might not be in the bill, this was testimony on the bill, and I'm in support of your local control, or our local control. And I was wondering about the testimony about the police body camera. Can you elaborate on that a little bit more?
Sure. So this was a bill that was actually passed by the council when our current council president was just a council member. And it required that the Baltimore City Police Department wear body cameras.
Do you know what year that was?
I wasn't around then. 2014?
I'm looking at Legal Defense Fund 2014.
Yes.
Okay, go ahead.
That sounds good. And so you already know the answers to these questions.
Oh, yeah, I do.
That's good.
I'm waiting on you. I got the answers.
So when that bill passed, the law department essentially struck it down as illegal because it's not something that we could do. It wasn't a power that we had as a city council.
Was that the only reason that you passing that legislation was illegal?
There are two reasons.
Oh.
So first, the Baltimore City Police Department was a state agency. And the second, Article 27 in our charter prevents us from writing laws that restrict or inhibit or affect the job of the police commissioner.
Okay. So in 2013, do you know of anybody introducing that bill statewide?
I don't.
That happened to be me.
Hmm.
Do you know why we couldn't pass the bill for about 3 years until then Delegate Sidnor and now Senator Sidnor became involved in the bill?
I don't.
Because we had to breach the wiretapping law. And if a person knew exactly what the bill does and the ins and outs of the body camera footage, it could actually be questionable. So based on that, do you think that you would have the right as the city council to breach wiretapping laws in the state?
I think that's something that we would evaluate given the legislative process, and that's precisely what it's for.
We were told at that time that you couldn't do it, and
Yep.
you needed state approval. But I thank you very much.
Thank you.
All right, Delegate Tomlinson and Tolles.
Thanks, Vice Chair. Obviously, I don't represent Baltimore City. I don't live in Baltimore City, but I do work in Baltimore City, sometimes play in Baltimore City. The thing that I'm mostly concerned about is public safety, the crime. How does this bill, or does this bill in any way, would getting control back of the city police department help in any way with public safety or crime? And I know that answer could be, you could probably give a 10-hour answer or just a simple yes. But that's what I'm concerned about. So will it in any way?
Well, Delegate, I want to say we also are very concerned about it. We live, play, and work, and sometimes, worship in Baltimore City, so we care deeply. And I think when you consider that public trust is hampered when there's disconnect, right? So if the very people you elect to represent you locally have no practical oversight over the law enforcement, community, I think there's that disconnect in Baltimore that doesn't exist to the same degree in other jurisdictions, right? Think about the fact that we have all these disjointed institutions, right, that are supposed to be serving the public, but the public doesn't have a more express on-ramp to engage and get redress and to feel heard. So quite frankly, I feel restoring local control, while symbolic in part, it also is powerful to make people feel I'm a part of a legitimate community where my voice matters, and I can actually, express myself to the people I elected to, to advocate, regulate, or do what's necessary to ensure that we want our law enforcement community to feel like they're part of the community, not separate from the community. And right now, having so many separate actors, separate institutions, and separate on-ramps for redress, I think it only exacerbates the disconnect communities feel from law enforcement, that ultimately, if people don't have a working trust with law enforcement. We cannot close cases. We cannot ultimately make people feel safe, because that disconnect means a hesitation to engage with the very people we entrust to keep all of us safe. And we just want the same circumstances that you enjoy in Carroll County or any other jurisdiction in the state.
So I'll try to answer this. I've been on the council now 2 years, and I can tell you there's one question from a particular news station that I get every single time they reach out to me. Is, what are you doing about public safety in the city? And frankly, this is one of those areas where all we can do is hold oversight meetings. It's all we can do. And I can tell you that is incredibly frustrating. It kills all imagination in lawmaking. And I think a lot of that will be determined with the new authority. I'll say also there to Delegate Smith's point, I'm sure you know we are under consent decree at the moment. It costs the city millions of dollars every year. It costs the city a lot of millions of dollars to actually comply with that consent decree, and the commissioner can tell you a lot about what that process has looked like. And I believe that is in part because our city legislature has been unable to pass laws when there have been problems within our police department. We would not be here, well, hopefully, I can't say, but we would not be here if we had the ability to actually act when complaints came to the city and to the council on issues with our police department. So how does it make us safer? I think that is yet to be determined. I think there are a number of creative things that other cities across the country are thinking about with helping their police department to be more effective, and I can assure you that is my highest priority. But I will say it will go a long way in mending that social contract between voters, between people who live in the city, between people who play in the city, and the people who protect the city.
Thanks. All right, Delegate Tolles.
Thank you so much, Mr. Vice Chair, Madam Chair of the Baltimore City Delegation. I noticed that we have another bill coming after this that's similar. Could you ask for two things? Could you explain to me the difference? And secondly, could you clarify that the Baltimore City Delegation is supporting this particular bill that we have forward?
Sorry, can I just clarify? I think if you're talking about 975, that's been withdrawn.
Oh, that's withdrawn?
Yep.
Okay.
Yep.
Thank you. Thank you, Mr. Vice Chair.
Well, I have nothing to say then, it sounds like.
All right. Thank you. Thank you so much. Thank you. Thank you, Mr. Chair.
All right, thank you very much. We're going to move on to the next panel of favorable witnesses on this bill. I'm not sure, some of these might be from some of these other folks that are sitting up here, but Kim Sauer, David Kramer, Darlene Kane, Meredith Riley, Sergio Espana, Melanie Gordon Newell, Molly Amster, all right, whoever would like to begin first, you have 2 minutes.
Thank you, Chair. Oh, can you hear me? Sorry. Thank you, Chair, members of the committee, and the sponsor for bringing this bill. My name is Kimberly Sauer, and I'm here on behalf of City Council member Christopher Burnett, who represents the 8th District. We're here today to urge you to pass House Bill 853, which restores local control and allows City Council to have legislative authority over the department. As it stands, no one has authority over BPD due to this technicality. HB 853 would fix that. This lack of control continues to hinder the efforts of the council in passing policies related to policing and crime, like Councilman Burnett's efforts to expand transparency and build regulatory guardrails for the department's use of facial recognition technology. Unable to include BPD, the council is only able to legislate protections pertaining to the private sector. The Baltimore City Council legislates year-round, which is particularly important when issues come up that demand an immediate policy or accountability response. The council can act immediately rather than delay because it must be referred to the Maryland General Assembly. If we can continue to prolong the full transition of the control of BPD, we will remain in a limbo state. Since becoming a city agency by the majority voters, the Maryland General Assembly has no authority, but with these provisions still in place, neither does the city. If the General Assembly does not pass HB 853, it will continue to block the complete and immediate transition of local control back to the city. For these reasons, we urge you not to delay this transition any longer and pass House Bill 853 without amendments. Thank you.
Good afternoon, Vice Chair Moon and other members of the committee. My name is David Kramer, and I'm here on behalf of Surge Baltimore, showing up for racial justice. We are in coalition with the Campaign for Justice, Safety, and Jobs, and we are in favor of this bill. I'm also here as a citizen of Baltimore. I'm a lifelong resident of Baltimore. And whoever I ask, whether it's neighbors, friends, or we had a big campaign to go door-to-door canvassing for the referendum that was passed in November, everyone is surprised to hear that Baltimore does not control its own police department and is actually an agency of the state. Whenever I ask, do you think that's right, everyone answers, we need to have control of our own police department. And at this point in time, it seems like we're in a no man's land where no one can legislate. It's imperative that this gets passed right away so that we can clear up this discrepancy in our charter so that we could have full control of our own police department. And I defer my time. Thank you.
Thank you, Mr. Chair and members of the committee. My name is Molly Amster, and I'm the Maryland Policy Director and Baltimore Director for Jews United for Justice. JUHA organizes 6,000 Jews and allies in support of social, racial, and economic justice campaigns. I want to thank our bill sponsor, the chair, and other members of this committee who have twice passed legislation meant to restore local control. We should not be here today testifying on legislation to restore local control to Baltimore City and our City Council again. Not in any way placing blame, and this should and could have been done in a 2021 law that sought to restore local control contingent upon the passage of a ballot measure. And as you heard, we did that. On January 1st, our police department is now a city agency, but our city council remains powerless. That's why we're here and need you to pass House Bill 853 to finish the job. We urge you to swiftly move to honor the will of Baltimoreans, our City Council, which passed a resolution calling on the General Assembly to take action to immediately implement local control, and our city's House delegation, who voted to support it yesterday. I've been working to restore local control since at least 2017. The goal of local control was and always has been for Baltimore residents to be able to lobby their elected City Council representatives in Baltimore year-round for changes to the BPD. The federal consent decree, which was established due to abusive and racist policing practices in our department, mandated the formation of the Civilian Oversight Task Force to issue recommendations to improve police accountability and strengthen police and community relations. Restoration of local control was a key recommendation. They said that BPD will never be accountable to the communities they're paid to protect and serve without the City Council having legislative authority over the department, and urged restoration of local control to happen, and this is a quote, with all deliberate speed. That was in 2018. Mayor Scott said it himself, local control of BPD is about racial justice, police accountability, and representative democracy. We urge a favorable report on House Bill 853. Thank you.
All right, thank you very much. We've got a few folks signed up to testify favorable with amendment. Michael Harrison, Dana Moore, and Nina Themelis. Whenever you are ready, whoever would like to begin.
Good afternoon, Mr. Chair, Mr. Vice Chair. I am Michael Harrison, again, the Commissioner of the Baltimore Police Department. Thank you for allowing me to speak today on House Bill 853, which I support with amendment. And I get and understand the practical implication that the language that has been presented to the members of the council and the proponents of this bill. I'm concerned, however, with the deletion of the line altogether, that we run the risk of political interference with the day-to-day operations of the Baltimore Police Department. During the debates on local control, the City Council General Assembly proponents have brought up several examples and instances like body cameras in 2015, the Trauma-Informed Care Commission of 2020, facial recognition prohibition in 2021. I will submit to you that facial recognition body cameras are tools that are technology tools. They're not deployment or investigative strategies. They are tools to be used for investigations, for oversight, but themselves are not strategies, are not deployments, and are not investigations in and of themselves. So I wanted to make sure we point that out. Listen, in the wake of the Gun Trace Task Force, the city commissioned in a 2-year investigation that took 2 years to complete, which produced recommendations on best practices for a police department. And then the last recommendation, which was 25, it reads that the BPD commissioner should be provided with the latitude to run the police department with minimal operational interference from elected officials, and under no circumstances should elected officials become involved in investigative or personnel matters. While the mayor is obviously the commander-in-chief, appoints the commissioner with the consent of the city council, we all get together in uniformity, create deployment strategies that we talk about to the public and to the city council all the time because they have oversight of us. But it is, we strongly believe that adhering to this recommendation and the concept not only is crucially important to avoid further scandal, but simple best practice in how to run a police department and the day-to-day operations of hiring, promotion, selection, discipline, deployment strategies, investigative strategies.
Good afternoon, Vice Chair Moon and members of the committee. My name is Nina Themelis. I'm Interim Director for the Mayor's Office of Government Relations, here to testify on HB 853. So the Baltimore City Administration supports making changes to Article 2, Section 27 of the city charter, but not in the way that is outlined in this bill. In November 2022, Baltimore City residents voted overwhelmingly to transition the Baltimore Police Department to local control. Today, the Mayor and City Council have that authority over the police department. Article 2, Section 27 of the Baltimore City Charter does not prevent the City Council from passing legislation concerning the Baltimore Police Department as a whole. It restricts that action to not infringing upon the powers of the police commissioner, which are outlined in the public local laws. It has been suggested that BPD's executive structure and powers include authority over deployment or investigative strategies, as well as personnel, staffing, or daily management decisions. This would be consistent with the structure of other city departments and agencies, as well as reflective upon how the General Assembly has legislated over the Baltimore Police Department while the department has been under its control. The Baltimore City Administration requests the language to be included to Article 2, Section 27 for those items. I do want to point out that having those items retained by the police commissioner would make him solely accountable and responsible for those decisions. And that is very important when it comes to our consent decree. The consent decree has been the city has been under the consent decree for the past 6 years. While there's no explicit conflict with local control and the consent decree, we believe that ensuring that the actions required under the consent decree remain as singularly and centrally focused as possible, which is why BPD has developed the language that we had submitted to the committee. The last thing that the city would want to do would be to violate this consent decree due to unintended consequences of locally enacted legislation that would result in federal takeover of the department, especially over these past 6 years of progress. So for those reasons, we understand and support the intent of HB 853, but would request the additional language rather than the removal of that section. Thank you.
Good afternoon, Mr. Chair, and to this honorable delegation. My name is Dana Peterson-Moore. I am the City of Baltimore's Chief Equity Officer. I'm also the Director of the Office of Equity and Civil Rights, and I am the Chair of the Local Control Advisory Board. And I am a 41-year resident of Baltimore, which is almost a lifetime. But don't ask me to do the math. Here to support HB 853 with amendment, and those amendments have already been discussed by Commissioner Harrison and Nina Themelis. The reason that I support it with amendment is because of, first of all, because of the consent decree. People keep talking about Baltimore and why should Baltimore be different. We should be treated differently because we are different. We are the jurisdiction in the state of Maryland that is under a massive sweeping police consent decree. We've been under that the restraints of the consent decree for approximately 5 or 6 years. We're hoping to come out of that at some point soon. But anything that is done that interferes with the police commissioner's powers to manage the day-to-day operations of the police department imperils our ability to comply with the consent decree. Allowing the police commissioner to retain the power to manage the day-to-day operations of the police department is an equity position, I believe. It allows the police commissioner and the police department to be treated like any and every other city agency in the city of Baltimore. There is no other agency that is subject to and has explicit statements that the city council should control the day-to-day, and we need the amendment in order to assure that the city police department is treated like every other agency. My last point is that on January 1, 2023, not only did the city police department become a city agency, it became an agency subject to the legislative powers of the city council. They have that power now. All they need to do, as I've said, click your heels 3 times and legislate. Thank you.
All right, Delegate Erican.
Thanks. Yeah, I wanted to touch on consent decree, but you already explained how the concerns could be. If we've got a lot of cooks in the kitchen, there's a lot of higher risk that we're going to have not fully baked cake coming out of that oven. So thanks for sharing those thoughts. In terms of the day-to-day ops, could you just let me know, Commissioner, what other things are you concerned, besides just the body cams, might be impacted?
Thank you. Great question. Things like body cameras, again, are technology tools. They themselves are not they are not investigations and or strategies. They're neither. Facial recognition, it's a tool, a technology tool that could be used in an investigation, but itself is not an investigation. The things that I think concern the administration are like the calls I get that suggest certain people either should get promoted or not be promoted, assigned to a specific area or not assigned to a specific area. And I get those calls pretty frequently. Not all, but some. Or this is what we should be doing in this particular area. And we're a data-driven agency that we follow the criminal justice, the police science, and the crime data that suggests or determines how we deploy, when we deploy, and how we do that equitably and fairly and constitutionally across the city. And I want to make sure that the culture that I tried to kill, and I believe that I've killed with interference and the cronyism prior to my administration of how people got promoted, selected, and or unpromoted and selected, never returns.
Yeah, okay, that really helps illuminate what the concerns might be and how they could make a policy essentially that might be innocuous, but then as it trickles down and hits the streets, it could still put you in a violation of consent decree, even if that wasn't their intent at all. So thank you very much for sharing that.
Delegates Conaway and Young.
Thank you, Police Commissioner, for coming in and witness panel. So to the Commissioner, you spoke about the constitutional use of tools. We've already talked about the police-worn body cameras. Is it constitutional for Baltimore City the City Council to decide to use the facial recognition system in law enforcement?
I think they have the authority, number one, to decide, just like the consent decree. For every technology that we want to implement, I don't unilaterally make that decision. I actually have to get the blessing of the Department of Justice to make sure that it is, number one, a technology that is constitutionally used and that there are safeguards to guard against abuses. I believe the City Council would have the same authority and would use it the same way.
Is it okay for me to ask you if Baltimore is using facial recognition software?
We do not have facial recognition software. There are everyone else in the state likely does and uses it. We do not have it. We have the ability to access it through the state, but we, as a city or as a police department, do not have the software or technology.
Is Baltimore using the surveillance system that was known as the Eye in the Sky?
We do not.
Do we have any plans on using an automatic drone surveillance grid system that you know of?
We do not have that, and that has not been presented to me for consideration.
Thank you so very much.
Thank you.
Thank you, Mr. Chair. Just for the record, David Roker is one of my favorite people, and we've had much worse arguments in private, and we still love each other. My question is for Director Moore. I understand that there was reference to new law department opinion that hasn't been shared with the committee yet, but I would like for it to be shared. I understand that you have some clarity on that. Could you provide that, please?
I do, and thank you for that question. And I would have thought that I would be one of your favorite people, but that's okay.
Director Moore, of course you are.
In full disclosure, in another life, he is my deputy.
That's right.
In full disclosure. So yes, I do have the law department opinion, and it goes on for about 2 pages. The bottom line of that law department opinion is, just as I stated, that on January 1, 2023, the Baltimore City Police Department became an agency of the City of Baltimore, and the City Council acquired the ability to legislate over the Baltimore City Police Department. That is clear. What is also clear is that ability is limited. It is limited by Article 2 of our city charter, Section 27, which is why the amendment was that is why the bill was proposed and why we are here to support that bill with amendment. We need to protect still the day-to-day operations of the police department. So that opinion is available. I believe that if it hasn't yet been released publicly, it will be, and it clarifies for all that when I say that you can legislate, the City Council can do so today. Thank you.
Thank you, Mr. Chair.
All right. I think that might be it. It looks like nobody is signed up to testify in opposition, so thank you very much. That's going to end the hearing on House Bill 853. We now have 3 bills from Delegate Young, starting with House Bill 1044. There's a slight change in order here. It's going to go 1044, 1022, and 1030. Those are all Delegate Young's bills. 1044 is jointly assigned with appropriations, so we've got Delegates Ivy, Acevero, and McComas joining us for this. So obviously, if you have any questions, just flag us down. All right, Delegate Young, whenever you're ready.
Thank you, Mr. Chair. Thank you to my colleagues here on the Judiciary Committee and our colleagues who have joined us here from the Appropriations Committee. I'm here today in support of House Bill 1144, the Crime Solvers Reward Fund Establishment. This proposal seeks to raise the current rewards that we give out in Baltimore and indeed in Maryland from roughly an average of about $8,000 in Baltimore City to hopefully having a goal of reaching about $50,000 in the across the state. When you step forward with information that leads to the arrest and conviction of an individual who murders someone in our communities. As a concerned member of our society who places high value on equity and security in our neighborhoods, I strongly believe that this bill constitutes a crucial advancement in grappling with the grave challenge of homicide in Baltimore and in Maryland. Allow me to paint a quick picture. You live in East Baltimore and you see a murder take place in your neighborhood. You have critical information, but you are scared to step forward for fear of retaliation, for being labeled an enforcement, and because of what we all know is the stop snitching culture. This proposal increases the rewards, again, to provide a much-needed incentive for that individual to overcome those concerns and come forward with that vital information, allowing that individual to potentially start a new life if they needed to move out, or perhaps at least helping to bring justice to somebody who needs it. Furthermore, this proposal would help create a culture where individuals are not deterred from providing that information from police, providing that financial incentive, addressing those real concerns would then hopefully create a culture of collaboration, a culture of trust between police, law enforcement, and our communities, thus leaving for a safer community. Additionally, according to the Baltimore Sun, just this morning, there was an article where they did a review of the 990s of Metro Crime Stoppers, the entity that provides for these funds throughout our state, but certainly in Central Maryland. It turns out that only $126,000 has been provided in rewards over the last 20 years, since 2000. That is the tax IRS reported information. Last year, about $3,000 was rewarded. So we have roughly an average of $6K that's being given out every year. Clearly, no one is stepping forward on that little bit of money. Here's another example, straight for you, Delegate Embry. Just yesterday, I found out that a $4,000 reward was given out for a murder in your district at the laundromat. Certainly, that should be a higher number. In conclusion, folks, this proposed increase to Crime Stoppers Rewards Fund is a practical solution to a serious problem. It makes sense to regular folk, and we need to help ensure that those individuals who are brave enough to step forward, we show them that we value their risk with a reward that's worth it. Thank you, and I urge a favorable report.
Good afternoon, Mr. Chairman, members of the Judicial Proceedings Committee. I am Michael Harrison, again, the Police Commissioner for Baltimore City Police Department, here to testify in support of House Bill 1044. And I would like to thank Delegate Young for the opportunity to speak about the Crime Stoppers Reward Fund. This bill provides that this special fund in the Department of Public Safety and Correctional Services be used to provide reward money to individuals who provide a law enforcement agency with qualifying information relevant to the investigation of a murder or an attempted murder involving a firearm. The qualifying information is information that directly leads to the identification, arrest, and conviction of the perpetrator. For an individual to be eligible for this reward, the agency must establish that the individual provided credible qualifying information, did not directly participate in the crime, and cooperated with the law enforcement agency. As we all know, the gun violence affecting Baltimore City and all jurisdictions in Maryland is unprecedented, and BPD supports an effort to engage with members of the community who possess information that can help us solve these violent offenses. It's important that these citizens are appropriately rewarded for coming forward. This will encourage residents to build relationships with law enforcement and shape a new sense of community focus on accountability. And once again, I have seen this work in my other job as chief in New Orleans and in Baltimore, where more incentives means more timely information and more accurate information in identifying and apprehending people responsible for shootings and or murders. And for these reasons, the Baltimore Police Department respectfully requests a favorable report on House Bill 1044.
Good afternoon, Chair and to the committee. My name is Archie Rams. I'm an East Baltimore resident and a proud father of 5 children. I stand before this House as a community member in support of Delegate Young's Bill 1044. We, the people of Baltimore City, believe that by increasing the Crime Solvers Reward Fund significantly, it would no doubt become a deterrent for people who want to make stupid decisions by putting fellow citizens in harm's way and disrupt the crime in our city and state. We're asking that the state and the city government make a substantial statement, a substantial, powerful statement, that it is good to come forward, and that the community appreciates those that do. It is less about the money and more about the message it sends that those who come forward to help solve these heinous crimes are needed and appreciated, and that the risks that they take in doing so are valued. That solving these crimes that helps everyone is of value to the community as a whole, and that the deed is appreciated and the risks that people take are recognized. The current situations does not do that, except in a very few high-profile cases that have large rewards. The small rewards offered by Crime Stoppers of around $8,000 at most for helping to solve a homicide is not sufficient to tell the people that their efforts are appreciated or to outweigh the pressures against coming forward. We suggest a dramatic increase in the rewards to help solve major crimes. We suggest an amount that reflects some of the value to the community. We suggest that the state and the city both offer $50,000 rewards to people who risk coming forward to help solve the many unsolvable homicides and attempt homicides that occur in our city every year. We, the people of Baltimore, want this. We recently voted 79% to 21% to approve a new reward fund for helping to solve crimes. We are asking the state to match the city effort. Thank you for your time, and my request is that the Chamber finds favor for this House Bill 1044. Thank you.
Good afternoon, Honorable Chair, and to the legislative members of this chamber. I humbly greet you. My name is Reverend Joyce Jones. I live in District 8, that's Edmondson Village, and I minister in District 7, that's Sandtown, Winchester. I am a retired nurse of 34 years in Baltimore City, and I have personal as well as professional hands-on with families who have lost loved ones through the tragedy of violent crimes. I'm here today in favor of this bill because I have my finger on the pulse of the community and that has experienced the greatest amount of trauma from violent crimes. The Department of Justice costs them $8 million for each homicide. We are at 300 on an average for the past 7 years. Add to that shootings, robberies, and crimes totaling an average year of $4 billion. I'm speaking here today because we live in a culture that breeds snitches get stitches. I am here to say and to support Delegate Young and Bill 1044, House Bill 1044, because we want to change that. We want to incentivize the witnesses. We want to give the witnesses the power back, the citizens of Baltimore their power back, and to breed a different climate in Baltimore City, to breed a climate that we can stand up and take part and speak up and speak out. Sadly, this year, we're on number 45, but sadly this year, the increasing amount have been younger individuals. If we could solve one crime by someone standing up, that would decrease the rate and bring closure to some mother and some child. Thank you for your time.
Delegate Boucher.
Thank you, Vice Chairman, and thank you, Delegate Young, for having the courage and leadership to bring this forward.
Appreciate you.
My question pertains to page 3, line 5, about federal funding. What federal funds are available, and are they need-based to potentially get increased funding? If we have more crime, can we get more funding for this?
I'm not aware of the need base. I also don't have a current list of what federal funding is available. I'm certainly happy to get that to you. Mr. Commissioner, might you know?
There are several federal law enforcement agencies that have funding, the FBI, the ATF, and there are times when we have crimes that one or both of them will add to what Crime Stoppers offers on its own. So there are times that depends on the criteria and what type of heinous crime is committed in the criteria, and if there's some FBI involvement, they will either offer or we can ask, or a combination of both, for the FBI to increase the reward money. Sometimes ATF will also do it, especially if it's a case involving guns and trafficking of guns.
Well, thank you very much. Appreciate it.
Thank you.
Thank you, Delegate, for bringing the bill. Thank you, panel, for coming in, and Police Commissioner. My question is in reference to page 3, line 25. What is the meaning of directly? That a person did not directly participate in the crime. And what I'm talking about is, let's say a person is hacking, they're being a taxi cab service without a license, and they take some people to a liquor store or something. People go in and rob the store, somebody gets murdered. The person who was driving the vehicle doesn't know anything about that. Later on, they find out that they actually drove those people to the store. Would they have directly participated, or would they be eligible for this reward?
Based on the hypo, and you've used the hypo a few times, so I'm familiar with it.
Yes.
I would argue not necessarily that they would not be ineligible, is what I'm trying to say. They would not be directly participating in the crime. But that being said, I would leave the discretion of who is directly participating to the state's attorney and to the police department. And I know the commissioner wanted to touch on this too.
Yes, sir. I would say, first of all, great question. I would say that two or more people involved in a shooting and or a murder and are there and are participating in that, just because one of them got away, that person cannot then receive the reward money to build a defense for himself against the person he was committing the crime with.
Thank you, officer. And Delegate, of course, you know that we're looking at legislation to say that a person who is not aware of their participation in a crime would not be charged. So that's why I was asking you that question.
Just to clarify, I believe that bill is one who is not aware of their participation in a murder would not be charged with felony murder.
Right.
But they would certainly still be charged of whatever other crimes they may have participated in.
So then they should be eligible for this fund?
I think
If that
that
bill passes.
I would leave the discretion to the police department and the state's attorney to make a determination on whether that individual qualifies.
Thank you for your consideration.
Yes, sir.
Delegate McComas and then Embry.
Thank you, Mr. Chair. I just wanted to know if there's been any documentation or studies that these kind of incentive programs do lead to convictions or capturing the felons. And then the other part of it is I know Baltimore has had the moniker of like the stop snitching, and so that a lot of people are fearful of saying anything, and then maybe that somehow it could be tracked back that if they ratted on somebody, they're going to be next in line to be the victim. So I wondered if you could comment on those concerns.
The first concern, I lost it just that fast. Can you tell me again? Oh, the research. So actually, so we've looked at research or tried to find research. We haven't found much. I actually had a conversation with the public defender office about just this, and they actually agreed that we can't really find much. And so the idea is that because there isn't much information at all, at the end of the day, we got to try something because people are dying. And so let's put this on the table. And at the end of the day, the cost-benefit analysis makes sense. We have 300 murders per year. Let's just round it up to 400 for easy numbers. It's 330. Let's round it up to 400 in Baltimore for easy numbers. Again, I told you my goal was 5,000 murders. Our commissioner has a budget of $565 million per year in Baltimore City. If we had 400 murders a year and y'all passed this bill and we funded it and we did give out $50,000 for each murder and we solved 100% of the murders, 400 of them, we would have spent $20 million. At the end of the day, if we don't solve the murders, we don't spend the money. So while, again, there isn't much research, I just see a very low risk for a potentially high reward of bringing justice to folks who need it. Your second question, if you the stop snitching culture, can you repeat it one more time?
Yeah, the second question was because of the stop snitching, what do I want to say, norm kind of in the city, and the fear of if you do snitch, you could be the dead person,
Right.
because somebody's going to kind of, connect the dots and say, oh, it was Joe over there. And so I'm kind of wondering, do you think that's going to be a potential problem? People will be reluctant. And I'll just, the Dawson family just kind of always is
My
like
district.
in everybody's mind. What happened to them?
Yeah. And I think that's part of, so Archie right here is the person that, when I knocked on his door, gave me this idea. And, part of the problem, and Archie, if you want to speak on it, please feel free. Like, folks, the money right now is $4,000. You can go to Miami, you can go to Vegas, you cannot move. And we want to make it so that way people can have that incentive if they don't want to stay in that neighborhood where they could be victimized as a consequence, that they have that option to make a change. Archie, do you want to?
And just to piggyback off of Delegate Young's statement, the culture has been in Baltimore for so long, and the only way to change that dynamic is to change the culture. I have so many elderly that are afraid to come outside. I have so many kids that seen everything but won't say anything because they don't want to put their family into harm's way. This would have a significant deterrent factor, and even if we don't have the data for it, this city is good enough to handle it, and I believe that by deterring, putting the factor of deterrence, that's something on the table, that's something that can help our officers, that's something that can help the community to say, look, stop, think first before you act, because there's a consequence. Right now we have a city with no consequence, very little. This would bring it up a notch.
Thank you, Delegate.
Thank you, Delegate, so much. Such an important issue and bill. I just wondered, reading the fiscal note, I'm puzzled by it because it says that this will have a cost of $1 million, even though you don't in the bill, you set up the fund, but you don't actually specify the amount to be appropriated. So I just wondered if you had any comments on how they arrived at that number.
Yeah, I think it says it in here. I saw it also, because when I saw it, I was questioning the same thing, because I purposefully didn't put a number, because obviously budgetary concerns, and that's higher than the Judiciary Committee. But if you look at page 3 of the fiscal note, the first paragraph, it says that it assumes a capitalization of $1 million for the purposes of, I guess, I don't know, just putting it in there. I don't know. But they put it in there, and I didn't have a problem with it. Again, my ask would be much larger than that ultimately. But again, I understand that that's a larger conversation with the administration and folks in appropriations. And so we tried to keep it a little bit more fluid in the meantime.
Thank you so much.
Thank you for your question.
All right, and I don't believe we have anyone signed up in opposition to speak, so thank you very much. We are going to House Bill 1022 next, also from Delegate Young, and also with our friends from the Appropriations Committee. Signed up on this, I've got Marcia Nettis, Kelly Meyer.
Actually, Mr. Chair, hold on, Mr. Commissioner. Can we actually take 1030 now? Because I know the Commissioner has to make a move.
Yes, sure. Okay, we can do that. All right, we're going to go to House Bill 1030. Michael Harrison and you. Okay, you're the panel. Go ahead.
Yes, just us. Honorable members of the Judiciary Committee, stand before you again here advocating for House Bill 1030, which is essentially a task force to study murder prevention and reduction in Maryland. I believe the bill is critical to help address our deepening concerns around this issue. You know, according to recent statistics, Maryland has a higher higher average than the national average as it pertains to murders per capita. We have 11.4 murders per 100,000 residents, and as we know, that's a little bit more challenging when you get into Baltimore, and certainly in certain parts of my district. This bill seeks to establish a task force that will bring together a diverse range of stakeholders to study the underlying factors contributing to homicides in our state. It recognizes that homicides are not isolated incidents, but rather a result of complex interplay of social, economic, and political factors, including poverty, limited access to education, inadequate medical health services, and of course, systemic racism. What I'm going to help try to do with this is mimic it after what we all heard of called the Squeegee Collaborative, where we brought everybody and their mama to the table, and we had a real conversation about what we needed to do to solve that problem. Today, and in fact, I think it was last night, WBAL had a story about how so far we've seen success there. We've seen a lot less folks on the corners squeegeeing. I want to mimic that, but focus on homicide. That means we always hear about law enforcement on the state, city, and local levels, and prosecutors coming together and having task force and having these conversations about how to reduce crime, but we don't do enough bringing in those violence interruption program and prevention programs like Safe Streets, like ROCA, like UMD ROAR. So I'm thinking about those folks. Also, domestic violence folks. I think Melanie Shapiro. Maybe she's not here. Domestic violence advocates. But essentially, all of those advocates and those people who bring around those wraparound services we talk about, the social workers and the employment development folk who are sitting behind me for the next bill. Like all of these people I want to bring to the table, have a series of conversations, and really try to hammer out what are the things that we need to do to reduce it. What are the challenges, but what are some opportunities to fix it? What legislation do we need? What coordination and collaboration do we need? Doing it on a statewide level. That's the crux of the bill. Bringing everybody together and having a real conversation about reducing homicides, because there's a lot of homicides in my district, and we need to find some solutions. That's the bill. Thank y'all so much.
Good afternoon, Mr. Chair again, and members of the Judicial Proceedings Committee. Again, I'm Michael Harrison, Baltimore City Police Commissioner, testifying in support of House Bill 1030. And I want to again thank Delegate Young for the opportunity to speak about the creation of this task force, which would study the causes of homicide in the state by conducting a comprehensive examination of factors. This task force would make recommendations regarding ways to increase the number of community programs to address the root causes of violence, ways to strengthen laws related to firearms and risk assessment tools, ways to expand access to mental health services and telehealth services, ways to enhance law enforcement and community collaboration, and lastly, ways to promote equity and justice for marginalized communities and end discriminatory policing practices. The BPD supports the creation of this task force, as we have seen firsthand how law enforcement alone is ill-equipped to solve this challenge. Murder is a complex social phenomenon, and reducing it requires multi-level, multidisciplinary, and multi-agency action. I have experience with these types of review efforts in New Orleans, when in late 2011, the mayor developed a strategic command to reduce murder initiative, which is very similar, if not identical, to what we're doing here in Baltimore today, which convened criminal justice and community partners to better understand the city's homicide challenge through strategic problem analysis, to develop effective responses, and to better focus available prevention and intervention resources. I'm a firm believer in collaborative, coordinated partnerships as a conduit for lasting change and meaningful, sustainable progress in reducing homicides. We all have a part to play, and a statewide task force holds promise in a more effectively aligning local, state, and federal partners around durable solutions, both in Baltimore City and across the state. And for these reasons, we request a favorable report for House Bill 1030.
All right, no questions on the task force. Thank you very much. Oh, you do have a question. All right, Delegate Conaway.
We can hear you.
$0, 0 cents, sir.
That's an outstanding bill.
Wait, we got another. Delegate Valentine.
Thank you, Mr. Chair, and thank you, Delegate, and thank you, Police Commissioner. My question has more to do with the letter of information from the Chiefs of Police Association, and is that just an oversight where they make a good point, instead of having 2 members from the Maryland Sheriff's Association, maybe having 1 from there and 1 from the Maryland Chiefs Association? Do you think that's appropriate?
Yeah, I saw that as a friendly amendment, and just remember, folks, when we started, we got these bills kind of late. Drafting, folks, was inundated with all of our requests, so, I got this kind of late and had to put it right in, so I didn't want to make a change, but I see that as a friendly amendment, and like I said, I'm going to be adjusting. If you read the bill, it's mostly government folks. It doesn't include a lot of the people that I mentioned that I would want to bring in, so we're going to adjust the bill with amendments, and you haven't received that amendment, by the way, but you will get amendments that reflect everything that has been said today.
Thank you.
Thank you, sir.
All right, we got 2 FWA favorable with amendments on the task force bill. And thank you very much. I think that'll be the end of questions for the favorable panel. Do we have virtual Vince McAvoy? No, we do not. What about in-person Melanie Shapiro? Okay, that's going to end the hearing on House Bill 1030. We're going to go back to House Bill 1022 with our friends from Appropriations. Again, Delegate Young. All right, and it looks like you've got a panel coming up. I'll just keep reading names if we got a couple more people here. Marcia Nettis, Kelly Meyer, Matthew Boley.
So my panel will be Marcia, Walter.
All right, you want to bring them all up?
Yeah, we're good now.
Are any of them online, your panel?
And Brave Boy.
Okay.
State's Attorney Brave Boy should be online.
Whenever you're ready.
As soon as I get back to the right page. Thank you again, members of the Judiciary Committee, my colleagues, here today now to promote HB 1022, Labor and Employment Post-Conviction Work Readiness Program. This program recognizes the challenges that individuals with a felony criminal conviction face as they try to reintegrate back into society. Quick statistics: about 1 in 3 releases from incarceration in Maryland are released back to Baltimore City. Certainly, I represent East and Northeast Baltimore. You can imagine a proportion of that, a significant one therein, come back to my district. So oftentimes, those individuals who are in my district face barriers to securing gainful employment due to the stigma of their conviction, and even though they have served their crime and paid their debt to society. However, we cannot afford to turn a blind eye to this issue and to those individuals. So HB 1022 proposes a critical step towards empowering those individuals and providing them with the tools they need to succeed through job training, placement services, and support and job development for participating employers. The program can help these individuals with employment needs. If you refer to the fiscal note, you'll see that it actually points to a potentially meaningful and significant, I don't know if it was meaningful or significant, the word they use, impact on small businesses by increasing the number of skilled laborers that may be potential for their job pool. We've heard many stories this session about folks who are re-entering society who struggle to provide for themselves and their family. This bill hopes to help break that cycle, the cycle that creates poverty, the cycle that manifests itself in crime, and allow those individuals to positively contribute to their society, to raise their families, and to be productive citizens in my district. I strongly believe that this bill, and yours, I strongly believe that this bill proposes an innovative and effective solution to the problem, and that's why I'm here urging your support. In conclusion, there are some friendly amendments that I've received from some of the folks sitting next to me who are local employment development practitioners from across the state. They're asking that we change this from a state program as drafted to a program where we are helping support their work, but with this population, which is something that the state does not currently fund. So I urge, with those amendments, a favorable report. Thank you.
Whoever would like to go next.
Thank you, Chairman. Thank you to the Chairman and to the Vice Chairman and to the entire committee, but a very special thank you to Delegate Young for taking up this bill and presenting it before you. My name is Marcia Nettis. I'm the Vice President and Regional Director for America Works of Maryland. I work in conjunction with the Workforce Foundation that specializes in policy development for those who are very much underrepresented. I stand today in full support of this bill, largely because of the support of what it's doing to help the communities move forward. We have been operating this type of programming for now 10 years in the Baltimore City area. I will tell you, I stand here today to tell you it is very successful. These are working with individuals who've been formerly incarcerated, again, primarily those who have felonies, a couple of misdemeanors, but primarily at least 2 felonies that are being released back into the community without the adequate support for them to be able to move forward and be successful citizens. I will tell you that it is so important that we get individuals who are returning back acclimated immediately into employment. I am proud to sit here today and tell you that we have a long listing of employers that are very much behind this effort and have hired these individuals believing in the second chance model in order for them to be able to fill a lot of their labor needs. It is imperative that we pass this bill because, again, these individuals are not only affecting their families, but again, we're taking a look at the second generational, multi-generational approaches it's having on them. I will conclude by saying that individuals who are part of this program, that this program should be expanded statewide. Multiple jurisdictions should benefit from the supports of this program. Thank you so much.
Good afternoon, Chair and Judiciary Committee. Thank you for this opportunity. I also want to thank Delegate Young. I'm Walter Simmons, the Executive Director of the Prince George's County Workforce Development Board and the President and CEO of Employ Prince George's. We've been operating reentry programming using a myriad of funds, donations for the last 15 years. We were identified after Baltimore having a large percentage of returning citizens. We also identified that we saw a large percentage of those going back into incarceration and doing that revolving door. They lacked opportunities. They lacked supports. The workforce system is funded through federal pass-through funds from the Workforce Innovation Opportunity Act. But those federal funds are not for supporting job seekers with barriers such as a criminal record and the mental health and other things that have happened, even the stress, post-traumatic stress from being incarcerated, which they say one night incarceration, you now have stress that will follow you for the rest of your life. So we see this as an opportunity for Maryland to create a statewide program and change the culture of how we approach returning citizens. Not looking at it from a human services standpoint, but looking at it from an opportunity to increase our economic base, increase the number of skilled workers in our labor force that our businesses have said that they have lacked due to COVID. We're also looking at a way to strengthen our households and apply 2-parent households and apply additional incomes to those households, which can increase educational attainment. We have been doing this for years across the 13 workforce boards, including Prince George's County. We're now looking for an opportunity to make this a standardized process across the entire state. And also, this is an opportunity to bring in funds. Yes, we're making an initial investment, but you are going to build the infrastructure of our workforce system to allow these local jurisdictions to then apply for second chance at grant. Right now, there's a grant on the street for $17 million if we had that infrastructure to apply for. Thank you.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Kelly Meyer, and I am the Program Manager for the Baltimore office of America Works of Maryland. Thank you so much for allowing me to testify today. I oversee 5 of our programs, including our reentry and our bail diversion programs, as well as our SNAP, Ticket to Work, and out-of-school youth programs. Our focus is to work with Baltimore's marginalized communities through workforce development programs to help them overcome the need for government assistance. Specifically, we want to help our customers find sustainable employment so that they can become self-sufficient members of the community. As Marcia stated, our reentry program has been in existence for over 10 years, and that's thanks to the funding by the ABLE Foundation. Throughout the past 10 years, we've had 1,654 customers complete employability and career plans, and of those, 1,069 have found sustainable employment. This is a 65% success rate. We've also always seen lower recidivism rates than the Maryland average, as low as a 40% difference. So the bottom line is our program is working. Our program works with recently released individuals to create a plan to avoid recidivism. Plans include building a resume, offering life skills and pre-employment training, and most importantly, introductions to employers looking for people with their skill sets. Many of our partner employers are background friendly and share the same ideals as America Works. Our customers are prepared for the interview process, and connections are then made to those employers. We also provide connections to various partner resources, including mental health, temporary food assistance, clothing, transportation, and shelter. Working on the ground level with our reentry population has shown me that many of these individuals have never had the support needed to thrive in our city. Providing them opportunities they've never had allows them to feel like they finally have a fighting chance to make something of themselves. Our customers often also refer people they know to our programs to receive the same services. So in conclusion, I urge you to support HB 1022. Thank you.
All right, now we're going to turn to a few of our online witnesses, starting with State's Attorney Braveboy.
Thank you so much, Mr. Chair and members of the committee. For the record, I'm State's Attorney Aisha Braveboy, and I'm here today to express my support for House Bill 1022. The bill establishes statutory requirements for an appropriation of $4 million in the state's annual budget to fund post-conviction readiness programs in 4 counties, and Prince George's County is included in that. So we are very excited and very interested in this particular piece of legislation. This bill would allow employed Prince George's to further collaborate with my office and other agencies to address ongoing concerns of crime and recidivism in the county and around, of course, the state of Maryland. Various studies have shown risk for recidivism in Maryland is highest in the first 3 to 5 years following incarceration. And so we believe that ensuring that those who are incarcerated have the ability to earn skills and are able to be in the employment market successfully would certainly cut down on recidivism and give them a real opportunity to contribute to our communities. The Prison Policy Institute reported that Maryland prisons release about 7,408 inmates yearly, and unemployment among those formerly incarcerated is nearly 5 times higher than the unemployment rate in general around the country. And further, the number of ex-offenders reentering society currently substantially exceeds the current availability of resources in our communities. And so there are links between, poverty and crime, and we all know about that, so I'm not going to go through that. But I will say that this bill will go a long way to assisting us in other communities to reduce recidivism and strengthen our communities. Thank you very much.
All right, so we're going to take a couple more online witnesses, and then we'll run to questions. Kimberly Haven and then Timothy Hatchett.
Good afternoon, Mr. Vice Chair, members of the committee. My name is Kimberly Haven, and I want to thank Delegate Young for bringing this legislation to the forefront. He and I have worked on this issue for many years. We have looked at other programs that might be implemented, other options, and honestly, I love coming to this committee and saying this is just good policy, and that's what this is. Formerly incarcerated people want to work. They're denied the opportunity to work. And when they come home, that patchwork of support services that they've put together for themselves is full of holes. You can't get a house if you don't have a job. Can't get a job if you're worried about where you're going to lay your head. And employers are reticent to hire formerly incarcerated people because they don't understand the value of and the importance of this virtual untapped workforce. But people like me who've been incarcerated want to work. And unfortunately, these critical reentry services are fragmented, they're generally incomprehensive, and they're confined to one particular county. Prince George's County is amazing in the work that they're doing, but we have 23 other jurisdictions that could also be doing equally amazing work. As a result, these individuals, such as myself, have a difficult time navigating a return to the workforce, or in some cases, entering the workforce of legitimate opportunity for the very first time. And this leaves individuals and their families dependent on social service systems as they try to meet the requirements of their release, and then they are denied the opportunity to access the financial stability to move past incarceration. We know that healthy, engaged, and employed individuals create healthy communities. This legislation is a major step in the right direction to improve the financial stability of individuals returning to our communities and their families. As a formerly incarcerated person, this is good policy. And if we as a state are committed to our goals of rehabilitation and reentry, HB 1022 is a move in the right direction. Thank you.
All right, we have a few questions. Delegate Taylor, Pasteur, and Kaufman in that order. And since we got a few folks, if you can try and direct the question at someone, that'd be appreciated.
Okay. Thank you, Chair, and it's really good to see Mr. Simmons here. Question, I know that these programs are targeted to post-release. Are there any plans for these types of programs to start prior to release in order to prepare our returning citizens?
Well, first, happy birthday, Delegate Taylor.
Thank you.
I think this is an opportunity to create a foundation for these programs, and then to allow us to take other funding to then offer the pre-release services. Right now, as somebody mentioned, they're fragmented. We don't have funding. We try to do what we can. This is for Maryland to create that foundation, to leverage that, and then build comprehensive programs where we have a structure where our Department of Corrections can then allow the 24 jurisdictions to come in and provide that support. So I think this is the steps to go towards that direction.
Awesome. Thank you,
If I could, Mr. Chair, just to advise the delegate, in Prince George's County, we actually have a relationship with the Department of Public Safety and Correctional Services, where we have an emerging adults program designed for individuals who were incarcerated between the ages of 18 and 26. We are currently virtually providing them with mentoring services, and we have a follow-up mentoring program once they are released. So we start with them while they're in, helping them build a life plan for when they are released. And these funds would really help us because a lot of those individuals need support when they return, but they already have a plan. So we're helping them develop that plan right now while they're in, so that when they are released, they can implement that plan. And the Department of Corrections, the local Department of Corrections, has recently reached out to us because they would like to implement a similar program locally. So yes, Walter, that's something we'll talk to you about soon, but we do have a foundation for that already. Thank you.
Thank you.
And Delegate Birthday Girl Taylor, I think the folks from Montgomery County are going to come up on the next panel, and they're going to speak to something that they may have similar.
Delegate Pastor, when you're ready.
Thank you, Mr. Chair. Thank you for this sort of bill. Thank you, Delegate Young. Certainly is more than needed.
Yes, ma'am.
It's absolutely essential on many levels. So my question is, I think you mentioned something about amendments or an amendment to take it from a state, is that what you said, from a state level and focus first initially on this local using the services rendered by the people who you're witnessing?
That's correct. Right now, as drafted, it was drafted as the state would create the program and would do it that way. But after engaging with these practitioners, it was clear to me that a better approach would be to instead empower them. They are already working in many respects. America Works already works with the communities. They just need support from the state. Employee Prince George's and the folks from Montgomery County and the folks in Baltimore City at the Mayor's Office of Employment Development, they already are doing this employment development, work readiness type of work. So instead of reinventing the wheel, it just makes more sense to empower the people that are doing the work. So that but really, again, at this point, targeting those resources, though, to this particular population. And right now, only America Works is the folks who really are doing that on a regular basis, or rather at scale, I should say.
Okay, what do you mean when you say this population? You're talking about focusing on America?
Folks who are returning home from imprisonment.
Conviction.
Okay. So are you talking about doing it in an area? When you said area, you mean post-conviction or post-prison? Is that what you're talking
That's correct.
about when you say area?
On reentry.
Reentry. Okay. All right. So I misunderstood that. Okay. So reentry. I've heard you have somebody from Prince George's County. You have someone coming up from Montgomery County.
That's correct.
Would you be able, I guess I'm directing this to anyone from your panel, would you be able to spread this out and work this out so that it would be as workable as it sounds like it already is in some areas, maybe the city, a couple of counties? Would you be able to do that, though, at the end, if this bill is passed for all of the areas in Maryland?
Yeah,
How would that work?
the way the amendment would work is that the funding would be available for all of the folks in any of the areas across the state that are already doing this work. Certainly, though, if the resources are available and appropriated, there would be no limitation, of course, to how far we would want to expand it.
So it's where the work sort of exists now.
Currently,
and how
right.
you can support them.
Right.
So would this bill, or is that another bill, include some sort around the state, if it's a state and you want to be able to help people around the state, and of course the differences, there'll be a lot of differences because the counties are different, et cetera. Would there be something infused in this that's like a needs assessment? So while this is going on in the places where you have some of the services, you can assess what is going on in other counties to see what their needs are and how it would be different, or is that something separate?
I'm gonna kick it over to him, but I would just say real quick though, I would welcome a friendly amendment that would restrict anybody who receives these funds from prohibiting someone not from a jurisdiction as long as they are from Maryland. Like if somebody from Charles County and maybe Charles County doesn't have it, had to come to Prince George's, I would welcome an amendment that would say that they would have to accept those people too.
I'm even thinking though about how you spread it out. You asking for the money, how you spread it so there's one in St. Mary's or wherever
Sure.
as it goes. Please.
So the bill states at least four jurisdictions. What we say from operating at a local level, you have America Works, you have your 13 local workforce boards that represent all 24 jurisdictions. This is an opportunity for the Maryland Department of Labor to identify a format to get those funds out to the community, but those that are applying are demonstrating the need, are demonstrating the work they are doing, and demonstrating that they can deliver the outcomes that are intended in the legislation and as managed through the Department of Labor. So it's creating a statewide administrative program, but instead of the administration being duplicative to what America Works and the 13 boards are already doing, it's getting them to administer it through the local area. And it says at least 4. So I know from our end, we would look at replicating replicating the best practices, where America Works is doing in Baltimore, what we're doing in Prince George, what's happening in Montgomery. But what does that look like in Anne Arundel, in the Lower Shore, the Upper Shore? That makes sense, that leverages the community resources, but still delivers the outcomes from the intended legislation that Delegate Young has proposed.
Thank you.
Thank you for your question.
Delegates Kaufman and then Conaway.
Thank you, Mr. Vice Chair. I appreciate it. First of all, Delegate Young, thank you for bringing this bill and all of your wonderful bills that you've brought forth today. I have 2 questions. One question is for you. You mentioned budget challenges, and you asked for an appropriation of $4 million. Do you have your heart set on that, or would you, if necessary, settle for less? And then secondly, and in the interest of time, per the Vice Chair's admonition, maybe just one of you could answer this, but you can choose who you want to answer it. Do any of you have data that your programs for returning citizens, in fact, result in less recidivism? Thanks.
So let me just say, I know they have an answer to that second one. We'll take whatever money we can get, but we also want enough money that they can do the work effectively.
Okay, thank you. And does anybody want to comment about
Sure,
it?
I'm happy to do that, especially since we've been operating this program in Baltimore City for some time. I will tell you that we have over 1,900 people that have been enrolled in our program during that period with an 86% graduation rate. But I think what's even more important is that once individuals are going to work, at least by 70, a little over 70% are staying employed for over 180 days. So the program is working. Again, individuals just needed that second chance to be able to prove they can do that.
Congratulations.
Thank you
Mr.
so
Vice
much.
Chair.
Appreciate it.
Thank you, Mr. Chair. Thank you, Delegate and panel, for coming in to testify. I think it's Mr. Simmons. Is that correct? I've heard this statement before, and I was wondering, can you tell me where it's from? And the reason why I was interested in it is because I've been told that there's a certain type of game that used to be played in Baltimore City called a bookings game, where you get a visit down to central booking over the weekend and then not get charged. So you said 1 night incarceration, you will have a lifetime of stress. I've been looking for a while and today to find out where is that quote from, and I was wondering, could you help me?
Can't give you the quote. It's more related to the studies on the mental health concerns. I could provide, through the necessary means, provide that follow-up on what the mental health impacts of incarceration looks like. But I can tell you this: we have done this work along with America Works for a substantial amount of time. We've seen people that we've worked with day in and day out, coaching, getting trained. The day of the job fair, they show up and you can tell they're a wreck. And that mental health of having to explain what's on the record, the explain the 10-year gap or explain anything, that's the mental health stress that relates to. And that's something that we have personally seen the stress behind that. But we can definitely find the studies that demonstrate the mental health impacts on from incarceration.
If you can find that, please send it to me. Thank you.
All right, thank you very much. We have a few more folks signed up, so we're going to take another panel or two. Matthew Boley, Wesley Collins online, Cecilia Yost, Natasha Kalfani, Grayson Wiggins, Christopher Dews, Adrian Featherstone. All right, whenever you're ready.
Good afternoon, Mr. Vice Chair, members of the committee.
Matthew Boley of Rifkin Wiener Livingston, here in support of this legislation on behalf of America Works. I'll be very brief, looking forward to working with this committee and the Appropriations Committee on this very important legislation. Glad to answer any questions.
Yes, good afternoon, Vice Chairman and committee members. My name is Cecilia Yost. I currently work at America Works of Maryland in downtown Baltimore as a fellow with the Workforce Foundation, which is a research extension of America Works. I wanted to also keep my testimony brief, as previous testimony pretty much articulated what I wanted to express, but I wanted to get more into the specifics of our Baltimore Ex-Offender Reentry Program. Essentially, participants in our program must live in Baltimore City and have been incarcerated for 1 year. Upon enrolling, they indicate any immediate needs they have, such as referrals to mental health providers, professional interview attire, and we work to resolve those issues. Along with this, clients receive an updated resume and meet one-on-one with a member of our career coaches or sales representatives. In addition to job placement services, America Works offers virtual and in-person trainings 3 days out of the week. These cover both soft and hard skills. We also provide vouchers to clients who are looking to obtain an industry-recognized certification to make them a more competitive candidate. Due to our long-standing relationship in the Baltimore metropolitan area, we have developed many partnerships with background-friendly employers representing a range of industries. Both our partner employers and America Works fervently believe that post-release employment support is absolutely crucial to lowering short-term and long-term recidivism rates. Given that retaining a job can be contingent on stable housing, affordable childcare, and a multitude of other factors, our regional offices have instituted biannual resource fairs where our community partners share their services with our clients. Lastly, I'm urging support of this House Bill 1022. Voting in favor of this bill will ensure that more of Maryland's returning citizens are equipped with the skills and opportunities to re-enter the workforce in a full-time capacity, ultimately lowering recidivism rates. Thank you so much for your time.
Good afternoon to the committee. My name is Anthony Featherstone, and I serve as the Executive Director for WorkSource Montgomery and Montgomery County's local Workforce Development Board. I'm here in support of House Bill 1022. In Montgomery County, we operate a dual-track reentry program which consists of facility-based and community-based employment services. It's widely known that employment is a critical factor in decreasing the likelihood of someone reoffending. However, gaining employment for someone who has been justice impacted is not always simple. It's not simple because there are a number of employment-related challenges individuals face post-conviction, from the need to secure the basics, like food security, housing, transportation, and childcare, and healthcare, to the challenge of understanding where they fit in an evolved labor market. Those who are justice impacted must overcome a great number of barriers to employment. These barriers sometimes cause a level of instability, which can lead to an individual recidivating. This is why workforce development funding to support individuals post-conviction is critical to reducing recidivism, strengthening families and communities, and our economy. The programs this bill would fund will help expand sector-based job training and transitional employment programs. The employment supports these programs provide for those with convictions help to stabilize personal infrastructures, assist in accessing quality academic and occupational skills training programs, develop professional skills, and achieve economic mobility through employment and career pathways. Additionally, evidence also shows that providing this type of service pre-release is a best practice in serving those who are justice impacted. And like other areas, Montgomery County's correctional facility provides many of the services I've mentioned through our on-site job center. In closing, I hope the committee looks upon this bill favorably, as it will help a lot of Marylanders who've been justice impacted. Thank you for your time.
Good afternoon, Vice Chair Moon and members of the committee. My name is Natasha Calfany. I am the Acting Assistant Director of Government Relations for the Office of the Public Defender. And on behalf of the Office of the Public Defender, I am requesting a favorable report for HB 1022. Formerly incarcerated people need employment for the same reasons we all do: to meet their basic needs, provide for their families, have positive self-identity and self-esteem, as well as accomplishing goals, to name a few. According to a report from the Prison Policy Initiative, Formerly incarcerated people want to work but face barriers to employment, specifically in the period immediately after incarceration. While many of those barriers, like discrimination, lack of opportunity, and criminal background check policies, are structural and institutional, some of the more interpersonal barriers can be alleviated by work readiness programs. Work readiness can help formerly incarcerated people increase educational attainment, update insufficient or outdated job skills, provide work experience to supplement a lack of or inconsistent work history, and improve on soft skills, to name a few. Work readiness does work, and it is important to note the programs that are formed to have the highest levels of success are those that engage people prior to release and allow for immediate work opportunities after release. We think this bill can lay the groundwork for this to happen. It is also important to note that higher quality and higher paying jobs have the biggest impact on the decrease of recidivism. This bill has the potential to do this as well in the selection of employers. While work readiness is only one piece of the larger puzzle in allowing for formerly incarcerated people to return to their families and communities and be successful, it is an important part. And for these reasons, the OPD asks for a favorable report.
Looks like we got Timothy Hatchett online.
Yes, good afternoon. My name is Timothy Hatchett, and I'm elated to offer my written support to American Works of Maryland Incorporation, which I believe is deeply needed for returning citizens of Maryland. After serving 31 years in prison, I just been home since January 9th, 2022, and I was released to the Gardenzia program. It's an addiction program treatment facility. When I enrolled in it, I became aware of American Works, that they offer jobs to people that come home recently incarcerated. Since being home, I came to American Works. They did a wonderful resume for me, and upon them doing a resume and helping me be job ready, I was given my first job ever. I wasn't allowed to do it because the hours didn't coincide with Gardenzia. I was given a second job through American Works. I wasn't able to do it because of the Gardenzia program. I vowed and I made a promise that once I released from the Gardenzia program, I will come back to American Works. I've been back down to American Works since then. On August the 26th, 2022, that's my first job I ever had in my life. I was happy. The program worked. I don't care what nobody say. The program had to stay. This is my first job ever. In 31 years, I've been in prison. I went to prison when I was 21, and it hurted me. But now that I'm home, I'm happy. This program really works, and I'm just asking that please keep the program because it really helps people that come home like me. At 21, I went to prison. I ain't come home till I was 53. It works. And I just ask that y'all please just support the bill and let the program continue. American Works, it really works for the people that, it's not just for people that was recently incarcerated that came home. It's for people that was already on the street that might have been looking for a job. They did a wonderful resume on me for somebody that never had a job. I just thank y'all, for giving me the opportunity to say how I've been doing. I've been working since the 26th of August. I'm still working as a forklift driver. I love my job. I have 2 cars, a truck and a car, and I'm just looking for another job, a part-time job. I don't want another full-time because it's going to hurt me. But another part-time job, that's what I'm looking for. And I'm asking that y'all please allow the program to continue. Thank y'all.
All right, thank you for sharing your story. Did Grayson Wiggins, did you want to?
Me too, Mr. Chair. Thank you. Y'all hear enough from me.
I think that might be it for this panel, and I don't see any other questions. So thank you very much, everybody. I don't see anyone signed up in opposition. Thank you to our friends from the Appropriations Committee. That's going to end the hearing on House Bill 1022. We are going to go to a pair of bills from Delegate Attar, starting with 856. And you have, I think it's just you, right?
Yes,
Okay,
everything else
great.
was written and it was submitted already. Thank you, Mr. Chair and members. For the record, I'm Delegate Dahlia Attar presenting House Bill 856, Correctional Services Baltimore City Convicted Gun Offenders Pilot Program. The goal of this bill is to ensure those convicted of gun offenses are appropriately supervised and provided resources to ensure they do not reoffend. This bill establishes the Baltimore City Convicted Gun Offenders Pilot Program, which is to be implemented and administered by the Division of Parole and Probation. It requires the department to provide convicted gun offenders with individualized case treatment plans, specialized guidance and supervision, and rehabilitation services. A court may order an individual to participate in the program as a condition of probation, and a violation of a court order to participate in the program is a violation of that probation. And the department must also submit an annual report on the program, giving us updates to see if it works, because this is a pilot program and it's only for Baltimore City. I have spoken with the department about this bill, and they requested 2 amendments. One clarifies that this bill is for offenders who are supervised in Baltimore City, and the second clarifies that this is to be implemented by the Division of Parole and Probation and not corrections. These are friendly amendments, and this bill passed with these amendments in the Baltimore City House delegation unanimously, and I ask for a favorable report. Thank you.
All right, I don't see any questions, and I do see a delegation letter in the file here. We do have one person signed up unfavorable, Alicia Capizzello. Okay, great.
Good afternoon, Mr. Vice Chair, members of the committee. My name is Alicia Capizzello. I have been a proud resident of Baltimore City for many years. I also am Deputy Public Defender for Baltimore City. The Maryland Office of the Public Defender urges this committee to issue an unfavorable report on House Bill 856. This bill is based on a flawed premise that additional onerous probation and parole requirements for gun offenses reduces gun violence. There is no sound evidence to support this premise. However, there are community-based programs that do not rely upon probation and parole that have been studied and actually do reduce gun violence. Greater investments should be made in these programs, not this bill. Additionally, under existing Maryland statutory law, the Division of Probation and Parole already is charged with developing an individualized case plan for each person under its supervision, assessing their risks and needs as an individual, with the stated goal of reducing recidivism. In short, this bill is unnecessary. Worse than unnecessary, House Bill 856 is harmful because it will fuel over-incarceration, and the bill is intentional about this. House Bill 856 is explicit that failure to comply with this unproven, very loosely defined program is a violation of probation for which a person may be incarcerated and in many cases re-incarcerated. House Bill 856 is an ill-conceived response to a problem that demands a careful, detailed, evidence-driven response, and the Maryland Office of the Public Defender again urges the committee to issue an unfavorable report. Thank you.
All right, I don't see any questions here either. Thank you very much. We do have one informational witness signed up, Jason Billingsley. No? Okay, I think that's it. That's going to end the hearing on House Bill 856. Let's go to House Bill 854. You have Jason Billingsley, is this right? Mark Panak? Do you have a panel on this?
Mr. Dews is on my panel. I
Okay.
don't see him in here, and I'll tell you. And I believe someone from Out for Justice. I'm not sure who in the end was going to be here for that.
Jason, yeah, the only other folks we have signed up, Jason Billingsley, Mark Panak, Christopher Dews, and then one FWA and one unfavorable. All right, so whenever you're ready.
Thank you, Mr. Chair and members of the committee. For the record, I'm Delegate Dahlia Attar, presenting House Bill 854, Revisions to Expungement of Records. Several months ago, a constituent reached out to me with concerns about expunged records still being used against people. For example, expunged convictions are being used against people many years later, sometimes when applying for jobs, other times when applying for security license, and there are many other examples they've listed. I spoke with DLS about this, who advised me that the current statute does allow for this to happen as it is written. I'm here before you with this bill because if we are allowing people to expunge certain convictions from their records, we are doing so because we believe the conviction should not be used against them and negatively affect the rest of their lives. We are giving them a second chance. So we must clarify this statute to ensure that this does not happen. If we're giving them a second chance, we should be giving them a true second chance. To be clear, this bill does not change a person's eligibility to file a petition for expungement. It only changes what happens after an expungement is granted. It ensures a person's expunged record is no longer used against them, and I ask for a favorable report. Thank you.
Thank you, Mr. Vice Chair. Mark Pennock, President of Maryland Show Issue. We wholeheartedly support this bill. Right now, the state police are using this expungement provision to say that the expungements are simply not effective with respect to granting permits, HQL licenses, and indeed buying or purchasing a regulated firearm. So basically, the expungement, instead of giving the effect right in the statutory language of Maryland law, it says that expunged conviction is no longer a firearms disqualifier. Full stop. And yet the state police are still using as a firearms disqualifier, relying on advice from the FBI and the ATF. I have their letters. And that's just going to earn the state police a whole lot of lawsuits, which we really don't want to bring. So we urge that this problem can be fixed and should be fixed right away, because this is basically a misuse of the expungement statute to allow this to continue. And it's a matter of some urgency, and I hope the committee gives it that priority. I'll be happy to answer any questions.
Delegate Erican.
Thank you, Mr. Chair. Thank you guys both for being here. I'm confused. How does the state police have access to expunged records? Because the idea, I guess, behind it is that it does a clean slate. So how are they still seeing the charges when they've been expunged?
So I don't know exactly how state police sees it. He mentioned that aspect of it, but when records are being expunged, they're being kept somewhere, and they're not. That's why I brought this bill, because they're not actually gone forever. So it's being used against them sometimes with job applications, with, like he mentioned, with permits, because it's still there. So the intention of this bill is to make sure it's gone, destroy the records. If something's expunged, it's gone. But currently, that's not what's happening.
So is it like a digital database somewhere that
I actually believe like there's a storage room that the original statute references. I don't know exactly how they're getting it. I have no idea how MSP in specific is getting it.
Wow.
He mentioned.
So if I may respond to that, in applications for permits, state police typically will ask, have you ever been arrested? And since the application is under oath, the advice is to people to disclose their arrests, and they typically will attach to their applications expungement records. And that puts the state police on notice through that means alone that these people have, in fact, have expunged possibly disqualifying crimes.
Okay, so they're self-admitting to it.
Yes, because the state police are asking for it.
Okay, and they aren't supposed to be.
They're not supposed to. Well, they're allowed to ask a great deal. People are being honest and showing that, yes, I committed this crime 20 years ago. I have since had it expunged. And yes, it should be no longer the effect, but the state police are still giving it effect.
So how will we get that message out if this bill should pass?
This bill should pass, should remedy the reliance on by the FBI on their view of what the effect of Maryland's expungement is, because it addresses their concern in a case called XREL Crank versus ATF. It's in my written testimony. They're applying the test used in that 10th Circuit case to say that Maryland's expungements don't meet that test. We think that's wrong, but it is the FBI's position that Maryland's expungements don't meet that test. And that's what the state police are relying on. to the extent that they're going back and revoking existing permits, existing HQLs, and indeed placing at peril these people for arrest and prosecution. Because if that is the right standard, that's how they remain a disqualified person, notwithstanding existing Maryland law that says they're not.
Wow. Okay. Thank you. Thank you both.
Mr. Chair, Chris Dews is in another hearing, but we do have a representative from Alper Justice if she can testify. I believe Jason Billingsley is signed up, but did he sign? I think he signed up.
All right, 2 minutes. Let's go quickly.
Thank you, Mr. Chair. Nicole Hanson Mundell, Executive Director of Out for Justice. We are in full support of this bill, given all of the years, and I think the Vice Chair can attest to the years of work on legislation around expungement and pushing for access to expungement. Okay. As a formerly incarcerated woman, when I am able to get my record expunged, I not only want the record expunged from the court, from the police department, but I also don't want it out in the universe, right? I want to be able to live my life as a free woman, clear from anybody having access to my criminal record, especially when this body and over the years have ensured that eligible offenses have access to expungement. And that is the sentiment for all formerly incarcerated people. When we're able to get our records expunged, we don't want the banking industry or the mortgage industry or auto insurance or landlords or any type of people, housing access. We don't want that access to our record, Mr. Chair. The delegate asked about how we get the message out. Well, Out for Justice has a history over the last 10 years of getting the message out, right? And so you can rest assured you have the offices of public defender who supports these particular clients, will likely be telling their clients the type of access. You have advocacy organizations all across the state who have budgets to get the message out, especially once we pass legislation. We will be sure to send out the action alerts and make this implementation of this law a priority.
All right, thank you very much. I don't see any other questions. So we do have one favorable with amendment, Miles Spires. I don't know if you're here. All right, I don't see Miles Spires. And then we've got one opposed, John Cox. Yes, okay.
Mr. Vice Chair, members of the Judiciary Committee, I'm John Cox, Deputy State's Attorney for Baltimore County, and speaking on behalf of the Maryland State's Attorneys Association, opposed to House Bill 854. And the reason for that is the picture that we're not looking at here. And that is, I can give you a number of examples, but this bill would basically require obliteration. It would also not permit investigatory files to be maintained or even notes of police officers in a particular case. So I give you an example. An individual is charged with a crime. We decide that there's just not enough evidence to go forward against them with the evidence that we had available at that time, so we null process the case. And then then he applies for an expungement and gets everything obliterated. And then further evidence develops that he did in fact commit the crime. Maybe his wife comes forward and says, he confessed to me that he did it. All the records have now been destroyed. So that obviously greatly affects our ability to go forward. Another example is somebody, there's not enough evidence in a case, and he gets something expunged, and then the exact same type of crime is happening. And the police can't even go back to look at any or find any reports of what has happened in that prior incident because it's all been expunged. My best example, and the dilemma that it's going to create for a prosecutor is, let's say somebody's charged with a crime, either is acquitted or we develop evidence that they didn't do it. The victim has identified them as the person that did it. And then sometime later, we develop another individual and then charge that individual. If the first person has had those records expunged, what do I do with my ethical dilemma? I then, when I'm prosecuting the second person, have a duty to disclose all exculpatory evidence to the attorney for that person. And I can't tell them that the victim has identified somebody else who's committed the crime because everything has been expunged. This will hamper both our ethical responsibilities and the efforts of law enforcement to continue to enforce crime.
Delegate Cardin and Conaway.
Expunge, I mean, as the proponents are saying, the idea behind expunging, which, I mean, and the state's attorney's offices have been in favor of certain expungements when they're appropriate, is that that record should, or that information should never be able to be used to hinder this person's forward-moving progress in life. But you're giving us specific examples of how you need to make sure that it does exactly that. So I'm wondering philosophically if there's any way for the state attorney's office to understand that you're in a complete cognitive dissonance here.
Oh, I understand. And that's been the battle that I've had, and every time I've come in here in the expungement bills, in the difference between the interests of law enforcement and justice and all of the other unfortunate collateral consequences of the lack of an expungement in other circumstances, getting a job, licenses, everything along those lines. And I'm not here to advocate against that. The concern here is for law enforcement.
Thank you, Mr. Chair. Thank you, Mr. Cox, for coming in to testify. So in your wonderful testimony, you were talking about the expungement process, but you didn't explain how long it is that a person has to wait between the time that they are officially charged before they can have their record expunged. You made it seem as though they get charged today, nothing really happens within 2 months or 3 months, and they go get it expunged. Can you comment a little bit more on the time frame?
Well, there's some automatic and immediate expungement. It depends on the category. If you've got a non-conviction and you choose to, at least right now, and there's other legislation trying to change that, if you choose to sign a waiver of any liability, you can get something expunged immediately. So if there was a null pros today...
And the null pros comes from who?
From the state's attorney.
Oh, okay. Go ahead.
So if the state's attorney null process a case, the individual could go in that same day or the next day and apply for an expungement as long as they sign a waiver of liability.
Waiver of liability means that the person won't what? Sue you?
Exactly. Well, sue the person who charged you, whatever. I don't know who they would sue, but yes.
Sue somebody.
Yes.
Okay. So you think that you should be able to have a bite at the apple, as they say, I guess, and charge a person and say, well, we're going to null process that, and that should just stay on a person's record for what, 4 years, 5 years, 6 years, 10 years maybe?
Well, honestly, the null process or the existing charge, the court record, is not something that I'm concerned about.
Okay.
It's more the investigatory records. For the information that the police have, if they're going to either develop further evidence against that person for that same crime, when they've now been hampered and lost that, had everything expunged from them, or if I have, as I gave with the dilemma, I have a need to disclose that information to the next person that gets charged.
Right, or let's say a person wants to apply for a firearm 10 years after they were charged and it was null processed. So now they might not be able to get the firearm because they have this null process charge or several of them on their record. Is that what you're saying?
Well, actually, I don't know the answer to that one. It's kind of related to Delegate Erican's question. I don't know how they're getting that, but I don't profess to have.
No, what you would be in favor, if they do get do get that information, you're in favor of them getting that information and that being a disqualifier. Is that what you're saying?
No, I'm not. No, my concern is law enforcement.
Right, I'm talking about law enforcement.
Okay.
So if it's 10 years later and you have 3 or 4 null processes or stats or whatever on your record, and it's been the case can't be seen by the public on case search or whatever, but you apply for a firearm and there it is somewhere out there in this registry that we're talking about. You think that's fair?
I don't, no, I don't. That's not my concern. Honestly, I don't mean that to sound glib, but mine is more towards the investigation of crimes.
Okay.
Not permits or licenses.
Okay, not a person's constitutional right to bear arms.
Correct.
Right, okay, thank you.
All right, Delegate Phillips.
All right, I got a few questions. One is just educating me, right? I don't do criminal law. So what is the actual theory behind the waiver of liability if someone were to have a null process and they want to have their they want to have their record expunged immediately? And I've heard this often. They could do it immediately, but they have to waive their rights. Why?
And I didn't, this is well before my time, and honestly, it's not my concern because I'm more on the prosecution side. My understanding of the rationale was that if somebody had something null or expunged right away and then turned around a year later and sued, let's say the police department, for a wrongful arrest, the police department wouldn't have the ability to defend themselves because the records have been expunged. And so they would need that opportunity. The current statute allows for an expunged record actually to be resurrected if a court directs that it happen. That could be one of the rationales for that.
Okay. So whatever was decided on that one a long time ago may not really apply because we can go back and get those records today.
Well, there's actually other pending legislation, I think, that calls for the records to be literally sequestered for a period of 3 years, such that you could that possibility or that circumstance can be resolved.
Okay. So we've been hearing a lot about expungements. And one of the concerns, of course, that are raised by gun rights advocates is that, as was stated, the FBI is viewing this in a certain way, and we view our expungement laws in a different way. How do we square that with the idea that I believe collectively the general sense in this body is that we don't, once a person is expunged, we want them to have access to housing, to finances, to jobs, et cetera, right? So how do you square your position with a general desire to make sure people are not, for the rest of their lives, with the scarlet letter?
And my only concern here today is the obliteration of the record. And
but it impacts this other side. And so I'm just asking you to help me square it.
And I wish I could. I sat here a week ago and listened to some people, because when I was sitting there and somebody said, well, does this affect somebody's ability to apply for a license for a handgun? I sat back there and said, no, because nobody can get it because it's expunged. And then listened to two people whose opinions I respect say that's not true. And so that's not something that I knew. I had no idea that there was this access, but I don't doubt that it's the truth, because people have come up here and said it who know that. It's not my field. So I wouldn't be able to directly address that for you. I agree that that's not something that should be a collateral consequence of this. As I said, my concern is the ability to enforce the laws.
That presents a challenge for us.
It does.
All right, thank you.
All right, looks like, Delegate Erican.
Mr. Chair, thank you so much. Okay, so I think I understand better what your concerns are. Perhaps, and you can just say yes, I guess, we need to have the state police come in here and tell us what the heck they're doing. What do you think?
Have you ever heard a lawyer just say yes?
I have not.
I'm going to do it.
I'd give it a shot. You
I'm
are?
going to do it,
Oh
yes.
my gosh. Okay, good. So maybe that's who we'll call in and figure out how on earth they're able to still be doing this to people, even though they clearly don't have the legislative authority to do it.
All right, thank you very much.
Thank you.
All right, I'm going to take a risk here, guys, and attempt to slot and Delegate Attar, is that it for you? I think it is. Good night. Oh wait, we got one more. Sorry, we got one more witness online. Sorry. Miles Byers. Was this the favorable with amendment? All right, whenever you're ready. You got to unmute yourself.
Thank you so much for your commitment to provide the opportunities for new beginnings through expungement efforts. Such efforts allow our communities to flourish and families the opportunity to expand their economic profiles without the hindrance of forgivable past. I'm the executive director of Dalton Daly Group, a Prince George's County-based nonprofit organization focused on improving the lives of children, families, and communities. To further our efforts to prevent recidivism, we are assisting individuals with expungement efforts. However, we have noticed significant areas that belie the notion of having one's record expunged, including mandated reports to the Governor, Attorney General, the General Assembly, and the mandate in that case is not to be published, not necessarily that it has to be published to the public, and financial auditing reporting. In the day of the internet, public access to and existence of information in these types of records nullify the effect of expungement. Currently, such records are easily and publicly accessible through simple internet searches of the expungee's name because the aforementioned vehicles are not considered records. Rather, they are distinguished as being akin to unreported opinions as issued by the Court of Appeals. Hence, they are publicly accessible through a simple Google search of an individual who thinks that their record has been expunged. You can only imagine the dismay that causes when somebody finds out they can't get employment because, in fact, it is just readily available of a conviction that has been expunged. We do support the bill and hope that the true intent does go forth by closing these reporting type of loopholes. Thank you again for your time and consideration.
All right, I don't see any questions, so now we'll end the hearing. Thank you very much for your testimony. Okay, so before we jump to these the city delegation bill and Delegate Smith's bill, which have a number of people signed up, I'm going to attempt to knock Delegate Frazier Hidalgo's bill out, 996. He's the only person signed up, so I hope this is quick. Delegate Frazier Hidalgo, 3 minutes. 3 minutes. In and out.
Quick.
In and out. No questions.
Okay. All right. Thank you very much, Judiciary, for allowing me to be here to present House Bill 996, Artificial Intelligence Implementation. So this bill is affectionately known in the lobbying community as the Terminator Bill. And essentially, most of you probably have some idea what artificial intelligence is. And we're to the point in time now, technologically, where hardware and software are catching up to each other, and they're being put in a situation where artificial intelligence, or AI, is getting to the point where it is writing poems for people, it is writing papers for people, you're seeing video that's been done by AI for people, and it's starting to get really hard to distinguish what's real and what's not. Most of you know this, right? This is what's happening. Now, what's scary to me is the next phase of this is when you take all of that software and you put it into a robot. And I know some people are kind of laughing, but it's here. Let me assure you it's here. Tesla right now has a robot that they have been working on for about 1.5 years, and about 6 or 8 months ago, they had their early beta release, and it can walk around this room by itself. It can pick up a drill gun. It can drill things. It can do things. Those are going to be in your homes at some point in the future. Now, yep, I heard that, and it's coming. It's coming, Mr. Vice Chair. It's coming. So with that said, what this bill does is it's really, really, really a simple bill. You know, you've all heard that, but it is. It basically says if you're a programmer, right, and you're writing AI or you're writing a program, and that program ends up hurting or killing somebody intentionally, then you're liable, just like you are both civilly and criminally. So if you upload some AI into a robot, and then the robot, for whatever reason, thinks that it's squeezing an orange, but really it's like squeezing your neck or whatever it might be, then that programmer is responsible. Now, I know that you may think this is insane, but may I remind you that growing up with Star Trek in the 1960s and 70s, this does more than that communicator ever did. May I also remind you that this currently, and for the last 8 or 10 years, has done more than all the computing power on all the space shuttles. So we're here. We are not the only ones doing this. AI bills and resolutions have been introduced in at least 17 states in 2022, and several have been enacted already in Colorado, Illinois, Vermont, and Washington. And part of this, just going back historically speaking, for those nerds out there, Isaac Asimov, I don't know if anybody knows who that is, but he was a sci-fi writer back in the 40s and 50s. And in 1942, he wrote the 3 laws of robotics. And if anybody, is that all I get is 2 minutes? 3 minutes. Okay, well, the 3 laws of robotics. Number 1, a robot may not injure a human being or through inaction allow a human being to come to harm. Number 2, a robot must obey the orders given to it by human beings, except where orders would conflict with the first law. And the third and final law, a robot must protect its own existence as long as such protection does not conflict with the first or second law. With that said, if there are questions, I'm happy to take them. If not, I'm happy to leave you.
All right, the Skynet bill, Delegate Grammer and
Skynet
then
bill.
Williams.
Thank you. So it kind of feels like we're going to be drawing up bills on this for the next 15 years. Has any state adopted any similar bill or any language along tort lines in any state at all?
So my understanding is that Colorado, Illinois, Vermont, and Washington have already done something similar to this. I don't know the exact details, Delegate Grammer, but I'm happy to look into and get those exact details for you.
If you trip across, I hate to have you do more work, but if you could share that, I'm very interested in the subject matter.
Okay.
And I think the rest of the committee probably is as well. Thank you.
Delegate Card.
Thank you, Delegate. So, if I design a car that automatically drives and I can program it to drive, and then I sell the car to somebody, they tell their aged grandmother that they bought a car that can automatically go, and the grandmother has a heart attack because she freaks out. I am strictly liable for those damages, wrongful death, according to this.
As long as it's intentional.
Yeah, I intentionally built a car that is capable of driving on its own, right?
No, the intent of this bill is if you intentionally programmed a car to intentionally kill someone or hurt someone.
No, that's not what it says. It says intentionally designed to be capable of causing personal injury.
Okay.
I mean, we can fix that if you want, but basically you want to create strict liability for somebody who creates some sort of robot that has the ability to do damage. I mean, all cars are robots, right? So they all have the capability.
No, cars are not robots.
Well, they all have computers in them, and they're able to move on their own. I mean, you can program them to move on your own. They can put it on cruise control, and it can move on its own.
Right, but that's not in the traditional definition. I mean, that's semantics. I don't want to like get into semantics with you, but that's not what the envision of this bill was, which is why I read you the 3 robots, and this is all about robots. It's not about cars, but your point is well taken on cars. Again, the bill is specifically designed for those people who do this on purpose. It's designed to stop bad actors so that AI, we focus on and get the good from artificial intelligence, not the bad.
But it's not the intent. It's not the harm. It's the intent to harm. So you want to make people strictly liable for designing something that could harm. I just want to make sure, or versus
no, that's and maybe the wording of the bill. Okay. I'm not an attorney. Obviously, you're an attorney. So, but that's not my intent. Is to stop those people who intentionally program something to hurt someone, and they do hurt someone.
Okay.
That is my intent. That's the intent. And if that didn't come through exactly, pardon me, I'm not an attorney.
I totally understand. We can talk about it.
Okay, thank you.
All right. That sounds like a good amount of time on assault with a deadly robot.
One more.
It's all
One more.
fun
Oh, wait, we got another
it's all
question.
fun.
Conaway.
It's all fun, Mr. Chair,
Conaway.
until someone gets.
Conaway.
Thank you, Delegate. When you brought the title up and the author, I thought that I was familiar with it, and I just wanted to tell you I was familiar with Asimov's Guide to the Bible, the Old Testament. So thou shalt not kill, and thou robot shalt not kill. Thank you.
Very well said, Delegate. Thank you for your indulgence.
Thank you. Interesting bill.
Thank you.
Okay.
Bye-bye.
We're going to move back onto our regularly scheduled agenda for House Bill 864, which is a Baltimore City delegation bill. I believe we have Delegate Smith here to represent the city delegation. And we have a few people signed up: Muriel Shutinya, Nina Themelis. Those are the favorables. Whenever you're ready.
Thank you, Mr. Chair. Thank you also, distinguished members of the Judiciary Committee. For the record, I'm Delegate Stephanie Smith, here to present House Bill 864 that was introduced at the request of the Baltimore City administration. And so to expedite matters, I'll make sure that the issue experts continue from here. And we do hope to see a favorable report for House Bill 864.
Good afternoon. Nina Themelis, Interim Director of the Mayor's Office of Government Relations, here to testify in support of HB 864. The bill provides for the responsible and gradual sunsetting of the Civilian Review Board while preserving and enhancing its existing investigatory and subpoena powers within the Baltimore City Office of Equity and Civil Rights, the agency that's currently responsible for supporting and staffing the CRB, the Police Accountability Board, and the Administrative Charging Committee. The CRB was created by state law in 1999 as the only civilian body with oversight of the law enforcement agencies of Baltimore City. Although the CRB is currently the only entity with independent investigatory authority, the enabling legislation limits its jurisdiction to 5 allegation types and requires complaints to be filed on a signed form within 1 year of the incident. HB 864 maintains this authority and model of oversight while removing administrative constraints and expanding jurisdiction to all complaints involving a member of the public. You'll now hear from Muriel Shutinya from the Baltimore City Office of Equity and Civil Rights, who will speak to the specific operations of the Civilian Review Board, Police Accountability Board, and Administrative Charging Committee. So with that, we respect a favorable report on HB 864.
Thank you all so much. My name is Muriel Shutinya. I serve as the Chief of the Police Accountability Division in the Office of Equity and Civil Rights for Baltimore City. I oversee the Civilian Review Board, the Police Accountability Board, and the Administrative Charging Committee for the city. As Nina said, HB 864 gradually sunsets the Civilian Review Board responsibly while maintaining that investigatory and subpoena power. Currently, the Civilian Review Board has very limited jurisdiction over complaints of police misconduct. It has 5 allegation types: harassment, abusive language, excessive force, false imprisonment, and false arrest, where the incident happened within 1 year of filing, and it has to be submitted on a specific signed CRB form. The Police Accountability Board, we are approximating will receive 700 complaints of police misconduct annually involving a member of the public, and approximately 50 of those cases end up being eligible for the Civilian Review Board. This bill expands that investigatory power to all complaints of police misconduct involving a member of the public. Currently, when a complaint of police misconduct is received by the Civilian Review Board, the Office of Equity and Civil Rights reviews that complaint for legal sufficiency and provides it to the board. We process that complaint, and then our civilian investigators actually conduct the investigation. This legislation, taking the language from the CRB enabling statute, codifies the current process that the Office of Equity and Civil Rights already conducts while supporting the Civilian Review Board. This bill maintains the investigatory and subpoena powers of the Civilian Review Board that are not currently assigned to any other Police Accountability Board entity in Baltimore City, and then allows Baltimore City Council to determine how the CRB's responsibilities are reallocated. This is both in the spirit of local control and also for very practical matters. Our PAB in Baltimore City has 17 members that signed up for monthly meetings, quarterly meetings with heads of law enforcement, and other activities. The time commitment to review 700 complaints of police misconduct, review the complaints, decide if they should be authorized for investigation, and then review the completed investigations can take up to 1 full day a week. It's not practicable or prudent to assign those powers broadly to the Police Accountability Board. This legislation preserves this crucial investigatory power, gives the City Council the ability to reallocate these duties to the Police Accountability Board in a manageable way, in a subcommittee of individuals that have that time, and in a legally sufficient way that's implementable and in best practices with civilian oversight. Thank you.
Okay, I don't see any questions from this group. Thank you very much. We have some unfavorable witnesses, Michael Davey, Yannette Emanuel, Molly Amster. Whenever you're ready.
Good afternoon, Mr. Chair, members of the committee. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police and the Baltimore City Fraternal Order of Police. We're requesting an unfavorable report on House Bill 864. This bill only affects Baltimore City. In 2021, the Police Accountability Act was passed to give civilian oversight and transparency as it pertains to police misconduct. This bill authorizes the Baltimore City Office of Equity and Civil Rights to review and investigate simultaneously with the Baltimore Police Department's Internal Affairs Division each complaint it deems appropriate and report its findings directly to the Administrative Charging Committee. The Office of Equity and Civil Rights basically is an umbrella agency that oversees the Police Accountability Board, the Administrative Charging Committee, and the Civilian Review Board. As written, the passage of this bill will allow any, if not all three of those agencies to conduct an internal investigation on police misconduct. Already, the Civilian Review Board has the authority to investigate excessive force, abusive language, harassment, false arrest, and false imprisonment. The Administrative Charging Committee under the law today has the ability to review all the internal affairs investigations conducted by Internal Affairs, review body-worn camera footage, request additional investigative steps, order the officer to appear before it, and has subpoena power. As the bill is written right now under 1656C5, it actually would allow the Civilian Review Board to hold a hearing prior to deciding whether charges should be brought against that officer, where the officer and or his representative could ask questions of the witnesses. That's before the officer is even charged. This is only going to delay the investigation, and it's going to contradict the Police Accountability Act as it pertains to efficiency and timeliness of the investigation. Technically, there could be 5 investigations about one act of misconduct. The Office of Attorney General, Internal Affairs, the Police Accountability Board, the Administrative Charging Committee, and the Civilian Review Board. You could get 5 different results based on the way the bill is written. The only person that's going to benefit that is the officer who's being investigated for misconduct, when they could have different results. For those reasons, we'd be requesting an unfavorable report on House Bill 864. Thank you.
Good evening, Chair Moon and members of the committee. For the record, my name is Yannette Emanuel, Public Policy Director at the ACLU of Maryland, here in opposition to this bill for separate reasons. We continue to oppose the city's efforts to undermine community oversight. Last year, the committee passed HB 991, which was introduced by Delegate Smith and supported by the Maryland Coalition for Justice and Police Accountability. This bill sought to ensure that the Civilian Review Board structure authority remained intact while giving it the additional powers and the scope of the Police Accountability Board's powers as mandated by the Maryland Police Accountability Act of 2021. One of the most critical components of community oversight is independence and independent investigatory powers. HB 864 seeks to give the illusion of independent accountability by repealing the CRB and giving the Office of Civil Rights, a city agency, independent investigatory powers and the authority to share its findings with the Administrative Charging Committee. Instead of investigators reporting to the CRB or the PAB, which is accountable to and made up of committee members, HB 864 seeks to keep those investigations and recommendations internal, and that is unacceptable. Not only would this increase community resentment and distrust as residents go to the board to seek redress yet end up with little, but it means that Baltimore City will have an even weaker community oversight structure than it did prior to the repeal of Leo Board. For the foregoing reasons, the ACLU urges an unfavorable report on HB 864. Thank you.
Mr. Chair and members of the committee, for the record, I'm Molly Amster, Maryland Policy Director and Baltimore Director for Jews United for Justice. JFJ is opposed to House Bill 864 as it will serve to weaken, not strengthen, community oversight of policing in Baltimore. The city claims that this legislation will have little to no impact, that it essentially just transfers Civilian Review Board powers to the Office of Equity and Civil Rights, and by extension, the Police Accountability Board, the PAB. That is not the case. The important thing to understand is that the CRB is an independent agency. The Maryland Court of Special Appeals established that in 2006. The CRB is not an agency overseen by the mayor, city council, or the police department. That allows for a level of independence which would not be possible if House Bill 864 passes. sunsetting the CRB and granting its independent investigatory power to the Office of Equity and Civil Rights, a department under the supervision of the mayor, who also supervises the police commissioner, is a conflict of interest. The National Association for Civilian Oversight of Law Enforcement says, one of the most important and defining concepts of civilian oversight of law enforcement is independence, structural and political. Political independence refers to the extent to which political actors can influence or affect the operations of an oversight entity. Several organizational and procedural aspects of civilian oversight can be assessed in these terms, including whether the oversight body is represented by the municipality's law department or its own independent legal counsel, or Office of Civil Rights, or the ways in which political actors can influence the staffing and composition of civilian oversight by retaining authority over hiring, appointment, and removal processes. As such, the CRB should not be sunset until the PAB is granted the same status and powers of the PAB. Of the CRB. Let me repeat that. The CRB should not be sunset until the PAB is granted the same status and powers of the CRB. We therefore urge an unfavorable report on House Bill 864.
Delegate Embry.
Thank you so much. Can you give us the status of the PAB?
As far as it being set up?
Yep.
I understand that they just finally appointed all the members to the board and are now setting up the charging committee as well.
And I'm sorry if I have a follow-up. Is there any timeline that's been provided by the city?
As far as when they're going to set that up?
Yes, the PAB, yes.
That I'm not sure, but I know that the CRB is also not appointing members or investigating as well as they're waiting for the PAB to get set up, so it is causing a delay.
Got it. Thank you so much.
All right, thank you very much.
Thank you.
Thank you.
That's going to end the hearing on House Bill, whatever that was, 864. We're going to move on to House Bill 861. Delegate Smith, do you have a panel of all online people?
No, some of them are in the hall.
Some of them are in here.
Probably.
Okay, I'll start reading some names. Joyce King, Greta Willis, Jessica Emerson, Kyle Fisher, Amanda Rodriguez, Joyce Lombardi, any of these folks here. Braden Stinar online, Melanie Shapiro. Folks want to start coming up.
Sure.
Melanie Shapiro, Susan Tucci, Robert Morgan, any of these folks?
He's quickly flagging some folks that were just in the hallway.
Okay.
I'm happy to get started if that
Yep,
would
go
be
ahead.
helpful for you. Thank you, Mr. Chair. Thank you, my colleagues of Judiciary. This is the last time I'll be before you today. For the record, my name is Delegate Stephanie Smith, and I'm here to present for you House Bill 861, and I do hope to receive a favorable report. This is a bill that's really addressing what it means to get the support that we've designed through the state as a victim of violent crime. As many of you may be familiar with, the Criminal Injuries Compensation Board, it's designed to help those who are victims of violent crime to receive some support when there are different adverse outcomes of being a victim. We know that the ultimate penalty of being a victim is death, and this is helping survivors pay for funeral expenses, for example. We know that there's attendant psychological and emotional distress that comes from being a victim of violent crime. This particular board provides resources to help people cope with that. And there's myriad other things, particularly when we're discussing intimate partner violence, where maybe there needs to be some hotel fees or some other types of debts that are incurred, just trying to maintain safety when those types of matters arise. So what this bill sets out to do is to reimagine the composition of the Criminal Injuries Compensation Board to ensure that its membership is reflective of the breadth and diversity of our great state. It also gives a lot more credence to the professional staff that already are closer to evaluating the validity of those requests for reimbursement, and allowing them to basically process those requests and really, instead of this board essentially rubber stamping the professional staff response, it's more about elevating them. If there's any discrepancy between someone who has been denied, reimbursement under this this provision, then this board would be more of an appellate entity where those types of appeals would go to. This also expands the notion of who is constituted as an actual victim of violent crime. It's not just the person that has physically been attacked or has lost their life. It's also those dependents and other domestic partners. We want to ensure that anyone in the constellation of proximity to that victim is properly supported by this fund to ensure not only their wholeness, but also in some instances, it can prevent further acts of violent crime from happening in the first place by removing people from either communities, housing, or other situations where they could be further exposed to violence. And so I don't want to go too deep because we have people who are going to go deeper with some of those, those provisions I spoke of. I wanted to give a little macro about this bill is important because if we say as a state that we want to be here for victims of violent crime and we have set aside funds expressly to support them in a time of great need, the ability to access those funds should not be opaque. They shouldn't be tedious. They can be both vetted appropriately, but not so expansive that no one gets the actual resource that was designed. So this is more about streamlining, creating more accessibility, and also ensuring that the board that has the responsibility for these funds represents our great state. So thank you for your time today, and I do hope for a favorable report for House Bill 861. Thank you, Mr. Chair.
Good evening, members of the committee. Once again, my name is Heather Warnken, and I am the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law. Previously, I served at the U.S. Department of Justice, where a substantial portion of my work included collaborating with and advising DOJ's Office for Victims of Crime and its constituencies of state administering agencies and victim service and compensation programs across the country. So based on this background and experience, I am here in strong support of HB 861. This is not just about the healing and dignity of crime victims. This is about public safety. By assisting with the destabilizing expenses that come with the trauma of violent victimization, including funeral and burial, medical and mental health needs, compensation helps to reduce the risk of future victimization and perpetration of harm and the long-term costs of violence to the state. Now, currently, there are numerous challenges undermining the effectiveness of this program, including a harmful reliance on court fines and fees to fund these benefits, unreasonable and discriminatory attempts to promote victim, quote, cooperation and reporting to law enforcement within 48 hours, which is especially unjust for victims who may fear or distrust police or who may have prior involvement with the criminal justice system, and blaming the victim by operating on a flawed model of only supporting, quote, innocent victims, leading to determinations of, quote, worthiness, too often influenced by race or other discriminatory factors described extensively throughout our written testimony. So HB 861 addresses these barriers, and it is the product, as you will hear this evening, of a collaboration by a large and diverse coalition of organizations and directly impacted people representing the overlapping constituencies, navigating these barriers every day. So in closing, I'll say, as we inevitably wrestle with questions surrounding how do we pay for it, our coalition poses what research tells us is a more apropos question for our communities hardest hit by violence. How do we not? We urge a favorable report. Thank you.
Hi, everyone. My name is Kyle Fisher. I'm an emergency room physician with the University of Maryland. I'm the policy director at the Health Alliance for Violence Intervention, the HAVI. I'm here today in favor of the bill on behalf of the HAVI. We're a national network of hospital-based violence intervention programs. We have about 5 or 6 programs here in Maryland, one that I helped start. And the reason I'm here today is that one note that our programs consistently and repeatedly bring up is that the Victims of Crime compensation system does not work for the patients that we take care of. Our patients are predominantly young Black and brown men that have been survivors of gunshot wounds and stab wounds. But despite this, they were essentially locked out of the criminal injury compensation system. From their perspective, it might as well just not even exist, to be honest. Almost none of our patients end up getting any compensation. And let's be clear, they're survivors of attempted murder. Attempted murder. These are real crimes, and they're survivors, and they deserve to be part of this system and to be compensated. The current system, where they are injured, it only makes their recovery more challenging because not only are they recovering from physical wounds and psychological wounds, but now they have the financial expenses associated with being a victim that they're now on the hook for. And so this legislation really helps to improve the system to make sure that it's accessible for all of the folks that we take care of. It gets rid of the old system of the CICB picking winners and losers based on this idea of like a deserving and undeserving crime victim, but rather just calls balls and strikes, right? If you are the survivor of a crime and criminal injury compensation is allowed to you, you should get it. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence. I'd like to thank Delegate Smith, who had to run, as well as the steering committee of the coalition. We are a wide array of individuals, which reflects the significance of House Bill 861. Because House Bill 861 is about all victims of crime. The intention of House Bill 861 is to refocus the victim compensation process on the harm that was caused and not on the crime that was committed. We've spent a lot of time, and I include myself in that conversation, talking about public safety. What do we do to reduce crime? How do we prevent crime? What do we do with the people who commit the crimes? But what's often left out of that conversation is what about the victims? This bill is about the victims of the crime. Overwhelmingly, they want to be restored. Victim compensation is still a payer of last resort, but it's so cumbersome to even access the system that most people don't even try. The numbers are right there. There is a mandated report. I have a copy. It's on the DLS website that they file every year, the CICB. And in fiscal year 22, the number of claims filed, 855. Number of claims denied or closed, so no payment whatsoever, 460. Number granted, 354. Number of domestic violence-related claims paid, 0. That's because the law requires that you must report it within 48 hours. You must cooperate with law enforcement. You cannot have contributed to your victimization. There are so many barriers, and you will hear from a survivor of domestic violence who has gone through an arduous process to receive compensation. This bill takes a comprehensive approach and restructures victim compensation to what it can look like and what it should look like in Maryland. We, as I said, we refocus on the victim, and we remove the arbitrary barriers to eligibility. We reconstitute the board so it's reflective of the people that it is serving, streamline the grants process. I know that my time has expired. The bill is quite lengthy. We are happy to answer any questions about it, and we urge a favorable report.
All right, why don't we pull a couple more folks up to the podium? I think I see Jessica Emerson, Joyce Lombardi, Amanda Rodriguez. Whoever would like to begin.
I can go first. Excuse me. Hello, my name is Susan, and I am a survivor of domestic abuse. After being strangled, having bones broken, suffered a lung contusion, 2 staples in my head, and several concussions, I had an outrageous amount of medical bills. I first submitted my application to the CICB in early August 2021. At the end of August, I received a response that paperwork was missing. I submitted the requested paperwork immediately, and I heard nothing. January of 2022, I was told that my CICB caseworker was no longer with the organization and that I needed to resubmit everything, which I did, and I heard nothing. April 2022, I sent an email requesting a status update on my claim, and no one got back to me. September 2022, 13 months after initially submitting my paperwork, I heard that my claim had finally been submitted to the board. 1 month later, I received an interim letter of eligibility with the reimbursement amount of $1,214.46. I assumed I would receive my reimbursement check within a few weeks. I didn't, so I emailed the CICB on December 8th. No reply, so I emailed the following week. This time I got a response that I needed to complete a W-9. I did so immediately, and I still heard nothing. In the beginning of January 2023, this year, I started calling the CICB. I was finally told by the CICB that the holdup was on their end and that they were getting W-9s from my healthcare providers. January 24th of this year, I was told that my check was being mailed the next day. This was not true. The letter that was mailed was the final decision letter, not the check I was promised, which states two different reimbursements amount. Page 2 of the letter states, claimant is owed $455 of unreimbursed medical expenses. Yet page 3 states that the claimant be awarded $700 for the above referenced expenses. And yet, wildly, the amount that I requested is $790. To date, 19 months later, I still have not received my reimbursement. Without my relentless pursuit, what would have become of my claim? And even with my relentless pursuit, where is my reimbursement? I think that it's pretty clear that the CICB needs some improvements.
Good afternoon. My name is Robert Morgan. I'm a crime victim. I became one in 2018, which terminated my employment at the University of Maryland. I had the privilege and pleasure of being an assistant chef serving the patients lunch for 4 years. At that point that I was assaulted, fortunately for martial arts training, I didn't get killed. My head hit the curb, my shoulder suffered a level 5 separation in the shoulder joint. And I sought out assistance from the Criminal Injury Compensation Board. I was encouraged when the police gave me a pamphlet indicating that there was a moral responsibility of the state to help crime victims. And what I met with was something that was opposite that. I met with bureaucracy, I met with insensitivity, I met with dilatory behavior, and I met with shifting the buck. It took the help of Roar, it took the help of Delia Attar, and it took the training I received from attorney Robert Fulton DeShields as a paralegal for me to navigate this system. I looked into it, I found out they had a provision for emergency award. No one knew how to process that. And I knew that they had to have regulations that had the force of law. In Comar, there were none for the emergency award procedure. Through this process, it was constant shifting the buck, going to one other person, this one is not in, the commissioners need to get together. Duke Ellington said that a problem is an opportunity for us to do our best. I urge favorable report of this bill and improve on the moral responsibility that the state has acknowledged and bring these tools into play for the CICB. Thank you.
Good afternoon, evening. I'm not quite sure what time it is. Mr. Chair, members of the committee, my name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which seeks to reduce the collateral consequences of criminal legal involvement for sex workers and survivors of trafficking. I am also here in support of House Bill 861. One of the most crucial changes this bill will make is the elimination of the determination as to, quote, whether and to what extent the victim claimant was responsible for their own injury. The presence of this language within the current statute reinforces the myth of the perfect victim, which means that to be considered a real victim of crime, you can't struggle with addiction, you can't live in poverty, you can't have a mental illness, and you definitely cannot engage in commercial sex or have a criminal record. This manufactured and unrealistic distortion allows us to question the legitimacy of claims of any individual who does not act like a victim, while in the same breath minimizing and even forgiving the abuser's acts of violence. This is of particular relevance to both trafficking survivors and sex workers who commonly have criminal records and experience victimization as a result of their involvement in the sex trades. Consider the victims of Mr. Charles Nabbitt, former owner of Mountain Manor, a substance use recovery center in Baltimore City, who pleaded guilty to transporting women across state lines for purposes of engaging in commercial sex, and coordinated with a trafficker for access to his victims, all of which either were or had received treatment at Mountain Manor. Mr. Nabbitt's defense attorney leaned hard on the prevailing image of victims like this by referring to them as prostitutes and commenting explicitly on their drug use. Mr. Nabbitt's victims would likely fail the CICB's purity test, given that they were using illegal drugs and engaging in sex work when they were purposefully recruited, exploited, and victimized by both Mr. Nabbitt and the trafficker he was working with. For far too long, the people most harmed by the criminal legal system and targeted for violence have been the least supported by the state and have been excluded from conversations about public safety. The victim compensation process needs to work for all victims, not just those deemed worthy by standards rooted in victim blaming. For these reasons, the HTPP supports House Bill 861 and respectfully urges a favorable report. Thank you.
Good evening, Vice Chair and committee members. My name is Lydia Watts. I'm the Executive Director of ROAR that Mr. Morgan mentioned, the Rebuild, Overcome, and Rise Center at the University of Maryland, Baltimore. ROAR was started about 3.5 years ago. We started operations in June of 2019. In the ensuing almost 4 years, we have served over 600 unduplicated survivors of crime in Baltimore City. About 60% of the folks who come to ROAR are survivors of gun violence. So either family members who have lost somebody to homicide, or the survivors of non-fatal gun shootings that you heard about from Dr. Fisher at the first panel. What we see routinely is exactly the experience you heard from Susan and Mr. Morgan, the unremitting bureaucracy that survivors have to overcome, and that is only if they are deemed eligible by, as been noted by other panelists, reporting to the police within 48 hours, cooperating with the police, and not being culpable in their own victimization. Also a determination made by the police. So this is ripe with all sorts of racial discrimination. As Dr. Fisher noted, the majority of folks who are victims of gun violence are young Black and brown men, and that's true across the state of Maryland. And the assumption that we see made time and time again is that just by virtue of being Black and being young, that they must have been engaging in some kind of activity that contributed to their victimization. However, what we also know is there's only a 10 to 30% closure rate on non-fatal shootings in Baltimore City. So we know that that means that 70 to 90% of those cases have not been investigated thoroughly, yet the police feel comfortable making an assertion as to whether this victim is culpable and or is not cooperating with the police, which would either one of those denials by the police would render this applicant non-eligible. At the ROAR Center, we represent applicants in appeals of those denials, and we have almost 100% success rate. ROAR urges the House Judiciary Committee to issue a favorable report on HB 861. Thank you.
Good afternoon, Chairman, members of the committee. Joyce Lombardi. I am here representing Center for Hope. We represent about 6,000 victims and family per year who have experienced a range of violence: child abuse, elder abuse, domestic violence, and gun violence. We absolutely urge a favorable report of this bill. Our program managers have reported a lot of the things that you've heard here today. I myself can share my experience because I helped 2 of our gun violence survivors navigate claims through the board, thinking, I have a law degree, I've sued ExxonMobil Corporation, how hard can this be? The answer, extremely. The number for the victims represented is exactly 0. Take that number and roll it down the street, because that is what they got. The victims of gun violence that I represented, one was a couple who was shot in the face by someone that had something called a knock and shoot. It's a gang initiation. They're still suffering from those injuries. Someone got off the 85 bus after power washing. He was shot. Bystander doesn't know who shot him. Someone else was laying concrete in Reisterstown. He was the victim of a white supremacist attack, left him incapacitated. Those claims were met by denial, delay, dilution, as with the ExxonMobil Corporation. lost paperwork in one. We had to resubmit the claims. It wasn't clear what we needed. No return phone calls. I could go on. It was unbelievable to see it up close. I turn your attention to the accounting mechanism. I think it's on page 5. Extremely interested in that and making this a trauma-informed board. I urge a favorable report. Thank you.
All right, let's turn to some of our online folks now. We've got Joyce King and Braden Stinnar. Why don't we start there? Joyce, whenever you're ready.
Okay, great. Good afternoon, Mr. Vice Chair, distinguished committee members. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office and co-chair of the Maryland State's Attorneys Association Special Victims Subcommittee. MSAA supports HB 861 with MCASA's amendments regarding privacy and clarification eligibility. I'll defer to Ms. Jordan regarding explaining those amendments. We echo all the testimony that you've heard today that CICB is currently not an effective reimbursement option for our victims. I spoke with our forensic services patient navigator at our Frederick Health Hospital, who stated in her career of working with thousands of patients, she can only think of 2 patients that were actually successful in receiving reimbursement. And even in those cases, they only received a much less payout than what they should have been entitled to. Patients typically wait years to hear back and often have to send information over and over again. The MSAA would like to highlight in our testimony really non-fatal strangulations, which make up a majority of intimate partner violence patients we see at Frederick Health Hospital. Strangulation is particularly lethal for intimate partner violence, as unconsciousness can occur within seconds and death under 2 minutes. These medical examinations and forensic documentation that follow a strangulation event are not only potentially life-saving, but they're an invaluable prosecutorial tool. In about 50% of strangulation cases, there's no visible injury. However, where there is injury, there's often internal swelling, carotid dissection, or blood clots, which can be fatal. What we see are victims are not seeking the care that they need because they have the inability to pay, that there is much vagueness and lack of surety whether they're going to get reimbursement. We believe these barriers are even more so for physical child abuse cases. We want these patients to have access to services, access to the support that they need, and MSAA asks for a favorable report of HB 861.
All right, Braden Stinnar, when you're ready.
Thank you, Mr. Chairman, and distinguished members of the committee for the privilege to speak before you today. My name is Braden Steiner, and I'm a third-year law student at the University of Baltimore and research fellow with the Center for Criminal Justice Reform. I'm here today to testify in support of House Bill 861. This bill seeks to address barriers and clear pathways for all victims to get access to the support and dignity they deserve. After decades of well-known challenges, this bill is the product of collaboration by a large and growing coalition of diverse organizations and directly impacted people representing the overlapping constituencies of victims and survivors facing these barriers every day. Beyond victim services, this includes those working on violence prevention, criminal justice reform, reentry, racial justice, and more. This collaboration is emblematic of the common ground we occupy, especially the desire to see the return on investment to public safety through this bill. For example, a well-functioning victim compensation program plays an important role in community violence intervention efforts, a role we have yet to realize in Maryland. Regarding gun violence reduction, perhaps the most promising potential is that it could provide ways to help support and stabilize people engaged in behaviors and relationships associated with gun violence. Access to these benefits can thus provide community violence interventionists, trauma recovery specialists, law enforcement, and others who work with people caught up in cycles of violence, victimization, and trauma an important tool and tangible resources to help meet their needs, connect them to services, and set them on a path of healing and desistance. This is especially powerful from a victim services lens, given that too often Black and brown victims of gun violence are criminalized and unlikely to be seen and served as victims of crime. All, I repeat, all survivors of violent crime deserve support. Thank you.
All right, we're going to take Lisa Jordan, assuming her favorable with amendment is friendly. Is that right?
That's my understanding.
Okay, great. Go ahead.
Yes.
Thank you, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We are supporting House Bill 861 with some, I'm hoping, friendly minor amendments. And I am not going to repeat everything that everyone else has said, but I will give you an example. At one point, I have to credit the CICB. They are no longer doing this, but at one point they were denying compensation to victims of statutory rape because they felt like they were contributing to their crime. I really do think that the board has moved forward, but the statutory provisions in House Bill 861 are needed statutory reforms. There are three things that I would respectfully suggest the committee consider. One is we use CICB when reimbursing for rape exams, and one of the things that we do with those reimbursement requests is we have protections for privacy, that the medical provider is not required to provide a narrative of all of the details of the sexual violence or photographs of someone's intimate areas. We suggested some similar language to limit the times that photographs or really graphic details of the crime would have to be shared there. Another is regarding medical exams. Current law permits the board to order a medical exam, and similarly, we really believe that medical exams should very much be limited to when it's absolutely necessary and there's no less intrusive way to get that sort of evidence. These are important privacy protections. And then the final suggestion that we would make is that we 100% support removing the provisions about being involved in the crime. That leaves language that says they will not provide CICB to the perpetrator of the crime, and we would suggest that that needs some clarification. So if a conviction is not required, as you know, sexual assault survivors have a rapist who's convicted, and we do not believe that any rapist should be able to have CICB compensation. For those reasons, we ask for a favorable report of House Bill 861 with amendments.
Okay, now we're going to pause for questions. There's no opposition to this bill. All right, Delegate Arakan.
Thank you so much, Mr. Chair. First, to the victims that have testified, I'm so sorry for what you went through, first of all, and second, how you were re-injured by what appears to be an utter lack of functionality from this department. I'm embarrassed to hear the stories and to hear what you've gone through. And ashamed that our state handled it so poorly. So besides that other issue, which probably needs to have an audit of some kind done because that's so egregious, I am just reading through the department's comments. I don't know, I know the sponsor's not here anymore, but I don't know if Melanie is best to answer this or whoever wants to and feels like they're best equipped. There's a pretty significant fiscal note on this bill, and I don't know if you all have heard the rumors that we've heard, but pretty big fiscal notes are likely not going to fly this session.
Yes, so thank you, Delegate Arakan. One of the things to note is that we have asked for the money to come in starting FY25, and so it's not in this year's budget. There was also money for additional pins. I believe that there was a letter for GOCAP that had a lot of staff that they were requesting, but we actually, and what has been seen from other states, is that when some of these improvements are made, there's not this, it's still a payer of last resort. So if health insurance exists, then the health insurance covers the initial claim, it's the out-of-pocket expense. And so I don't think that there's going to be this, everybody comes up with these dire situations. Are there going to be more victims that are going to be eligible for compensation? Absolutely, as they should be. And as we as a state should be supporting them as they've been victimized and victims of a crime, and we should be restoring them to whole. It is not in a way to enrich anybody, but merely to cover the expenses that they are otherwise out of pocket as a result of being a victim of a crime. And as for some of the other aspects, and Ms. Morgan is probably best to speak to this, there is federal matching that happens as well. So there was a brief mention about the reliance on fines and fees, and I know that there's been debate and legislation in here regarding how we rely on fines and fees, and that is one of the sources of income. And so we do believe that it should be an item in the budget, but starting in FY25. And then there's some federal dollars that come in as well. And if I can hand it over to Ms. Morgan to share about that.
Sure. The Victims of Crime Act and the role that the United States Department of Justice Office for Victims of Crime plays is significant here. They have a relationship working with all states and territories' victim compensation programs to provide matching funds, which were actually increased with 2020 legislation at the federal level through the Victims of Crime Act Fix Act. So depending, and the federal government is actually currently in progress updating the guidelines for this process for the first time in 23 years, so very significantly for the first time in a generation. That overhaul is designed to do a lot of things that we're trying to do with this bill at the state level to streamline the process for states getting reimbursed and to reimburse them 60 to 75% on some of these, and I'm happy to share with you some follow-up paperwork about how that state reimbursement process works.
Yeah, that'd be really helpful. They did mention in here concern that there was that gap where they would not have any funding. So I don't know if there's an amendment that's going to be proposed, because it looks like they said from October to July they'd have nothing. So that's certainly something for the sponsors to think about. And then just a quick comment on sort of the overarching policy. I know Lisa Jordan did mention that she wanted to make sure that rapists were not being compensated. You know, are there other groups of people, like, I mean, I think some of us might be uncomfortable if someone convicted of murder was also being compensated. Is that a policy position that you guys have talked about?
Well, the hypothetical of a rapist or somebody convicted of murder seeking this for the act that they are seeking reimbursement for, it is certainly possible that somebody who is convicted of murder, served their time, is now released and is subsequently a victim of crime. So they would not be eligible for compensation for the crime that they're that they served time for. But it is very, very true that returning citizens are at very high risk of being victimized. And that's true for many, many folks, and predominantly true for communities of color and low-income communities, who are also the least likely to be able to absorb these costs. So the rates of victimization are much higher in those communities and among returning citizens, as a subcategory of our population, are much more likely to experience subsequent victimization. So what our policy position is that a prior conviction would not render them ineligible for subsequent compensation. But that, of course, in the scenario that Ms. Jordan presented, the rapist would not be able to seek compensation for any harm that they may have incurred while committing that rape. And the way that that would be assured through this process is there still would be some level of proof that the person would need to provide that they were in fact a victim of crime. And so I would submit that that rapist would not have anything as proof that they were the victim, that in fact quite the contrary, that they were the perpetrator. So there would still be an element of review. It just wouldn't be required by either a police report or some other certified method but there would be some level of requirement, and that could be medical records that shows that somebody went to a hospital for injuries. So theoretically, could a rapist who maybe has self-defense wounds, theoretically that could be possible, but again, while the claims adjuster at CICB is reviewing that application, that any kind of sort of cursory explanation would hopefully be made clear. I would also submit that the vast majority of crime survivors, when we talk to them, particularly from our most disenfranchised community, have never even heard of this fund. So the likelihood that somebody who's not being served by a victim services agency or by the prosecutor's office or by the police are not going to hear about this fund. I mean, even those that are served frequently say, I've never heard of this, or I heard about it much too late.
Okay, I just want to confirm with Ms. Jordan, if I can, that was the amendment that she actually intended, because that was not my understanding of what she said, so perhaps I was confused. Ms. Jordan, did you intend for that amendment only to be for people who are considered rapists, who are convicted of the crime of rape, getting compensation for damages during the rape they are committing, or at a subsequent event where they have both been convicted of a previous rape and are now applying because they are a victim of a separate crime?
Yeah, thank you for that question, the opportunity to clarify. We are not suggesting that simply being a convicted rapist or convicted murderer would bar subsequent compensation. That's certainly been a bill that's been presented to the General Assembly in the past. Our concern is about the lack of clarity in the bill's current language that says the perpetrator of the crime may not receive compensation, but there's no standard of proof. There's no indication that the language is not limited to situations where there would be a conviction. So I think that the bill could fairly be read at the moment as saying we will not provide compensation for those self-defense wounds only if there's a conviction. And with all respect to my colleagues, I don't trust that people who have been involved and are sex offenders are necessarily going to represent the clear picture. So I would suggest that you do want to say that that there's no conviction required, that there's no finding of delinquency required, particularly when you look at crimes against women and children. I mean, how many child abuse cases do we have where the abuser is just never convicted? We want to make sure that that abuser is not then getting compensated for counseling because he's been a child abuser or something like that. So I was thinking of a closer tie, but I was also thinking that you would clarify that the conviction is not required.
Okay, all right, that helps clarify. I think there's definitely, this bill is very dense and it brings up some other policy questions I think that some of us might be uncomfortable with. We can talk offline.
Delegate Kaufman.
Delegate Erican asked my question about the cost of the legislation, so I'm good.
Delegate Embry.
This is a quick question. I think this is a great bill. I do have so if I'm doing the math correctly, the board that's proposed would not allow anyone, or would not have room for anyone from law enforcement, its attorney's office. Would you be willing to allow someone from that part of the criminal justice system to be on the board, at least, one member?
We were certainly not any opposition to having law enforcement on that board. Our goal is to include people with lived experience and with expertise around crime victimization. Police officers obviously interact with victims all the time, but in a very narrow construct, and are not often learning the full array of experiences that survivors have, particularly when we're talking about communities like what I represent, which are predominantly Black and brown communities in Baltimore City, where there's a lot of distrust of the police. So there's, certainly we're not trying to exclude the police and the helpful role that they could play, but we also want to balance that voice by having people with lived experience and experts in victim services.
Absolutely, but you wouldn't mind if that was
I personally would not be opposed to that, no.
No, yeah, certainly, just to add to that, the intent is not that exclusion, but for pretty much the history of this program, both in Maryland and across the country, it has so been disproportionately populated by that population. As Ms. Watts explained, this is to greatly diversify it.
Appreciate that. Thank you.
Yeah.
All right, thank you very much. I just want to make sure we actually caught all of the people who signed up that wanted to speak on this. All right,
So Vice Chair
we've got
Moon,
some more. Yep.
this is another survivor who did not sign up, but she would like to share her experience if the committee is available, and I do believe there are
We
other
don't
people.
generally do that.
I know. She happened to be here today for something else and is living this experience in Prince George's County. So if the Vice Chair would be so gracious as to allow her the 2 minutes just to share her story.
All right, we might give her the one exception, but let's see who else is here from our signed up folks. Do we have Greta Willis, Robert Morgan?
Robert Morgan already testified,
Okay,
Your Honor.
Melanie Gordon Newell, Lisa Malek. Any of these folks here?
I think Greta Willis was under the impression she was testifying virtually.
Okay. And then we have yeah, okay. Did I miss anyone else? All right, why don't you come up? You're favorable with amendment?
Right.
Yep, okay, I've got you. Why don't you go ahead and come up, and then we'll go ahead and take our surprise guest. And again, let's try and be brief, please.
My name is Nikki Owens. My cousin was William Green. He was in a traffic accident, and he voluntarily and cooperated with the police. He was taken out of his vehicle. He was searched, he was handcuffed, and he was put in the front seat of a police car. The officer went to the vehicle to move it out of the way of traffic, and he fired 7 shots at my cousin. 6 shots entered his body, killing him. The officer was arrested within 24 hours, and he has been incarcerated since January 28th of 2020. My husband and I paid for my cousin's services. We paid over $15,000. Another side of his family did cover some of the burial costs because they had plots. I submitted documents for the funeral costs for my cousin in March of 2020. I never heard from anyone from the committee until December of 2022. That was the first time that they sent me a letter to my home to ask me to submit additional documents. And they asked me for additional documents of other things that were paid for, like various. So I sent it. Those costs were covered by his other side of the family via GoFundMe, which my husband did help them set up, but I was not the beneficiary, and neither was my husband. Our names were not on it. Our bank accounts were not on it. I submitted receipts that had my American Express card. There wasn't enough in the GoFundMe to cover any of the costs that me and my husband paid. There was a lawsuit, a civil lawsuit against the PG County, and my family did receive a settlement, but I was not part of that lawsuit. His mother and his children were part of that lawsuit. They contacted me in January, and they asked me about the lawsuit, and I explained to them I was not a beneficiary of that lawsuit. I did not receive any money from that lawsuit. And then they called me back about the GoFundMe, and I explained to them that I was not a beneficiary of the GoFundMe. And then they refused to take my calls anymore or respond to my emails. So that is my experience. And as of today, I still have not heard back from them.
All right, thank you for sharing your story. We have one more favorable with amendment. Pauline Mandel, you're going to close us out.
Yeah, good evening. My name is Pauline Mandel. I'm the Director of Legal Services at Maryland Crime Victims Resource Center. Used to be the Stephanie Roper Foundation. I'm here because our agency for the last at least 20 years has been working with criminal injuries compensation, and we have been helping victims, assisting them in any way possible. Last year, we touched over 700 victims of criminal injuries. We have a full-time attorney who does absolutely nothing but appeals both in the way criminal injuries works is you start out with a letter from them whether or not your claim has been denied. If it's been denied, the first denial, you can ask to go before the board. Our attorney goes before the board with them. If we lose at the board, we go to circuit court, which is an appeal. If we lose at circuit court, we go to the Court of Special Appeals. Our last Court of Special Appeals case was sometime last year in terms of there was a, bless you. I know it's been a long day. People in Montgomery County, if they are a victim of a crime, are entitled to a $2,500 payout from Montgomery County. And so criminal injuries decided that if you were a victim of a crime and you were in Montgomery County and they were going to give you funds, they would deduct $2,500 from those funds because you have received something from Montgomery County. So our appellate attorney took that up to the Court of Special Appeals, which is not called the Court of Special Appeals anymore, but anyway, took that up, and the court came back stating that that money could not be taken and CICB needed to pay the full amount. So that was the last appellate victory we had. But there's all kinds of stuff out there. I say all this stuff just to say we can talk for hours about all the horror stories you've heard. My staff has seen them. My staff has done everything possible to assist. We actually had a victory last week. We got one of our clients, after 5 years, got a check for $25,000. He was a gentleman who was driving an ice cream truck, got shot, totally disabled, and it took us 5 years to actually push through and get his check. He was thrilled. So the concerns that we have, I think, are mostly evidentiary. I'm sorry. So we can discuss those with the board in terms of, because when we represent clients, which is what we do on a regular basis, there are things, for example, allowing police reports to become evidence is not a good thing for our clients when we're representing them before the board or if we're going to court. So there are different issues that we have in terms of that. One of the concerns I have is at this point in time, when we are
We're going to need you to wrap up, unfortunately.
Okay.
Did you submit your amendment in written form?
Nobody will.
Okay.
Okay. The biggest problem we have is the inability of criminal injuries to move cases, move them forward. Okay? It takes them forever to do anything. Procedure does not work because it takes forever. They also have 7 vacancies, so that's another whole issue. But the point is, the first thing that needs to happen is to be able to get them to work in a way where things can be done quickly, people can get their funding. And if you look at, there were comments about the funding and talking about the people who were denied, and over 200 people on that report were denied.
Okay, we got to wind up. I'm sorry.
Right.
The rest of this is going to have to be by text.
Okay.
Yep.
And the reason they were denied is because
There's
they got show cause orders from
All right.
criminal injuries and did not know what to do with them.
All right. Thank you. Thank you very much.
Thank you all very much. Have a great evening. And we would ask for favorable, and the amendments will be sent.
Thank you so much. And folks can follow up if they have additional questions. Okay, that's going to end the hearing on House Bill 861. We're going to move on to House Bill 978 from Delegate Ciliberti. I believe this is a solo bill, so whenever you are ready.
All right, Mr. Chairman. This is, I am Delegate Barry Ciliberti, Frederick County, and with April Miller, also my compatriot from Frederick County. We are here to present, of course I am, House Bill 978. And folks, I am mindful of the fact that the mind can absorb, but the seat can endure, so I'll try to be brief. Basically, this is criminal law threat against state or local officials, first responders. For the record, a first responder means a firefighter, an emergency medical technician, a paramedic, a rescue squad member, a nurse, or a doctor who provides emergency services. This used to be the nurse's bill, but it's moved on to this. For the purpose of the bill itself, the purpose of including first responders within the scope of certain prohibitions against making or delivering threats to take the life of, kidnap, or cause physical injury to certain state and local officials, generally related to threats against the state and local officials. Ladies and gentlemen, it is a bill similar to much that has been stated throughout the country. 32 states have already implemented similar laws to protect the people trying to save our own lives. And basically,
You've got to remain vigilant for those who respond negatively to their presence, trying to interfere with the care that they provide to victims and patients. Emergency responders and healthcare providers are charged with do no harm. When others interfere with their care, harm can occur. So, ladies and gentlemen, the first personnel, fire personnel, EMS, paramedics, rescue squad members, and emergency physicians and nurses, folks, they need our help so that they can do their specialized work and keep citizens of Maryland as safe as possible. This used to be known as the nurses' bill, as I said earlier, but has morphed into this. So for that, I would urge the passage of House Bill 978. Thank you. Threats against state or local officials, first responders. That's it. Thank you.
All right, thank you. That was straightforward enough. See no questions. That's going to conclude the hearing on House Bill 978.
Thank you, Mr. Chairman.
Thank you.
Ladies and gentlemen of the committee, I appreciated all your,
Favorite bill of the day.
all your questions.
We're going to move on to House Bill 877, Delegate Feldmark. We have, let's see, Rich Gibson, Natasha Kalfani, Kimberly Haven, Christopher Dews, Lasha Jordan, Akita Jones, Delia Trickett. All right, well, whoever's there from, whoever's
I'm
left.
not sure how many
Whenever you're ready.
folks are still around, but thank you very much. Good evening, Mr. Chair, committee members. For the record, I'm Delegate Jessica Feldmark, here to present House Bill 877, the Reentry Success Act. The goal of this bill is simple: to support the stability and success of our returning citizens, both to improve their quality of life on the outside and also to reduce recidivism. This bill aims to achieve that goal through two main components. One is ensuring that every individual leaving incarceration does so with fundamental supports in place to help them transition back into life in the community. Basics such as identification, assistance for food and health care, transportation, and a transitional supply of prescription medication. The other main component of the bill is offering incarcerated individuals who are approaching their release date the opportunity to participate in reentry mediation. Reentry mediation is a powerful tool which helps an incarcerated individual rebuild and strengthen a key relationship that will be critical to supporting their successful reentry transition, and it has been shown to decrease recidivism. You'll hear more, hopefully, if our virtual witnesses are still with us, yes, about reentry mediation shortly. But as you listen to this, I want you to remember and think about this. There is not one of us in this room who could be here today without the support of someone. If we're so lucky, several someones, right? The people in our lives who give us the emotional support to believe in ourselves and the practical support to manage the challenges and logistics of daily life, right? So people returning from incarceration are no different. They rely on key relationships to support their success. And reentry mediation gives them a chance to repair and rebuild or strengthen a key relationship to help prepare them for a positive reentry transition. I do want to briefly highlight one more point for those of you who have heard previous iterations of this bill. You'll recall that previously there were concerns from victim advocates about contacting someone as a potential mediation partner being a potential re-traumatizing event. So in response to those concerns, we have codified in this year's bill screening procedures which actually are already in place but were not specifically articulated in the previous version of the bill. So it now clearly specifies that an individual identified as a potential mediation partner cannot be a victim
or anyone with a stay-away protective or no contact order, or anyone who has requested victim notification. So I ask for your favorable report, and I'm happy to answer any questions.
Good evening. My name is Natasha Calfany from the Office of the Public Defender, and we are asking for a favorable report for HB 877. Family and community connections and stability are key components to an incarcerated person successfully re-entering the community. The mediations provided under this bill could address issues that would impact housing with family upon release, child visitation and co-parenting issues, as well as overall family dynamics, expectations, etc. upon release. This is important because even when there is no resolve, the opportunity for the parties to be heard in mediation strengthen the foundation and create a path for the families to move forward, thereby increasing an incarcerated person's chances of success. When families are strong, incarcerated persons are more available to engage in services and opportunities of employment and mental health and substance abuse treatment, which ultimately reduces recidivism. Equally important, this bill would allow for DOC to work with incarcerated persons to obtain their ID, be connected to food supplement benefits, medical benefits, and medication, as well as transportation, all things that are necessary for survival and successful reentry. The services provided in this bill give incarcerated people the support they need and deserve after successfully finishing their sentence. Finally, in supporting this bill, it is imperative to support HB 64, the Correctional Ombudsman bill that would provide the necessary oversight to ensure that these services are successful. Thank you.
Okay, we're good? All three of you testified?
No, I have not.
Oh, I'm sorry. Go ahead. Sorry.
Thank you for cutting me off, Chair. Appreciate
I'm
that.
very sorry. Please don't start his clock right now. I'm sorry. We'll start him again at 2 minutes. Sorry.
No.
Sorry. State's Attorney Gibson.
Thank you. Rich Gibson, State's Attorney for Howard County, President of the Maryland State's Attorney Association, prosecutor for 19 years in various jurisdictions across the state. No prosecutor wants to prosecute an individual more than once. We don't want to prosecute someone once. But it's a tragedy when we do it multiple times. And I think it's essential, and all the prosecutors of the state support giving the individuals that are returning to society every asset at our disposal as a society to help them be successful. It's a fact that the overwhelming majority of the defendants that are incarcerated will rejoin us at some point in time. And HB 877 goes a long way towards the goal of giving them what they need to be successful so we don't have to prosecute them again. It facilitates reconciliation with friends or family that may provide structural support upon release without jeopardizing individuals or re-traumatizing individuals that don't want to be contacted because the protections are baked into the new bill. It provides a means for getting identification to support employment and benefits. It provides a means of getting food supplements, medical assistance, public transportation passes, and essential medicine if necessary. This bill goes a long way to giving individuals returning to society an actual shot at being successful. I support it wholeheartedly. The attorneys across the state support it wholeheartedly, and we urge a favorable report. I welcome any questions. Thank you.
Now, are there questions? Delegate Young and then Delegate Kaufman. Oh, I'm sorry. We have Ms. Jones who's here as well. I beg your pardon. We have you here to speak virtually, so we'll take you for 2 minutes, okay? Akita Jones?
Thank you.
Thank you.
My name is Akita Jones-Vincent. I'm the Director of Reentry Mediation for Community Mediation Maryland. Community mediation is a voluntary, non-judgmental, and confidential process that provides participants support in having what is often difficult conversations, both pre and post-release, that include talking about things that happened in the past and also making plans for the future. And making those plans is a necessary step in the journey that is re-entering into the community. In addition to the concrete support that this bill provides, such as transportation, medical, social services, We know based on both experience and research that the relationships with the people in your life are crucial to a successful reentry. Conversations that happen in mediation include a wide spectrum of topics. Some of them are living arrangements, employment and education, substance abuse support, communication, just to name a few. And in mediation, participants are able to hash out the details around a topic or a plan, including what their feelings and values are, in a way that doesn't happen during a phone call or even a visit. For example, in a visit or a phone call, it can be decided, sure, you can come live with me as long as you stay out of trouble. In mediation, you get to decide what that actually looks like, what each other's expectations are, like no company after 10 o'clock because I work at 4 in the morning. Or we're going to provide transportation to this neighborhood where the library is so that you don't run into certain people. And I've mediated cases where expectations around childcare and custody are discussed, and cases where children are able to tell their parents how their life changed when they were kicked out at 18. And finally, I just want to share that a mother has told us that she thought she was planning for her son's release, and after mediation realized she hadn't been planning at all. So because of the support that this offers people re-entering into society, we do strongly support House Bill 877.
Now, Delegate Young, then Delegate Kaufman.
Thank you, Mr. Chair. And once again, thank you, Delegate, for bringing the bill into the panel. My question has to do with home plans. I know usually people are sent home, not all the time, with a home plan. How does this correlate with that? Does it add to it? That's my question.
I mean, you can add to it, but I think that the basic answer is it strengthens it, right? It takes it to a deeper level of making sure that folks are actually connecting and communicating and understanding the issues that they're going to have to, deal with that new changed relationship. So I think it's an enhancement to that level of planning.
I would agree. It augments what currently exists.
Thank you so much. Thank you, Mr. Chair.
Yeah, yes, great to see you, my friend Delegate Feldmark. I was just wondering if you received an email this morning with from Jen Beskin with the Department of Public Safety and Correctional Services. Did you receive it?
I must apologize that I am not familiar with the email you are referring to.
I don't think she sent it to you. I'll forward it to your office
Okay,
afterwards.
thank you.
But in the bill, she says, with the HB 877 poses operational and fiscal challenges for the department as currently drafted. And then later on, she goes on to say that certain provisions in your bill could put inmates and others in the jail at risk. So I was just wondering, if you have any comment on their letter of concern. It seems like I can just forward it to you and you can get back to me.
A clarification? Delegate, can you repeat or clarify what the claim was?
Yes, they said this is 877, that's what we're on, right?
Yes, yes, sir.
It says, from the department has, while robust reentry programs and services are critical to the success of returning citizens, HB 877 poses operational and fiscal challenges as currently drafted. Then let me find the part where they talk about harm. So when you have a chance to read it, Delegate,
Sure.
I just wanted to know what your response was to the concerns.
Well, I mean, without having had a chance to read through it, I will say, yes, there are some fiscal impacts. I think that goes with most quality programming. But in terms of risk to safety, I'm not sure what that refers to. I think it is important to note that reentry mediation is already happening, right? We want to make it more widely available. We want to make it accessible to everyone. But the service is already happening, so it certainly can be done without posing a risk to safety.
How about this, Delegate?
Sure.
You're a thoughtful person, and I want to give you the time to be thoughtful. So why don't you take it home with you tonight and maybe get back to the committee with your thoughts later?
Thank you. Thank you, Delegate. And thank you for sharing it with me.
So very kind, really. I mean, I'm not really used to that here. I don't know what to do. All right. Are there further questions? All right. Seeing none. Thank you very much. There are other people signed up to testify, though. But I don't think that the people listed virtually, they're not there. Christopher Dews, is he here? I didn't see him.
Chair Clippinger. Chair Clippinger, I think Delegate Fulmark wanted to say something.
Well, I just, reading through this, I do want to respond to two things I'm seeing.
That's fine.
If you're okay with that, Mr. Chair, thank you. They seem to be expressing concern about the fact that the mediation would take place between the individual who is incarcerated and someone that they have identified. And I think that is actually pretty essential to the benefits of mediation in recognizing that that individual is the one who understands their life and relationships and can best identify who's going to be a critical support to them on the outside. Also, they seem to be raising concern about the fact that mediation can be visually observed, but that DOC staff cannot be in the room. And that is a fundamental piece of making reentry mediation meaningful and successful, is that it has to be confidential. So yes, for safety reasons, it can be observed visually, but it cannot be listened to or have DOC staff in the room. I think that's pretty important and fundamental to the mediation.
Just to add to that, if the mediation was occurring on DOC space, physical space, they have the ability to properly screen those individuals that were going to be taking part in the mediation beforehand to ensure that no contraband or any improper items were brought into the facility. And so there are safety procedures that could be implemented that don't really change the cost in terms of functionality that would allow this to occur.
Any questions after they have completed their homework assignment so quickly? Seeing none. That's satisfactory, Doug. All right, there you are.
Thank you. All right.
He's a soft touch, that Kaufman. All right, soft touch. Thank you both very much.
Have a
I
good
don't
evening.
believe Kim Haven or there's anyone else virtually. Kim Haven, Basha Jordan, Delia Trickett were signed up but are not here. Christopher Dews not here either, so that's fine. And that concludes the testimony on House Bill 877. We're going to go now to House Bill 855 from the Vice Chair, who is going to head up there and make me talk for a while so that he can get there and settle in for a second so that I can start his time. Wow. It's tough but fair. Tough but fair. I see Mr. Kakanis, I think. Michelle Hall. Daryl Carrington?
He's not here.
Not here, okay. I see Mr. Carr in the back, but you're favorable with amendments and you'll go next. Is that all right? Great. That's fine. So we'll have Delegate Moon now for 3 minutes and everybody else for 2. We'll go from there. Go ahead.
Thank you, colleagues, for hanging in here tonight. House Bill 855. It's a very, very simple bill. I don't think it's going to take 3 minutes for me to explain. It was brought by the advocates who were taking a look at what we did with the marijuana legalization bill that the chair shepherded through last year. And here's the problem. As we get into the post-legalization world, we wrote a law that says, here are the amounts you're allowed to have. If you exceed these amounts, it's 6 months jail. So that's still on the books. Now, we said you could have 1.5 ounces of flour or up to 20 grams of concentrate or products not exceeding 1,250 milligrams. That sounds straightforward enough, except if law enforcement encounters someone with both flour and concentrate. And so unless you're really good at doing ounce to gram to milligram conversions of liquid to solid things, it's not an easy law for people to comply with in order to avoid the 6 months jail time. And what this bill would propose is just a lot easier if you just say and instead of or, that someone can possess up to 1.5 ounces and up to 20 grams of concentrate and up to 1,250 milligrams of product. And that way, the law is perfectly clear. If you exceed these 3 categories independently, it's the possibility of jail. Otherwise, you're good to go. We don't want to be in a situation where someone's got 1 ounce of flour and 10 grams of concentrate. Well, you tell me, have they violated the law or not? That's too confusing. I think an and is simpler. That's the bill.
Okay. Sure. Good evening, Mr. Chairman, members of the committee. My name is Neil Karkanis, here this evening on behalf of the Marijuana Policy Project. And I'm sitting in place of Olivia Noggle, who's out sick today. But first of all, thank you to the Vice Chair for bringing this bill. The language is actually one or more of the following, and then it lists those items. Effectively, this bill is just here to clarify the law and avoid any confusion. So with that, it's a simple bill. We appreciate you supporting it, and for those reasons, we urge a favorable report.
Good evening, Michelle Hall from the Office of the Public Defender, and we would also request that this committee issue a favorable report for all of the reasons that were just stated. I also would add in a hypothetical that Delegate Conway posed a few weeks ago, if an individual is possessing 2 or fewer cannabis plants and that is yielding a certain amount of product, then under the current drafting of this bill, they could all of a sudden be in violation of the law. I think that really undermines the personal use scheme, the reason individuals may want cannabis plants in the first place. And so again, this is a simple common sense fix, and we would urge a favorable report. Thank you.
Questions for the panel? Delegate Simpson.
I guess this is the first time it's really made me start thinking in this terms, because I'm starting to think of my own pantry. I don't see myself as like accumulating a bunch, but I can imagine that if somebody is buying cannabis, you know, that I just think of like almost everything. That I think, you know, just even chili powder, like, what I'm going to make, and I already have 10 of them at home. So are people really, and we don't do this with alcohol. Have we thought that, are we still being too restrictive? Because nobody's coming and checking to see how many bottles of vodka I have.
We do cap how much alcohol can be produced by people who we have licensed to produce and sell alcohol in this state. That's been a feisty topic in past legislative sessions. But that's all to say, we had to draw a line somewhere at this onset, so I'm not questioning where those lines were drawn. Are we going to have to revisit these numbers in the future? Probably, but I think we're quite a ways from that scenario.
Okay, thank you.
Further questions for the panel? Seeing none, thank you all very much. We'll hear now from Rusty Carr, please, for 2 minutes.
Thank you, Chair Cleppinger, members of the committee, and thank you, Delegate Moon, for this bill. To your point, the limits for not flour, for concentrate and for edibles, doesn't match up to the way we do the allotment system for medical, where we have an equivalence between concentrates and flour, and there's a formula that does that equivalence, and that handles the handling one or the other. The current law on limits has a limit for concentrates and a limit for edibles that is not equivalent to the way we do the limits in the medical system, and it's much stricter on the edible side than it is for flower in terms of the equivalent. If you take the medical system and compare it to the recreational limits, there's a discrepancy there in terms of fairness, in terms of what people are allowed to purchase. And to your point that we're going to get to fixing that years down the road, my request is to go ahead and fix it now. Thank you very much. Thank you.
Seeing none, thank you all very much. Thank you very much. That concludes the testimony on House Bill 855. Now we're going to the last bill of the evening, in House Bill 980. Delegate Young. Delegate Young, Michelle Hall, Matthew Meadows, Christopher Dews. I'm just going to keep going. David Carter, Neil Karkanis. Yeah.
I think it'll be the three of us.
I think it's the three of you, and that'll be everybody. So, Delegate, go ahead for 3 minutes.
Won't be before you all long. The end draws near, my friend. This bill is simple. It merely says that the use of cannabis cannot be the sole reason that you violate your parole or probation or that you are held pretrial. Thank you, Mr. Chair.
Okay. Good evening again, Mr. Chairman, members of the committee. My name is Neil Karkanis here on behalf of the Marijuana Policy Project, sitting in place of Olivia Noggle, who's out sick today. MPP is a nonprofit. They've been working to improve cannabis policies across the country for the last 3 decades. As you know, in November 2022, the citizens of Maryland overwhelmingly voted in favor of question 4. 67% of Marylanders voted in favor of question 4. It's actually the largest margin of any state ballot measure to legalize cannabis. You all have done great work on this issue. House Bill 980 just ensures that folks that are on probation, parole, or pretrial release are protected by, cannabis, which is effectively legal July 1st. So for those reasons, we encourage a favorable report. Thank you.
Thank you, Michelle Hall, again from the Office of the Public Defender. The only thing that I would add is, I think importantly, this bill still makes clear that courts, parole commissioners can establish as a condition of pretrial release, probation, or parole, limiting the use of cannabis for an individual. And sometimes that makes sense, right? Sometimes there's a nexus between the crime and cannabis use. Sometimes substance use issues are a concern for that particular individual, and so it makes sense for the safety of that individual and others for there to be some type of restriction on cannabis use. But for many other individuals, cannabis will be legal on July 1st, and their involvement in the criminal legal system alone shouldn't restrict their ability to use cannabis or be a reason that they lose their liberty when they're on some type of pretrial release, probation, and parole. So we especially think that the stop or a safe gap that makes clear that courts and parole commissioners can still establish this as a condition when it's appropriate is the really critical piece of this bill, and we would urge a favorable report.
Okay, questions? So I've got a few. So I guess my question, there's an amendment that is here.
Yes, sir.
And it would require that it appears to make a judge have to have some kind of hearing, because it says that they have to find by clear and convincing evidence that someone shouldn't be smoking marijuana while they're on pretrial or afterwards. Is that what you're envisioning here?
To clarify, it wouldn't be that they would find by clear and convincing evidence that they shouldn't be smoking. It would be more so that they would need to find by clear and convincing evidence that the individual or that the use of cannabis poses a danger to the person or another person.
So would the state and the defense have to make arguments as to whether or not cannabis? So my understanding of what you want to do in the bill is that if a judge wanted to say, during the time that you're on pretrial, you're just as if we're going to abstain from alcohol, you're going to abstain from marijuana. You're going to abstain from cannabis as well. So we're going to have you abstain from these things. And as I read the bill as originally introduced, if they make that specific finding that says that the defendant's use of cannabis would create a danger to the defendant or other people, they could make that ruling and then say, okay, you can't smoke marijuana while you're on pretrial. You couldn't drink alcohol, I guess, in a different context.
Sure.
If you're on pretrial. Am I right in how I'm reading that, at least as the bill is currently introduced?
The initial drafts merely stated a specific finding. Office of the Public Defender, and I'll turn it over to Ms. Hall to follow up, asked for a little bit more clarity on that. I believe they thought there was some constitutional amendments, but I want to speak, please.
Go ahead.
Sure. So our concern with the bill as initially drafted was that the language didn't make clear that this had to be something that was found at the outset. I think the language could be read in a way that later someone could find that that there was a danger from cannabis use or something like that. So that was the first piece of the proposed amendment, but also that there needs to be some type of evidence, some type of rationale as to why there needs to be a limitation on cannabis use if we're going to be restricting an individual being able to use a legal substance. And so, that was the basis for where that language came from.
But as the bill's initially drafted, they would have to make that affirmative step at the beginning. So they'd have to say, as part of the pretrial conditions, you are not allowed to smoke cannabis, drink alcohol, do any. I mean, that's kind of part of the existing litany that's there. The way I read it I think that would be part of the existing litany at the very beginning. It would just change the way the judge would have to say it and say, okay, I find that there is a compelling reason here to say to you that I don't want you to smoke cannabis, just in the same way that if there was somebody who had too much to drink, got into a fight, they would say, okay, I want you to abstain from alcohol during that. If, like, for example, if it's somebody who was under the influence of cannabis and they were driving, the judge could very easily say, I don't want you to smoke cannabis while you're on pretrial. That appears to be, that I believe would be okay, at least under the original draft of the bill. Where I kind of wonder where we're going here is, with a clear and convincing standard, is there going to have to be some kind of mini trial where we're going to have to prove that by clear and
Mr.
convincing
Chair,
evidence?
I think we would probably, I would be in alignment with aligning it how we do alcohol.
Okay.
I think
we're going to talk about it some more, but
Sure.
I just trying to get clarity, and I know the vice chair has a question, so.
Sure, and I think I think the concern is we don't want, we do want there to be some type of rationale and not just a list of these are the things that you can't do without any type of connection to any concerns for this individual defendant, which is why that is the proposed language. So that's what the goal. I know that I am anticipating your confusion is that isn't that what we're always doing, but I do think that we want the language to be clear.
Mr. I'll come back.
Thank you, Mr. Chair. So I guess I'm curious to see what your actual policy goal is with this bill. And I say this from a friendly place because in 2015, I tried something very, very similar. This was obviously before legalization, and the thing got totally changed, not by me, through its course, and it didn't end up passing. But maybe what they did to it will help inform this question. They said, no, we're not going to let you take this away as a parole, marijuana restrictions as a parole or probation condition. We're just going to say you can't be sent back to jail, or you can't be retaken or incarcerated on the basis of a marijuana parole violation. But they wouldn't let us say it's not a parole violation on the basis of what we were doing with alcohol. So I guess that's my question. Are you trying to stop it from being a condition whatsoever, or is what you're trying to stop is the incarceration or reincarceration on the basis of that marijuana being a parole violation?
I think the language of the bill speaks to solely. Oh, let me take a step back. This is one of your old bills, Mr. Vice Chair, and so, but the language speaks to solely, well, it being the sole basis, and so the goal is, I think, to ensure that it's not the old regime. It's a new regime of legalization. And under that new regime of legalization, we will treat it as such, as a legal substance. That legal substance is regulated, and we may move with it under that paradigm. But we don't want folks to just be treated as if it's still illegal.
So, sorry, just to be very clear about this. So you would not favor a bill that stopped someone from being reincarcerated for a parole violation of marijuana, but nevertheless still made someone piss in a cup, check in with a supervisor and check on their marijuana use? That you would be opposed to that, just that part, if it didn't lead to incarceration, even if it couldn't lead to incarceration?
I don't think I got it. I would not be. There's a double negative that messed me up.
Yeah, sorry.
Can you say it again?
Yeah.
Triple negative, you said?
I think you get the idea. Yeah. So anyway, just something to think about. And then the last thing I'd say is, I think Valerio, before this thing hit the floor, also changed it to not just marijuana, but anything that we made no longer a crime wouldn't be a reincarcerable parole violation. So I throw that out to you just to spitball on that.
Yes, sir. Thank you, Mr. Vice Chair.
This question really might be, if anybody can answer, I'd appreciate it. But Chairman, you mentioned you were talking about assault and if somebody was on probation. But so currently, I mean, obviously, if you get a DUI, usually you're not able to drink while you're on probation. But something like assault or something like that, I mean, are you necessarily not able to drink when you get out?
I am not on the delegates panel.
It seemed like you knew. It seemed like you knew about the subject.
No, a little. It depends on who you talk to. Talk to some of them. I mean, it's fine. Well, okay. This isn't my bill, but just for the purposes, I mean, the reference that I made to an assault is that there are sometimes that assaults happen, and there's alcohol involved with the conflict, a barroom brawl. And so everybody was drinking too much, and the judge gets them the next day or the day after next, and sets pretrial conditions and says, okay, I'm going to release you on pretrial with the understanding that you are not going to drink alcohol during the time between now and when your case is heard. So, but the judge can read what's in the four corners of the charge and say, okay, there was a barroom brawl and they were drinking alcohol, and so thus I'm going to say that they can't do that here. I guess that if there was somebody who was shoplifting, unless they were shoplifting while they were drunk, which I guess is possible, but actually has happened now that I think about it. I've had that a couple times in district court. I'm just saying there is usually something that's happening pretrial, at least, that's very clear, that says, okay, there's something happening that would say to the court, hey, we need to make sure that they're not drinking at least in advance of trial, because that seems to be leading to some of these other problems. I guess the question is if that is analogous in some ways between, not that alcohol is a perfect analogy to cannabis, but at the same time, if you're moving in the same way, there may be times when a judge wants to say that because of a specific thing. And I guess the question that the delegate's asking is, when can they do that and when can't they do that?
But as far as probation and parole,
talk to them.
As far as parole and probation goes, currently, I mean, are those just general in the state of Maryland? Are those just general terms for probation and parole right now that you can't have alcohol?
I mean, I think generally it depends on, as many things in here do, depends on like the judge and what they're asking for. It depends on the states, and by states I mean the prosecutors. So I think that it depends, and that can be added on, or not even. I mean, big picture, there can be conditions of probation that sometimes, to me, don't necessarily align with why we're there and what that individual needs. And so the real goal of this bill is to say that we're limiting, if you're going to be precluding someone from using cannabis, that we're really tying that to what this person needs or what happened in this particular crime. So that's the concern that we're trying to push back against.
Okay.
I apologize for my extreme ignorance on behalf of cannabis. I will put that out there. Right.
Mama.
So like I understand where you're coming from as far as like in child protection. If you had somebody who, of course, there was alcohol or drug use and it contributed to the neglect or abuse of the children or domestic violence or whatever. And I know cannabis has its challenges because it's not like alcohol where you can test them, or drugs, certain drugs that you can test and there's, or I don't know. My understanding is that it's challenged because you can't really test the levels to know that somebody is like currently under the influence, or was this a week ago or 5 weeks ago. And so I guess that makes it a little difficult, other than I know that there are times, particularly with how strong the cannabis is, that there have been kind of personality changes or things that you can have some mental health issues that are cannabis related, but that would that would, I guess, be the only indication that it was like active. And like, how would we incorporate? I mean, am I correct that it's just a hard drug to be able to say you're using?
I would argue that state's attorneys and police alike already, in instances where there's cannabis use that in violation of the law, have their means and their training to be able to understand and know, or at least deduce, that an individual may be under the influence of cannabis. We also know that, you can test positive for cannabis for up to a month after usage, so that's part of the concern here. But ultimately, again, I would want the evidence of whatever the circumstances. We have another bill before us having to do with child neglect, as you just brought up. That bill says that the use of cannabis alone does not equate to a neglect of child in those circumstances or in those cases. This is a similar posture where there has to be some sort of additional evidence or some sort of a rationale to align with the determination. Now, whatever the language that is appropriate and the wisdom of the chair and this committee to get us to that intent, I think we'd be open to that. But again, it's merely about making sure that, I think Neil could say it a little bit better, the discriminatory intent or impact rather does not continue with this legal substance.
I wonder if to some extent do we need a bit of a sunset on all of our cannabis till we get to the point where we're of the same mindset of drugs, of alcohol or other types of things. Because like I said, 20 some years ago, we even, said, hey, this is legal. You can legally use this. It's only if it then impacts. And I do think, yes, I guess there's somewhat of a bias. So sometimes I wonder with some of all these bills that were like, well, child abuse or domestic violence in 3 years, 5 years, will we no longer need that specification because we'll have a better understanding of how it's in regular practice.
So Delegate Simpson, perhaps in 5 years we'll be there, but obviously July 1.
No, I know.
July 1 is when cannabis is legalized. And so the intent of this bill is to ensure that people that are using it legally aren't in violation of pretrial release, probation, or anything like that for using a substance that is legal. That's simply what we're trying to do. And if we can get the language tailored to do that effectively, then we're open to that. But that's simply all we're trying to do.
All right, I'm not going to keep people too much longer. We have people in opposition, I think, to the bill as well. But very quickly, I mean, the standard conditions, 10 standard conditions for probation. So now moving from pretrial to probation. They've been convicted of something, and they have to, the standard first 10 are report as directed, follow the agent's instructions, work or attend school, get permission before changing your address or leaving the state of Maryland, obey all laws, notify a supervising agent at once if charged with a criminal offense, including jailable traffic, get permission from the court before owning, possessing, using, or having under your control any dangerous weapon or firearm of any description, permit your supervising agent to visit your home, don't illegally possess, use, or sell any narcotic drug, controlled substance, counterfeit substance, or related paraphernalia, appear in court when notified to do so, pay all fines and costs and fees. The alcohol is in one of the special conditions, and I believe it's safe to say that the possession of cannabis or something else would probably be under the special conditions as opposed to the general conditions that everybody gets when they go through probation. But in any case, I've wonked out enough now, and I'll stop.
We appreciate it, Mr.
All
Chair.
right. Are there any further questions?
Thank you, committee.
Thank you very much. We'll now hear from I think it's just making sure. Matthew Meadows? No. Christopher Dews? No. David Carter? You're here? Okay.
Thank you so much. I just want to point out first, thank you for having me. This is my first time actually coming up here and speaking before the committee. So it's giving first date kind of nervous vibes. So really thank you for your consideration time. But for the record, my name is David Carter. I am here on behalf of the ACLU Maryland, which urges a favorable report for HB 980, which would prevent a court from denying pretrial release and probation, as well as the Maryland Parole Commission from reincarcerating individuals who have violated parole solely on the basis of marijuana possession or a urinary analysis indicating marijuana use. In 2022, the General Assembly moved to legalize the recreational use of marijuana, which Marylanders affirmed that same year. In doing so, the state made clear that the arrest and incarceration for the possession or use of marijuana is a failed policy that ruins lives, primarily lives of people of color. Technical probationary violations are a frequent cause of recidivism. Technical violations such as failing a drug test or missing a meeting accounted for almost 70% of the parole and mandatory supervision returns to prison, and over 40% of probation revocations. With decriminalization of legal marijuana, its use should not be the grounds for reincarcerating individuals. Reincarceration also reinforces the cycle of poverty and impacts communities. Children with parents who return to jail bear the burden as well. Moreover, disrupting lives and families to address substance use disorder is simply unethical. Reducing incarceration rates and the rates of recidivism among parolees continues to be a cost benefit for the state. HB 980 is a logical next step in disentangling individuals from the criminal justice system for using marijuana. HB 980 would allow Maryland to cut incarceration costs, maintain public safety, allow the Parole Commission to focus on resources on high-risk offenders, and enable returning citizens to continue their reentry into society. So for the foregoing reasons, the ACLU Maryland urges a favorable report on HB 980. Thank you.
Harsh and abusive questions for his first time before the committee? None? No, we would never do that. All right. Seeing no questions, thank you. Congratulations for your very first time in front of the committee.
Thank you.
And that concludes a polite golf clap from the committee now. And now we'll go to those people in opposition, and it appears to be we don't have Vince McAvoy. Oh. Stop. Kevin McCarthy is here. Or not Kevin McCarthy, John McCarthy. You're signed up as Kevin.
My name has always been John.
Yeah, somewhat. I don't think you're Kevin McCarthy. I think that's someone very different. But in any case, John McCarthy, now in opposition for 2 minutes.
On behalf of the Maryland States Attorneys Association,
Your sound went away. Your sound went away. Let's see if you can. We can just. Wait, that's better. Try again. No. We can't hear you. We could hear you, and then we couldn't. Yeah. No. Yeah, hold on 1 second, Mr. McCarthy, State's Attorney. Hold on. We're gonna bring him back. It just has to be the last witness for the day, because of course it does. Let's try again.
Can you hear me now?
There we go. Now let's try again.
I'm sorry. It must have been that Kevin guy causing a problem. In any instance, on behalf of the Maryland States Attorneys Association, I am here.
Okay, I'm sorry. You cut out again after 15 seconds and we can't figure out why. No. I could read your lips, but I can't. He's getting help. Help is on the way.
After 15 seconds, they cut you off.
Yeah, they're hard up in Montgomery County, apparently. It's, no, we're going to try this. Oh, God, now it's all broken. He's coming back. Ready? Can you hear me? Try. We can't hear you. We can see you, we can't hear you. And now I don't think you can see us because this has to be perfect this way. Are you there? Can you try and talk again? He can't hear us. We're getting something. Everyone at home must find this entertaining. Or not. Is there a reason that our signal is down? No, I don't think we are. Okay. All right, this is what we're going to do. This is the first time for everything. We're going to give him a chance at a time over the next couple days to enter his testimony in opposition to the bill. But we obviously are we still live? We're still, this image is online. Okay. Look, so we're not available to the public, so we're going to stop right now. We're going to give him the opportunity to provide his testimony in opposition. We'll see if we can get him available the first thing tomorrow and knock it out, or we'll work with the state's attorney's schedule to figure this out in what is pretty unusual. But for now, we're going to just suspend the bill hearing. What's the bill number again? The bill hearing on House Bill 980, and we will come back to it when we can figure out the technical issues on another day, either tomorrow or Thursday. With that, that concludes the testimony of the House Judiciary Committee. Thank you all very much. Have a good evening.